Public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Criminal Code Amendment Hate Crimes Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I would also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For the benefits of those participating remotely, I'm the Chair, Senator Nita Green. I'm joined today we'll be joined by Deputy Chair Senator Paul Scar, Senator Alex Antic, who's on the teleconference, and later we'll be joined by Senator Maureen Faruqi. I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to the committee, and such action may be treated by the Senate as contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether to insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera, and such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name, the capacity in which they appear, and witnesses should speak clearly into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off and turned to silent mode. I now welcome representatives from the Australian Human Rights Commission. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy and shall be given a reasonable opportunity to refer questions asked of the officers to a superior officer or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you to please state your full names and the capacity in which you appear today? We'll start with you, Ms Finlay. Welcome.
Thank you, Chair. My name's Lorraine Finlay. I'm the Australian Human Rights Commissioner, appearing on behalf of the Australian Human Rights Commission.
Welcome.
And I'm Melissa Diabru. I'm a senior lawyer with the Australian Human Rights Commission.
Thank you both for joining us today. Do you have an opening statement before we go to questions, Ms Finlay?
Yes, Chair, we do have a brief opening statement. Thank you.
Thank you very much.
Thank you. Well, we would like to begin by thanking the committee for the opportunity to provide evidence in relation to this inquiry into the Criminal Code Amendment Hate Crimes Bill 2024. Whenever introducing legislative amendments of this nature, the critical issue is striking the right balance between different human rights considerations. In this case, the Commission welcomes the amendments to expand the targeted groups protected under certain offences under Division 80 of the Criminal Code Act 1995 Commonwealth, and the introduction of a new offence of threatening force or violence against those broader protected groups. While we have made recommendations that seek to further improve the legislation, we recognise the need to strengthen existing laws and, on balance, are supportive of the bill. The changes proposed to sections 80.2A and 80.2B of the Criminal Code Act and the proposed new sections 80.2BA and 80.2BB are significant changes in recognising the profound harm that hateful conduct and vilification inflict on the physical and psychological well-being of individuals and groups in our community. They send a strong message that this conduct is not accepted in Australian society and that everyone has the right to safety and physical security. The amendments also recognise the intersectionality of the listed protected attributes and that individuals may identify with a combination of the attributes protected under these provisions. Our first recommendation is that the amendments proposed to sections 80.2H, 80.2HA and 80.2K of the Criminal Code Act should include disability as a protected targeted group. These provisions criminalise the public display of prohibited Nazi symbols, including giving the Nazi salute, and terrorist organisation symbols that are likely to offend, insult, humiliate or intimidate particular targeted groups and their members. The amendments already proposed would expand the targeted groups protected, but they do not currently extend to include people with disability. People with disability are a group that have been specifically targeted in conflict. For example, the Nazi T4 program involved experimentation on and the execution of persons with disability. The public display of prohibited Nazi symbols, the Nazi salute, and the symbols of terrorist organisations are likely to offend, insult, humiliate or intimidate persons with disability. This group is equally entitled to protections under these provisions. Including persons with disability in the proposed expanded targeted groups would support and promote equality, inclusion and respect, and would align these provisions more closely with Australia's existing anti-discrimination laws. Our second recommendation relates to two other proposed amendments in the bill that would remove some safeguards in the application of certain provisions in Division 80 of the Act. The bill proposes to change the fault elements from intention to recklessness for one of the elements of the offences in sections 80.2A and 80.2B of the Act, which is the urging of force or violence against particular groups and their members. Currently, the fault element of intention requires that the person intended that the force or violence would occur. This amendment means that the offence would instead apply where a person is aware of a substantial risk that the force or violence will occur, and having regard to the circumstances known to him or her, it is unjustifiable to take that risk. In addition, the bill proposes to exclude the operation of the defence for acts done in good faith in section 80.3 of the Criminal Code Act for the existing offences in sections 80.2A and 80.2B, and the proposed new offences in sections 80.2BA and 80.2BB. As noted by the Scrutiny of Bills Committee in its review of this bill, and the Australian Law Reform Commission in a 2006 report, the defence of good faith was taken from historical sedition laws and was introduced at a time where proof of intention was not required. While these changes would make prosecutions under these sections easier, there would be no requirement to establish that the person intended that the force or violence would occur, and insufficient ability for context and circumstances to be considered as part of the establishment of these offences. For example, the Criminal Code Act applies to children as young as 10 years old. A child making a post on social media that could be interpreted as urging or threatening force or violence against a targeted group could unwittingly fall foul of these provisions without any intention that force or violence actually occur and without allowing for sufficient consideration of their particular circumstances. While, on balance, we support the proposal to lower the threshold from intention to recklessness, given the seriousness of the overarching offence in terms of urging or threatening force or violence, the Commission recommends that the offence provisions be amended to incorporate considerations of the context and circumstances of the conduct in a way that is consistent with that proposed by the Australian Law Reform Commission in its 2006 report. This would not unduly impact the identified need to reform and strengthen the existing laws to make them more effective in addressing hate crimes, but it would act as an additional safeguard to ensure that other rights, such as freedom of expression and freedom of association, are also protected. Thank you for your time today, Committee, and we're happy to answer any questions you might have.
Great, thank you very much for that. I'll just check. So, do we have Senator Scarr there at the moment?
He's via teleconference, Chair, at the minute.
Great, thank you. Senator Scarr, I was going to hand to you for questions, but I also have questions, so I can go first if that helps, if that assists.
It would assist, Chair. I'm just struggling with my computer at the moment. Thank you.
That's okay. Let me ask my questions first, and that hopefully might we might be doubling up on some of these questions anyway. So thank you very much to the Australian Human Rights Commission for that, for your submission and for the opening statement. I guess this is a really important piece of legislation, and our committee, as you've seen over the past couple of years, is very open to making recommendations to the government about how to improve a bill. And with a bill like this, it is about getting the balance right. And I'm very interested in how we get that balance right, and if there's a way that we can take all of the views from the submitters and the witnesses today and try to strike that right balance. So I'm very open to suggestions, I think is what I'm saying to you. I wanted to ask, though, at a very before we get to how we criminalise this behaviour, we do need to understand a little bit about what the level of racism and other discrimination is in our community, and why these laws might be even necessary in the first place. So I wondered whether that would be something you could speak to, Ms. Finlay, particularly given that the Human Rights Commission released the anti-racism strategy or framework, only a week ago. Are the rates of racism and forms of discrimination increasing?
Thank you, Senator. And my answer was immediately going to refer to the National Anti-Racism Framework that was released only last week, and the comments that the Race Discrimination Commissioner made at that time and has made since around the unfortunate continued presence and indeed escalation of racism in Australia, both at a general level but also given recent events. And I understand it was referred to by the Attorney-General in his introduction of this legislation in the second reading speech, particular forms of racism that this legislation is particularly conscious of around, in particular, both anti-Semitism and Islamophobia and their rise in recent times in Australia. So it certainly is legislation where, at a practical level, the need for the laws to be strengthened in a way that this bill is recommending is something that we certainly appreciate, particularly in light of the National Anti-Racism Framework having been released.
Thank you. And I guess my other, this might not be something you can speak to directly, and possibly law enforcement might have a better idea of this issue, but I think one of the reasons this type of legislation is important is because we often see an escalation from vilification or hate symbols, or the type of language that's being talked about in this legislation, or for example, graffitiing on a particular on a shop front of a particular symbol. The capacity for that type of behaviour to escalate, I think, is something that will come up, I think, a few times today with our submitters. And I was just wondering whether there was any comments from the Commission about that, about the trajectory of this type of behaviour. You've said we're seeing an escalation of the quantity, but I wonder whether we're also seeing an escalation of the, the not just discrimination, but the violence that this behaviour leads to.
I think there are two very important points to make in relation to that, Chair, if I may. The first is that you're absolutely right that calling out behaviour early on is really important in terms of, firstly, preventing that escalation, but secondly, sending a very clear message throughout the community that this type of conduct is unacceptable. So we would say there needs to be a full effort, not just through legislation such as this, but through a whole variety of other mechanisms, as outlined in the National Anti-Racism Framework, to actually address those types of behaviours from a very early point. However, the second point I'd make, which goes to that, is that when you're criminalising this type of behaviour, it's important that that happens, and there's clear guidance under the International Human Rights Framework that that happens at the more extreme end of the spectrum to, again, ensure that you're striking that right balance. Having only that more extreme end of the spectrum, for example, where speech falls into threatening or inciting violence or transfers into conduct, doesn't mean that you're accepting or think it's advisable to have behaviours at a lower end of the spectrum. It's simply a question of when that criminalisation should occur and when the law as a blunt tool should step in. So certainly this legislation, in our view, is important in terms of both sending a clear message about behaviours that are unacceptable, but also in terms of striking that right balance in terms of inserting the criminal law at an appropriate point in the spectrum. And I might just check to see if Ms de Breu has any further comments she'd like to add to that answer.
I don't actually. I think you covered it perfectly. Thanks.
Ms de Breu might be able to contribute to the next answer to the question, because it's probably more of a legal one as well. Ms Finlay, you stepped us through in some detail the Commission's view on the removal of the good faith defence, and I thank you for that. I guess when we're talking about threats of violence, there are some submitters and witnesses who are opposed to the removal of that good faith defence. And as I said, I'm really open to all different views today. But the thing that I can't get past is that I can't see a situation where a threat of violence, which is what we are seeking to criminalise, would ever be done in good faith. And I wondered if you had a view about the necessary, how we were able to criminalise this behaviour if we were to keep the good faith defence there. I just can't see how we would manage to effectively criminalise this type of behaviour.
I could make one brief comment before passing to Ms. Debreu. I think what you're saying is correct in terms of we need to recognise the offence isn't simply the threat of violence in and of itself, it's with the elements of intention and recklessness.
Yeah.
And so when those elements are added in, we find it difficult, as you do, Chair, to see a situation where it could ever be said that a threat of violence could be made in good faith. Sorry, I might pass in case there are any additional observations.
Yes, I absolutely agree. And I think one of the important things to recognise up front as well is that the description of the defence as acts done in good faith isn't necessarily reflective of the purpose of that provision. And I think when you look at it, it obviously includes some carve-outs that you can see are historically related to those sedition offences. And they speak to things like doing acts or conduct in good faith relating to forms of political communication. But there are also some other considerations in there that you'll see are also included in the Australian Law Reform Commission's recommendation that we have drawn on for the purposes of our recommendation. So absolutely agree with your comments about this, particularly threats never being able to be done in good faith. But what we see as being important in those provisions is the ability for the court to have regard to the context and circumstances of the conduct, rather than this being able to say that there is actually a good reason why you've done this. It's more about making sure there's the opportunity for the court to have regard to those matters and make sure that it's applied only in circumstances where it's appropriate given the sanctions and the penalties, and also making sure that it doesn't disproportionately limit other human rights.
Okay, thank you. I've got a question about that as well. I've got two more issues to cover off, and then I'll hand the call over to Senator Scarr. The first one is that, again, Ms. Finlay, you stepped us through this in quite some detail around recommending that the list of protected groups be extended to peoples with a disability as a protected group. And you explained, I guess, the connection between particularly Nazi symbols or anti-Semitic or even far-right language or behaviour or threats of violence, and the way that people with a disability would be affected by that. I guess it's the connection that I can make to that is the way that also people with from the LGBTI community might be impacted as well. Are there any other circumstances where persons with a disability are targeted by right-wing extremist groups, or is it really around this issue of the connection with Nazi symbols?
We certainly use that as one example, Chair,
right.
where for us it was just not clear why they hadn't already been included, given other inclusions were provided to expand out that category of protected characteristics. And I think the other thing that's important here and that the legislation does do is to recognise an intersectionality, that it may not be one characteristic in itself, but the combination. So we would simply say that it really does, adding people with disabilities into that section really does align the protected groups throughout that division of the criminal code, but also aligns more clearly with Australia's existing anti-discrimination laws.
Yeah, okay, understood. And thank you. Thanks for clarifying that for me. And just one more clarification I'm keen to get on the record is going back to Ms. De Bruyere, the issue about the carve-out or the context of this behaviour. Your submission states that there is a risk that individuals engaging in expressive or critical speech and certain public gatherings or protests could be viewed as sources of incitement or threats against protected groups, limiting the rights to freedom of expression and freedom of assembly. Could you just clarify the Commission's view that the incitement of violence in some circumstances should be protected by the right of freedom of expression and freedom of assembly?
I think we're not necessarily saying that those are situations where it's okay to engage in this kind of behaviour. I think that paragraph is really speaking to the idea that there are situations where tensions might be high in very sort of tense circumstances where people might say things that they don't mean. And when you take away that you reduce that fault element from intent to recklessness, you're already capturing a larger group of people, which we don't necessarily agree with. It's just about making sure that you strike that right balance. So again, we're not necessarily saying that it's okay for that behaviour to happen in those sorts of situations. It's probably just calling out the fact that you can have situations where people are engaging in protest to advocate for certain rights, for example, and the interpretation of what might be considered a threat and circumstances where you're not necessarily then requiring intent to be proved. It just means that you're going to be capturing situations where it is important to make sure that there is that ability for the court to have regard to circumstances and context.
Understood. Ms. Finlay?
I just add one comment to that, which is that obviously the Commission does not in any circumstances believe that incitement to violence is something that's acceptable. The challenge here really is sending that clear message about conduct that is objectively not tolerated within Australia, but recognising that that conduct often occurs in grey areas that can be quite subjective in terms of their interpretation. So while we do believe the legislation needs to send that strong message, it does also need safeguards like the provision that we've recommended, simply to ensure that those contexts and circumstances can be taken into account and to reflect the fact that not at the level of clear incitement to violence, but throughout those grey areas, there can be reasonable minds disagreeing in terms of exactly what particular behaviours might mean or how they could be interpreted. So this is an attempt to just really make sure there is that ability for that context to be taken into account where it's appropriate.
Understood. Thank you. That's why I sought the clarification. Senator Scarr, are you ready to ask some questions?
I will ask some questions, Chair, via teleconference. I'm just having issues.
We can hear you really well, so go ahead.
Log in. Okay, that's fine. I want to ask some questions first in relation to this issue in relation to children, and we've had some discussion at this committee in the context of other legislation about the exposure of children to criminal liability. And one of the points that was made by I think it was the Deputy Commissioner of the Australian Federal Police, was you've got the CDPP has a prosecution policy and there are other policies which the AFP has in terms of dealing with children, which from their perspective in the other context we're considering should provide some comfort that there's an awareness within both the police service and also the prosecutorial authority about whether or not it's in the public interest, especially in the first instance, to bring charges against children for these sorts of offences. To what extent do those policies, but even more particularly how those policies have been applied in practice, give comfort or don't give comfort to the Australian Human Rights Commission?
Thank you, Senator. There are a number of points emerging from that question. The first is which we obviously recognise that these specific provisions being considered today don't operate in a vacuum, and they do need to be considered within the broader context of the Commonwealth Criminal Framework, which does include, for example, I believe it's in section 7.1 and 7.2, specific provisions around the age of responsibility for children, and the requirement to prove that a child knows right from wrong before a prosecution can be commenced. And as you referenced, there are also the broader prosecution policies that apply, as well as things like Section 20C of the Crimes Act, which provides that all of the state court processes and sentencing processes relating to children apply in relation to federal offending. So those do give us some comfort in terms of ensuring that the broader circumstances around children and the broader frameworks that apply in relation to juvenile offending also apply in this context. However, we would say that in particular in relation to the prosecutorial policies and the AFP policies, those aren't necessarily reflected expressly in the legal provisions relating specifically to these offences. Therefore, we would say that, again, the provision we've recommended that just provides expressly that those contexts and that circumstance can be taken into account would be an additional safeguard, an additional reminder in law of the importance of striking that right balance and taking all of those things into account. And we would say that is needed in light of a number of practical examples we can give that I know this committee is well aware of, where there have been questions raised about interactions with children at a Commonwealth level, and the way that not necessarily these specific provisions, but other provisions around Commonwealth offending have been applied in practice. And I might just pass to Ms Dearbrew and see if she has anything to add to that.
No, I agree with the things that you've said. I suppose the only other thing I would say is that embedding it into this legislation just allows the court to be able to have regard to it. The prosecution policy really is about whether to bring that prosecution, and then there are sentencing guidelines as well. But I think this just brings it into the ability of the court to have regard to those matters.
Okay, so just with respect to that point, the court is to have regard to it, was how you put it, and paragraph 22 of your submission refers to the courts considering the context and circumstances of the conduct. It's a very general application of that range of matters, considering the context and circumstances of the conduct. Can you give any insight as to how a judge in practice would actually consider each of those matters? So the issue I've got, or I'm grappling with, is, well, how does this work in practice in terms of if some sort of language is used and a particular group is or someone, a member of one of the particular groups, has a particular attribute, fear is instilled in them, they raise it through the legal system, and then the judge has to sit there and look at the context in which the conduct occurred and whether or not the conduct was done as A, B, C, D. It's not a defence. It's presumably, it's not an element of the offence. I'm trying to get my head around legally how a judge would actually apply this.
Thank you, Senator. And it is designed to be considered in order to determine whether the elements of the offence have been made out. So you're right to note it's not intended to operate as a defence in that context. And the recommendation that we've made does align with the recommendations made by the Australian Law Reform Commission in their 2006 report, which did go into further detail in terms of how in practice some of these things may be applied by a court. And indeed, there are parallels that can be found in other pieces of legislation in terms of ensuring that context and circumstances is taken into account whenever dealing with offences such as this that do rely on striking that right balance in terms of speech and conduct that should be criminalised. So in that sense, we would say it's an attempt again to strike that balance between providing a very clear indication of what the strict elements of the offence are, but still allowing for that broader context to come into play, recognising, for example, that subsections like genuine purpose in the public interest, these are tests that the law is quite well used to, that do have their basis in other provisions, and so are things that courts are well versed in applying. And I might just see if Ms Diabru has anything she'd like to add to that.
I suppose the only other thing I might say is that the Law Council pointed to another provision in the same division which includes some similar or another way of being able to embed in these sorts of considerations, and that's in section 80.2H, and it includes as an element of the offence that a certain subsection does not apply, and then that subsection goes through and sets out certain considerations that the court could have regard to. So that's another way that it could be embedded into these provisions as well.
Okay, so I'm interested in perhaps if you could take on notice and provide us examples of other sections or other laws which use this sort of approach. That would be useful. It's always useful for us to say, well, here's a recommendation. This is the approach that's used in another scenario, so we think that's something which should be considered. In terms of the qualification, if I can put it that way, would it apply to each element or each of the offences? Is that the intention, or it would apply across all of 80.2?
That would be the intention, Senator, that it would apply to the whether the elements of the offence have been made out.
Okay. All right. In terms of, and it doesn't matter whether or not it was an offence threatening force or violence or urging force or violence, it would apply to each of the offences, each of the different offences. That's the intent.
That is the intent, noting, of course, that the elements of the offence are different, and the recommendation itself is designed to provide a series of contextual considerations that relate specifically to those elements throughout those different offences. Whether any of them are determinative in particular cases will obviously depend on the particular elements and the circumstances themselves.
Okay. Could I ask you to take on notice and just to provide your views with respect to a number of other submissions that have been received? Is that possible?
Certainly.
The Australian Right to Know organisation has made a submission, in particular with respect to freedom of the press and reporting on issues, and I think your proposed words could address to some extent the concern which they have. So very interested in you taking on just providing your thoughts with respect to that issue. We've also received some submissions from faith leaders which have raised concerns about the intersection of people in good faith practicing their religion and provisions of this nature in terms of freedom of speech, etc. So if you could also have a look at the submissions from the Combined Church Leaders submission 26, the Australian Catholic Bishops Conference 29, Christian Schools Australia submission 27, and also the Islamic Council of Victoria submission 14, which touches on those issues as well in terms of that intersection, that would be useful.
Could I just clarify, Senator? having looked at some of those submissions, they cover a number of issues. Is it specifically in relation to the intersection of that right balance and the recommendation that we've made that you'd like some consideration to be given?
I think to the extent that your recommendation would alleviate concerns that have been raised. So obviously you've read the submissions, you understand the concerns that they've raised. So I'm interested to know whether or not, from your perspective, the introduction of those words of clarification, if I can put it that way, would provide the relevant comfort in that respect. But also, if you've got any other response to any of the points they make, that was the primary reason why I raised it with you. But if you've got any other comments you'd like to make in relation to their submissions, I'd of course be interested to hear those.
Certainly. Thank you, Senator.
Okay. Thank you, Chair.
Thanks very much. Now, because I'm in video conference, it's a little difficult for me to see whether there's any other senators online seeking the call. I don't think there is. Thank you very much to the Australian Human Rights Commission. Thanks for giving evidence today and for your submission. We have given you some questions on notice, or Senator Scarr has, and there will be a short time frame for the return of those questions by the end of the week. I'm really sorry about that, but we're due to report on the 12th of December. So we will try to get you those questions on notice in writing, but we'll seek to get them back from you as soon as we can. So thank you very much for your time today.
Senator.
Thanks very much. Now we're due to go to our next panel at 10:15. I'll just check in with the Secretariat to see whether we have most of our next witnesses on the line.
So, Chair, we have representatives from People with Disability Australia, Rainbow Families and the Challenging Racism Project standing by, and the Secretariat is reaching out to HIV/AIDS Legal Centre and Equality Australia.
Okay, great. Well, we'll just suspend for a very short period as we get our other witnesses and come back at 10:15. its hearing. Thank you very much. And I now welcome representatives from People with Disability Australia, Equality Australia, Rainbow Families Australia, the Challenging Racism Project, and HIV/AIDS Legal Centre and ACON. Thank you so much for speaking with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. Now, this is always a bit of a challenge on video conference, so bear with me. For the Hansard record, can I ask each witness to state their name and the capacity in which they appear? And we'll start in the same order of those organisations that I read out. So we'll start with People with Disability Australia. We just need your name for the Hansard record.
Megan Spindler-Smith, Deputy CEO of People with Disability Australia.
Great. And Megan, do you have anyone else with you today?
I do. I have Lisa Ira. Lisa? Lisa is a Senior Policy Officer with People with Disability Australia and may be having some issues with their mic.
Sorry. Yeah, sorry.
No.
I'm here. No, sorry.
It's okay. Thank you. I think that was okay for Hansard's purposes. We'll come back to you if it's not. Equality Australia joining us by video conference.
Hi, it's Anna Brown here from Equality Australia, the CEO.
And Oliver Ray, the Senior Legal Policy Advisor.
Thanks both. And Rainbow Families Australia.
Hello, Heather Corkill here. I'm the Equality Director.
And Ashley Scott, I'm the Executive Officer of Rainbow Families.
Thank you so much. And Challenging Racism Project, also via video conference.
Hello, it's Rachel Jacobs, she, her, and I'm a researcher from the Challenging Racism Project. I'll also be joined by two of my other colleagues, hoping they are logging on soon.
Okay, wonderful. Thanks very much, Rachel. HIV/AIDS Legal Centre and ACON via video conference. I think you might be on.
Yes, hello.
Okay.
I'm Vikas Parwani. I'm the Principal Solicitor at the HIV/AIDS Legal Centre.
Thank you very much for joining us today. Now, I'm going to invite organisations to provide a brief opening statement. Obviously, we've got a lot to get through today, so if we could keep them brief, and then we'll go to questions. I might just go in the same order if that's okay with everyone. There's no predetermined order that witnesses have worked out. That's great, thank you. So we'll start with the People with Disability Australia, and if you've got a brief opening statement, if you can make it now, thank you.
Thank you, Megan Spindler speaking. So good morning. Thank you for this opportunity to speak on the behalf of People with Disability Australia, or PWDA, regarding the Criminal Code Amendment, Hate Crimes Bill 2024. PWDA is Australia's peak national disability representative organisation that advocates for the rights of 1 in 6 Australians with disabilities. We commend the government for criminalising threats of violence and force against marginalised groups, including people with disability and the LGBTQIA+ community. This is a significant step forward and acknowledges the harmful effects of the pervasive verbal abuse that we experience sometimes on a daily basis. However, we are concerned that the bill fails to address serious vilification that does not include threats of force or violence. Serious vilification can have devastating effects and impacts on people with disability, including harm to our mental health, our decreased self-confidence, and feeling fearful to leave the house. These significant impacts are present regardless of whether the speech involves a threat of force or violence. For example, one witness for the Royal Commission into Violence, Abuse and Neglect and Exploitation recounted the following experience. I was on a tram and a person who seemed to be quite intoxicated was yelling at me. And she had a broken bottle in her hand, and I didn't know what she was going to do. But she kept on talking about my face and, saying how ugly I was, and no one defended me on the tram. Disability Royal Commission witnesses also recounted that serious vilification elicited a flight or fight response, causing spikes in adrenaline, hypervigilance, and fears for immediate safety. constant experiences of serious vilification has led to some people with disability being too fearful to leave the home. As one Disability Royal Commission witness stated, there are some days when I am not mentally prepared for the onslaught and just do not have it in me to go out and battle the world. On these days, I simply won't leave the house. Clearly, hate speech, regardless of whether it includes a threat of force or violence, significantly compromises the human rights of people with disability. To only criminalise hate speech where it involves a threat of force or violence is arbitrary and does not reflect the reality of the victim's experience. We ask the committee to recommend that the bill be amended to criminalise serious vilification against people with disability and other marginalised groups. We also want to ensure that the bill applies to online hate speech, which infiltrates the safe haven of people with disabilities' homes, and to define force and violence to include disability-specific harm, such as removing essential supports or using restraint through co-design with people with disabilities. Thank you.
Thank you very much. I really appreciate that. Equality Australia, a brief opening statement.
Good morning, committee. My name's Anna Brown. I'm the CEO of Equality Australia. I'm here with my colleague, Senior Legal Policy Advisor Oliver Ray, as previously mentioned. Equality Australia is a national organisation dedicated to achieving equality for LGBTIQA+ people. We are grateful for the opportunity to appear before this committee to discuss this legislation. Now, this bill has been put forward in the context of serious and increasing attacks on LGBTIQ+ communities across the country. And over the last few years, we've supported communities in responding to serious instances of hate, such as the neo-Nazi rally in Melbourne last year or the vicious attacks on LGBTQ+ people by fringe groups in the West Australian town of Albany this year. Every week we hear of new instances of abuse and violence against our communities designed to intimidate us and curb the expression of our identities. In the last 10 days, we've seen the attack on a couple holding hands in Adelaide. Last week, the queer formal organised by LGBTIQ+ youth organisation Minus 18 was targeted once again. And just this morning, we were made aware of a violent homophobic attack in Melbourne over the weekend where a young man was hospitalised, seemingly because he was walking with his partner. We're pleased that the government is taking this step to recognise and respond to hate crimes, but it is a small step. The inclusion of LGBTIQ+ people in existing serious offences of urging violence and the addition of a new offence for threatening force or violence are a start. However, similar to the previous witness, we are concerned and disappointed that these changes do not adequately respond to real-life experiences of LGBTIQ+ hate crimes. In particular, the bill fails to provide any protection against hate speech and vilification that does not rise to the level of threatening violence. Serious hate speech is deeply harmful and creates the conditions in which targeted violence can occur. For those living in states that do not have anti-vilification protections, this bill offers no redress or comfort. The offences that have been included in the bill also fail to adequately respond to the lived experiences of hate by failing to protect those who are targeted because of their support for our communities. Too often and increasingly, council employees, librarians or local business owners have been the target of hateful attacks for hosting LGBTIQ+ inclusive events or initiatives. We've also seen the repeated attacks on LGBTIQ+ sites and properties such as murals celebrating our community. These acts motivated by hate are also not within the scope of the bill. In the face of growing hate and violence against our communities, we urge the committee to recommend amendments to the bill to provide stronger protections for our communities, including adding protections against serious vilification and hate speech and ensuring these offences adequately capture the kinds of hate that is all too often directed at LGBTIQ+ people. We'd also encourage, whilst this isn't within the remit of this current inquiry, the Parliament and the federal government to take broader action against and in response to this increasing hate and violence. This includes adequate reporting and monitoring and working cooperatively with justice and other agencies across the country to better respond to and support those impacted by hate. Thank you.
Thanks very much, Anna. Rainbow Families Australia.
Good morning, and thank you, Chair and committee members, for the opportunity to appear today on behalf of Rainbow Families. As I mentioned before, my name's Ashley Scott. I'm the Executive Officer of Rainbow Families. So Rainbow Families is the national voice for LGBTQ+ parents and their children, representing the lived experiences of thousands of families across Australia. Our families are diverse, but are united in love and a commitment to raising children in a safe and nurturing environment. Unfortunately, we also share the reality of being disproportionately targeted by hate speech and conduct, including the coordinated online attacks, which can have profound impacts on our mental health and sense of safety. We welcome the intent of the bill, and particularly its recognition of the need to protect LGBTIQ+ people and people with disabilities. Expanding the protected attributes, removing the good faith defence, and lowering the threshold of recklessness for urging force or violence offences are critical steps towards addressing hate-driven violence. While some states and territories have similar laws, there are major benefits to creating Commonwealth criminal offences. Federal police have specialised units with access to intelligence and the capability to effectively respond, and creating federal laws also overcomes jurisdictional issues which can arise in online spaces. However, we believe the bill must go further to provide meaningful protection. I'll hand over to our Equality Director, Heather Corkill, who'll talk about how the bill can be made stronger.
Thanks, everyone. So firstly, the proposed thresholds for the new threat offences, in our view, are too high, particularly requiring evidence that a reasonable member of the targeted group would fear that the threat will be carried out. We feel that this element unnecessarily shifts focus. It shifts focus from the perpetrator's conduct to the victim group response, rather than prioritising the nature and seriousness of the threat itself. Secondly, the bill does not adequately protect associates of LGBTQ+ individuals, so may not include our children, and allies, as was mentioned earlier by Equality Australia, such as those who may organise events. It also doesn't address threats based on perceived characteristics that are imputed to protected groups. And these gaps expose allies, children in rainbow families and others to harm, and leave marginalised groups vulnerable to coded or indirect attacks. Finally, we urge the committee to consider recommending further criminal or civil responses to hate speech that don't, in situations where it doesn't explicitly threaten violence but still causes profound psychological and social harm. Research demonstrates a clear link between hate speech, mental health disparities, and increased suicidality in LGBTQI+ communities. The law should recognise the cumulative harm of such conduct on our communities. In closing, the bill represents an opportunity to move Australia closest to a society where every family, regardless of how they are formed, can live free from hate. We urge the committee to adopt our recommendations to ensure these reforms are effective, inclusive and meaningful. Thank you.
Okay, thank you very much for that. Thanks. I might be having a slight technical issue, so I apologise for that, but I wanted to hand over to the Challenging Racism Project. I think Professor Kevin Dunn's been able to join us, as well as Dr. Teo. I'm not sure who's providing the opening statement.
Yeah, that's correct. I am here, and as is Dr. Teo, and also Dr. Jacobs has joined us as well from the Challenging Racism Project today. We are a national-based organisation looking at racism in the country for the last 2 decades. Our principal focus is on gathering empirical material on the nature of the problem, and more latterly looking at anti-racism, and particularly what's effective in the forms of disrupting racism, whether that be in online or in interpersonal circumstances, and increasingly looking at systemic racism and what can be done about it. Our view is that these legislation and instruments like them, while not used a lot, are important in the message they send to society around what is not only criminal and illegal, but what is uncivil and what is also something that we would prefer not to occur in the country. So these instruments are very important. We support the addition of recklessness and that new threshold. We also support the removal of the good faith provision. We're not of the view that there is any such good faith defence for this behaviour. And we support whatever can be done in the area of intersectionality as well, recognising the way that these forms of hate are often increasingly interconnected. And while it is not straightforward how to do that in legislation, we think it is very much an important exercise to undertake. Now, I might at that point, though, pause and just check to see if my colleagues would like to make any further comments. Rachel's given a thumbs up, suggesting not. Aaron? Thumbs up as well. So, yeah, as I say, we're very supportive of this initiative. If I make one other example, we've just finished a project on race hate speaker tours and an analysis of these attempts to bring speakers to Australia to perform effectively race hate talk. And we've looked at what are the effective ways to disrupt those tours. And unfortunately, these provisions are rarely ever used. The most effective provisions is the Migration Act, where visas are not provided for those tours. But there's a lesson, I think, in the provisions that are available to ministers and the ministerial discretion that's available there, which is not available in the same way to events which are occurring domestically and for which the race hate instruments are difficult to apply, particularly as we see a move towards more cautionary race hate talk from the far right and the organised racist groups into what they call cultural critique, which is making it more difficult to apply this legislation. But we'd make that observation as well if people are looking for instruments and ways to empower this legislation further. Thank you very much.
Thanks, Professor. And finally, the HIV/AIDS Legal Centre and ACON by video conference.
I'm the principal solicitor at the HIV/AIDS Legal Centre in Sydney. We're a specialist community legal centre that advocates for the rights of people with HIV and hepatitis nationwide. I'd like to commence by welcoming the inclusion of sexual orientation, gender identity, intersex status, and disability into the definition as a protected attribute. I'd also recognize that a combination of protected attributes being added that could be a basis for someone to unlawfully threaten or urge violence against a group is another welcome change. Now, recognizing that HIV and or hepatitis would be covered by the definition of disability in the Disability Discrimination Act 1992. But for the following reasons, we urge the committee to include health status in addition to and distinct from disability as a protected status. Previously, HIV was included in the definition of disability in part as a way to reduce stigma. The idea was that to show HIV to be just like any other disability would reduce some of that stigma. However, as HIV treatments have improved over the years and they've reached the stage where positive people can live lives of equivalent longevity to their HIV-negative counterparts, positive people can remain healthy, live long, and do all the things that HIV-negative people can. For this reason, the National Association of People with HIV Australia withdrew from the Australian Federation of Disability Organisations about 10 years ago. Now, there are just 29,000 people reported to be living with HIV in Australia. Of these, 95% are on effective treatment, which means that they cannot pass the virus on to anyone else. Despite these scientific advances, HIV remains a highly stigmatized condition in Australia, and noting that nothing that we've been able to do in the last 40 years has reduced the stigma. A recent study found that 37% of participants reported experiencing stigma within the last 12 months in relation to their HIV, including 4% reporting that they often or always experience stigma. A recent study found that 33% of healthcare workers would not treat someone with HIV, and 40% agreed with most people that a person with HIV is disgusting. Positive people report being refused medical procedures or having procedures delayed or postponed until that person then cancels them in frustration. Now, hate groups in the past have targeted key populations like the LGBTIQA+ communities and used language which described them as HIV positive or as HIV being God's punishment to them. HALC has progressed vilification complaints against individuals who've targeted LGBTIQ+ clients using similar language. Now, it assists that HIV vilification is proscribed under the Anti-Discrimination Act 1977 in New South Wales. And police are generally unlikely to charge offenders who target people with HIV or hepatitis because they don't also see HIV or hepatitis as a disability. Now, including HIV as or health status as distinct from disability would also cover pandemics like COVID-19, where there were reports in America of Chinese Americans being targeted because they were presumed to have COVID-19. Now, with scientists predicting further pandemics in the future, health status would cover these situations. Stigma and discrimination ruin people's quality of life. It erodes self-confidence and that they need to access health services. And in the case of people with HIV, it undermines their ability to remain undetectable. And it causes interpersonal violence. It also makes talking about drug use, sex work, or HIV more difficult, and more difficult for people to negotiate safe sex. As a result, it drives our epidemic, making STI transmissions more likely, not less. And part of the reason why stigma and discrimination persists is because the law that deals with HIV is based on outdated and incorrect stereotypes of HIV-positive people being an invisible threat, always looking to pass on HIV. Adequate categorization of HIV within the law is one small step, which in my submission would assist in reducing stigma. Thank you.
Thanks, Mr. Pawani. I appreciate it. You've actually covered off most of what I was planning on asking you in your opening statement, but thank you. I just will acknowledge that yesterday was World AIDS Day here in Australia, but it's obviously overnight across the world, and there was probably quite a few memorials around the country, and you probably were attending one, so thank you for attending our committee today to talk about this at the same time as acknowledging those people who've passed. Thank you. I just have a couple of questions that I will, and then I'll throw to Senator Scarr, and I might have some at the end. But I just wanted to, I sort of said this at the start of the Australian Human Rights Commission evidence, but just make it clear that our committee has been really willing to make recommendations to the government to amend bills to get the balance right. And thank you for all of the suggestions around how we can improve this type of legislation. I think there's broad agreement that we need this type of legislation, but we want to get it right because it's so important, and particularly for the communities that you represent so well. I thought I might ask to Equality Australia, but also People with a Disability Australia, one of the forms of hate crime that we are seeing in the news, but in more prevalence at the moment, is hate crimes involving anti-Semitism and Nazi symbols, and this connection around far-right extremism, but the way that Jewish people or people of Jewish faith particularly are being vilified. And I wanted to ask about the intersectionality that is recognised in this bill in some way, but probably could go further, as suggested by some of the witnesses. What are you seeing at the moment in terms of that intersectionality of the hate crimes that we're talking about, understanding that the very difficult, powerful history of other communities who've been targeted by Nazism in the past? I might go to you first, Megan. You're nodding your head, so I'm going to...
Megan speaking. Look, absolutely. We know inherently that a lot of Nazism that is demonstrating a high level of anti-Semitism also has a high impact on people with disabilities, in particular because of the fact that as part of the Nazi movement, disability is seen as something to remove and to no longer exist. And so that crossover is extremely high. But we do know that in particular, people with disability who come from racially marginalised groups or from culturally marginalised groups have a higher level of impact, and that intersectionality is actually seen as a massive issue. What we do know is that when it comes to people with disability, the crossover is extremely high and seen as very similar or receives the same level of impact. However, it is not given the level of support or criminalisation that it would in other areas.
Thanks. Might go to you, Equality Australia.
I think we'd agree with PWDA around the just what we see out there in terms of Nazi and neo-Nazi activity and far-right extremism and the anti-Semitism being combined with marginalisation and hate towards other communities, including our communities. And we saw that in a really high-profile context when there was neo-Nazis or Nazis, I'm not sure if anyone's actually properly characterised them, joining anti-trans protesters on the steps of the Victorian Parliament, and they had signs that I will not repeat, but essentially calling for the destruction of trans people. So we know the history of the Holocaust, and we know that at least gay people were persecuted, as well as many other communities and groups, including most notably Jewish people, but also people with disability. And it seems that these environments, these social environments that these groups occupy are very much anti-LGBTIQ plus environments. Oliver, did you want to add something about the...
Yeah, I think that's all correct. And we're just increasingly seeing far-right organisations working together. So the TERF groups that Anna has referred to, targeting trans people, we've seen increasingly working with groups that are targeting people based on their race, and Nazi organisations, like Anna mentioned. I think it's important that the law recognises, as it already does in relation to these two offences, that targeting someone based on a combination of attributes should be captured in the same way as targeting someone based on a particular attribute. But if the law is expanded in any way, for example, to include serious vilification, it would be important that a combination of attributes are also protected in that case.
Megan speaking. May I just add one thing to what we... fantastic. So one of the things to acknowledge as well is that as part of the Holocaust, people with disability were inherently utilised for experiments. And so a Professor Asperger's, who was a Nazi sympathiser and engaged in that space, what we do know is that inherently people with disability were utilised for experiments through that time. And the issue is that now within the neo-Nazi space, that expectation and that dehumanisation is extremely high. And it does actually represent a high level of range of groups because Asperger's utilised the concept of classifying different forms of disability as either viable or inviable in society. And we know that neo-Nazis do fall under that. And the crossover with the LGBTQIA plus perspective, that is a very high issue that we are still seeing when it comes to neo-Nazi representation, and it does definitely spill over into other groups as well.
Thank you. And we're going to hear from the Jewish community directly about the escalation that they've seen, but I just wanted to get on the record, I guess, the intersectionality that we're trying to get cover off in this bill. Can I ask about anti-vilification? So lots of submissions have recommended that the bill go a step further, and I've got a really open mind about this, and I hope other senators do as well. But then other submissions obviously have called for us to, even wind back the protections in the bill itself. So getting the balance right. If I can start with Equality Australia, and we'll go to other organisations who have a view on this. Why do you think an offence of serious vilification is needed, and are there any particular models that you think that the Commonwealth should be considering?
So the importance of including serious vilification within the bill is because part of the hate conduct that we're seeing against our communities quite extensively doesn't rise to the level of the offences already in the bill. A lot of the things that we're seeing is language that is referring to LGBTIQ people in hateful ways, comparing our communities to pedophiles, saying, calling LGBTIQ people groomers, a lot of examples of speech that is incredibly harmful and can lead to, serious harm in a variety of ways beyond threats of violence. And what we've seen, for example, with drag storytime events and other events that have ended up being cancelled is not just those direct and credible threats of violence, but a range of conduct that leads to stigmatisation of our communities and puts us in further danger. So in terms of models, I think I might defer to Anna on this one first. And
that's fine. So, I mean, it might be useful to say, even look at the recent bill introduced in Victoria, but generally with support introducing, as other witnesses have supported or spoken in favour of, both criminal and civil protections. And when it comes to the civil protections, having a harm-based type provision that focuses on the impact on the affected group rather than just the incitement of a third party, even if it's hypothetically. And just one broad observation, and I think this point has been made in a number of submissions, is that the offences generally across the country in many jurisdictions have been rarely utilised, and that's been a real issue. Obviously, it's important that these laws send a message, and the deterrent effect they have is really crucial, but they also need to be able to be used when language is at an appropriately sort of high level to meet what should be, I would say, a lower threshold. They're just so rarely prosecuted. So that the inquiry that has preceded the legislation in Victoria, for instance, carefully examined some of those barriers, and the bill as a result has introduced a suite of responses. And I guess it's worth mentioning that the parliamentary inquiry had multi-partisan support, which was really welcome as well.
Thank you.
Heather, experiences from...
Yeah, I was just keen to see if there was other groups that had a view on an anti-vilification. Also, the Challenging Racism project might have a view as well, because we'll hear from different groups later today that support that extension.
Yeah, we would, speaking from the Challenging Racism project, and we have made these submissions to other inquiries at different times. You were talking before around intersectionality. It's not just that a particular speech event carries a hate ideology against a couple of different groups. What's actually happening here is organised groups are using these discourses to mobilise support. And they go intersectional so as to draw more people into their campaign. It's an organising event, and if we are to take a public good and public order perspective on these things, then we must be looking for additional instruments to disrupt this capacity. And so I'd encourage as much as possible for members of the committee to be thinking more about the public good and what we're attempting to do here to circumscribe the organisational capacity of something which is very ruinous to our civility and good public order in the country, rather than focusing on the rights of an individual to a particular type of speech event. Thank you.
Yeah, thanks very much. Ms. Corkill, did you have something to add? I thought I saw you come off mute before.
I didn't, but I'm always happy to add something.
Thanks, and then I'll have to hit. Sorry. Yeah.
Absolutely. So we would definitely recommend some type of anti-vilification protection at the Commonwealth level. And we think that's really important because although there are some protections in the states, they are quite patchy. And we think that this needs a national coordinated approach. It's often not a priority for busy state police services. They've obviously got a lot of other crimes to investigate, and it's really complex. There's actually difficulties obtaining and securing evidence. They're complex crimes, and we think that it actually really needs that federal response to hate speech beyond what is already in the bill. I don't know if I've found the perfect solution for this, but I did have a look at the French laws, which include, rather than just criminalising urging force or violence, they actually include the term hatred as well, which hatred is still a pretty high bar. It's not like ridicule or other matters that are or like reviling conduct, which is under state laws, and that may be a reasonable solution to still protect speech whilst also addressing that type of conduct that I think Oliver from Equality Australia was explaining before.
Okay, thank you. I'm just conscious of time. I've got to hand the call to Senator Scarr. I've got some other questions if we have time at the end, but Senator Scarr, I just did want to give you an opportunity to ask some questions.
Very much, and thank you to all of our witnesses for appearing today, and thank you very much for the advocacy, strong advocacy you provide on behalf of members of the community. It's greatly appreciated and acknowledged. Can I ask my first question to the HIV/AIDS Legal Centre, if I could? And I just want to drill down into whether or not there is any concern at all that HIV status and hepatitis status would fall within the definition of disability. So is it a question of it not being covered, or is it more a question of trying to draw out the attribute as a focus for the law?
Thank you, Senator, for that question. It is, we would say that it is covered by the law and within the legal definition. The issue is that the word disability doesn't align with what the experience and the lived experience of people with HIV and hepatitis is in today's age. So it's stigmatizing language that promotes an idea of a condition that is very different from what it first was when that act was introduced and that definition was introduced. So it covers it in that way, but also in terms of what the understanding of disability that police and prosecutors have. And so when a complaint of this nature comes to them, having health status there or HIV or hepatitis specifically there shows them a more direct link between the offence and the alleged behaviour than having it included in the definition of disability.
Oh, okay. So an alternative to actually specifically referring to HIV or hepatitis is referring to health status.
That's right.
Is that the submission?
Yes, that is our submission. Thank you, Senator.
Okay. All right. Do any of the other witnesses have anything to add in relation to this issue of either specifically adding an attribute in connection with HIV and hepatitis status, or including an attribute based on health status?
Megan Spindler-Smith from PWDA. Look, we would be supportive for a few reasons. One, because disability, when it comes to HIV, sadly at the moment, disability only covers when it is seen as problematic, and when the HIV is seen as problematic, e.g. the dementia related to HIV and things like that. However, and in absolute acknowledgement of the colleague here, because of the fact that medications and the treatment of HIV is so far ahead within Australia in particular, this does not necessarily lead to these cases, and therefore for many people who have a health status, that falls under the HIV space, they don't necessarily fit correctly underneath the disability requirements and therefore would be ignored or left out. But we do know that it is something that is absolutely an issue and should be supported. So we would have no issue from a disability perspective as the peak body in this space.
Yeah. Okay. Thank you. Does anyone else have any questions any other answers they'd like to provide to that question? I think that's pretty clear. Okay, thank you. I want to move on to next topic I want to ask is Equality Australia proposed an expansion of the scope of the offence to include a threat to use force or violence against property of a person. And as I understand the way the proposed offence is working at the moment, property would only be covered if a person was connected with the property at the time the violence or threat was made. To what extent, based on the experience of the community, is it seen as really important that the offence be extended to include a threat against a person or property? What are you seeing on the ground that triggered this recommendation to expand the scope of the offence?
Yeah, so thanks for the question. There have been a number of things, and we included some of them in our submission, but in particular, events that are targeting murals, for example, rainbow crossings, public symbols of the community that are designed to promote inclusion, and seeing attacks on those instances of property is not just about the property itself, but also about what that symbolises to the community. We've also seen attacks on venues, and so spaces that are known to be LGBTIQ plus safe spaces, bars, for example, or other community spaces can also be targeted. And this is equally a hate crime as an attack directly on an individual. So that's where that submission is coming from.
Any other contributions on that question in the context of hate crimes in connection with a threat to use force or violence against property as opposed to an individual?
Sorry.
No, please go ahead.
Sorry, Heather Cockhill from Rainbow Families here. Certainly people of faith are experiencing this. So we've seen in Queensland at least mosques be attacked with hateful messages in paint and those sorts of things. So certainly I would strongly support that the threats may be beyond just personal offences. So there would be some merit in including it.
Okay. Anyone else? Yep.
Yes, Megan Spindler-Smith from People with Disability Australia. I think the one thing we would also add is looking at property not just in physical buildings, but also looking at things like mobility aids and items that help and support people with disability to engage in community, but also survive. We have seen situations where these have been removed or accessibility has been actively removed versus it already being not there in the first place. We're not worried about that. That comes under other areas. But when it's actively removed from either a property or from the person themselves, those are issues that we are seeing quite constantly happening, where people are then not able to safely engage in any form of employment, society, or basic human rights.
Well, that's deeply disturbing. Is that occurring in a context where it's an expression of hate, or is it a general vandalism, theft issue?
No, these are occurring in instances of hate where people are physically either damaging or taking away people's mobility aids or even verbally threatening to do so that people are then not able to engage or move around in any way, shape or form. Yes, those things are actually happening.
Goodness me, I wasn't aware of that. So thank you. I'd find it very interesting if you could provide any case studies to the committee in that regard, because that's horrific. I hadn't I hadn't come across that, so that's deeply disturbing. So thank you very much for bringing that to the attention of the committee. And if anyone else has any additional case studies, I know Equality Australia did provide some very useful case studies in relation to damage to property. So if anyone else has any case studies with respect to the property aspect of hate crimes, which we should, which you think would be useful for this committee to consider, and case studies are always extremely useful. So thank you very much. Another issue which has been raised is, again, in relation to the scope of the offence of the threat to use force or violence, is whether or not it should be expanded to include a greater class of people, namely associates of people with the relevant attributes, or others who may be impacted by the threat of the use of violence or force. And in that respect, I understand some of the submissions have talked about where threats have been made in relation to events, and the impact that has on people connected with the event. I just wanted to give an opportunity for everyone to perhaps expand upon those arguments and how we might define the additional class of people we're trying to capture here, because I think it's a very useful point that's been made by people in relation to others who might not necessarily have the relevant attribute, but you might be a parent of someone who's a member of the LGBTIQ community. You might be someone who's hosting a party. You might be whatever it is. How would you define that additional class of people, if I can put it that way, who are potentially impacted by or the subject of threats to use force or violence against people who have a particular attribute? So I'll go to Equality Australia first.
Thanks for the question. It is a challenge, and that's one of the reasons why we've suggested a reformulation of the offence. We think that that's the cleanest way to do it. Reframing the offence as about threats to use force or violence being motivated by prejudice towards a group, which is distinguished by one of the categories, for example, race, sex, sexual orientation. That particular reformulation captures all kinds of hate that is motivated. So it's focused on why the hate-based conduct is occurring rather than specifically who is being targeted. We understand that the reformulation requires a fair bit of work, so we've also had a look at reframing the particular characteristics as well. So we've looked at some of the definitions of personal association. That goes some of the way and includes some members of the community that are closely connected to, for example, LGBTIQ plus people, but doesn't go all of the way. So we've also considered the need to redefine this term more broadly. And I think Heather from Rainbow Families had an additional suggestion based on the Queensland approach.
Yeah. And I don't know if you were asking this, Senator, but and we covered it a bit in our introduction, but just in terms of this sort of broad scope of people that are impacted in our experience, increasingly we're looking at council employees and workers, and I'll just single out, just as one example, our patron Tony Briffer, who happens to be, he's a patron of Equality Australia because they're an intersex advocate, was also until recently the Mayor of Hobsons Bay, and because of all of the increasing sort of far-right activity and threats that the council there were experiencing, Tony had to take out, Tony then had a security detail and was feeling obviously personally very, very unsafe because of the threats that were being made to them as the mayor. But we see this with librarians that have of libraries that have hosted drag storytime events, local business owners, and as Rainbow Families pointed out, obviously children of Rainbow Families as well. Like there's all sorts of broad, and the example that you identified yourself. So we're talking about a really broad range of different types of actors here.
And if I might add, possible.
Kill. Yeah.
Yes, thank you very much. Yes, the Anti-Discrimination Act Queensland has quite a neat and tidy option, which is to simply, as an alternative, add to the list, which is currently race, religion, sex, etc. You could say just and association. Association could be defined then as being associated with or in relation to a person identified on the basis of any of the other protected attributes. So that's how it works under the Queensland Anti-Discrimination Act, and it's fairly well tested there. And so it will not only include a personal...
You've just frozen.
An event or... Did you lose me?
Yeah, we lost you. You froze under the severity of my cross-examination.
Oh dear. Okay.
Not quite.
Yes.
So you're talking about the Queensland Anti-Discrimination Act.
Yes, thank you. And it includes it includes the words association with or in relation to a person identified on the basis of the other protected attributes already covered in the list.
Is that in a criminal context or a civil context?
That is civil, but it doesn't really matter in the sense that this is just an articulation of the protected attributes, which works in either context.
Yeah. Okay. All right. Thank you. Then the last question I have...
just going to, let you know.
I even know when you're conscious of time before you express it, Chair. We've been doing so many inquiries together. The last question I had was just in relation to this issue of whether or not we should be looking at the incitement, whether or not the relevant test should be incitement of fear in the relevant individual or a reasonable person within the class of individuals in terms of the test. And I've sort of been pondering this in different contexts, and quite often the law, I think it's fair to say the law does use this sort of formulation in a few contexts. What's the concern that if you use a test which is based on what a reasonable person who's a member of the particular cohort of people you're looking at, what's the concern that will be setting the bar too high? And is it possible to give us some particular examples of or case studies which can draw out the issue from your perspective? Can I go to Equality Australia first?
Sure. Yeah, so just very briefly, we support looking at the incitement of fear within the individual rather than a reasonable member of the target group. That's because we're not interested in a sort of hypothetical reasonable person. The relevant person here is the person who has been the target of a hate crime. And it should be sufficient that the actions of a person have incited genuine fear in a particular person, and that person who is the victim. As we mentioned in our submission, in those circumstances, criminal assault would already have occurred, and so why add this additional threshold? I don't have particular examples, but I might defer to other groups to provide in the interest of time.
Megan Spindler-Smith from People with Disability Australia. I can give you a direct example,
yes, please.
But also just to acknowledge that it is really important, especially when we think about the community of disability. We are such a diverse group, and also the impact of trauma can be very different depending on the diversity of our group. But I can give you a very specific example. A witness from the Disability Royal Commission stated, and this is a direct quote from them, so someone had posted my photo with me holding a glass of champagne, and it was on a forum called What the F Forum. And below there were 500 of comments about my face. People had said things like, what does your vagina look like? What the F is that? It looks like something that was partially digested by my dog. They described me as a lobster, and there were lots, and they diagnosed me as well. they said that I should be killed with fire. So it moved from an initial conversation around this person's visual space to being moving into threats of violence, because these people were encouraged to move into that space due to the conversation that was happened. And what we do know is that for this particular person, this sadly is a very big part of their life. And so the level of impact on them may be less than somebody who hasn't, but from a very standard perspective within the disability community, we have to be clear. But also we need to recognise that the concept of reasonableness has been used against many people with disability because of psychosocial disability, intellectual disability, and because of cognitive disability. And so we do have to be careful around that particular terminology when it comes to people with disability.
Senator, I offer a comment here from Challenge Racism Project. Our view is that well, we are more interested than the social and broader effects of these hate speech acts. And so in some respects, you would think if a reasonable person amongst the targeted group was affected, then that would be a good test. However, the problem is it's just too difficult a threshold, and it goes to the heart of why many of these instruments are not deployable and as effective as they could be. It is a straightforward thing to test whether someone was offended, was fearful, etc. So the individual is just, in the end, the best mechanism for this act to be brought to life in order for us to take issue with the scourge that is hate.
Okay, thank you. Thank you, Chair.
Thanks very much, Senator Scarr, and thank you for everyone for appearing today. We've run out of time. I had a few questions about the expansion around associated groups, but I'll just maybe finish by thanking you for your advocacy. There's a little 2.5-year-old who has 2 mums that I'm thinking of when it comes to that expansion. So we'll see how we go with that one. Thank you very much for appearing today. The committee is going to have a really brief suspension. We might come back at 11:15 with our next set of witnesses, if that suits other senators. Thank you.
Thank you. See ya.
ready to resume the hearing, if we can. Thank you very much for broadcasting. And welcome, Senator Faruqi. Good to see you. I now welcome via video conference our next set of witnesses, the Justice and Equity Centre, the Human Rights Law Centre, and the Castian Centre for Human Rights Law. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name and the capacity in which you appear today? I'll start with the Justice and Equity Centre.
Alastair Laurie, Director of Policy and Advocacy, Justice and Equity Centre.
Great. Human Rights Law Centre.
Arif Hussain, Senior Lawyer at the Human Rights Law Centre.
Thank you. And the Castian Centre for Human Rights Law.
Melissa Caston from the Castian Centre for Human Rights Law at Monash University.
Great, thank you. And do you have some colleagues with you as well?
Yes, they'll just introduce themselves now.
Runley Sifris, a Deputy Director of the Castian Centre for Human Rights Law.
Scott Walker, Research Fellow, Castian Centre for Human Rights Law.
Thank you very much for joining us today. Would your organisations like to make a brief opening statement before we go to questions? And we can go in the same order if that's helpful. We'll come to you, Mr. Laurie.
Thank you. The Justice and Equity Centre supports the main provisions of the Criminal Code Amendment Hate Crimes Bill, while also submitting that they do not go far enough to adequately address the challenge of hate speech against vulnerable communities. For example, while the proposed amendments to the offence of urging violence against groups or members of groups, including the expansion of its scope to cover women, LGBTI people and people with disability, are welcome, we note that the most likely outcome would be an offence that is infrequently prosecuted now will instead become infrequently prosecuted in relation to more groups. In his second reading speech, Attorney General Dreyfus stated that, quote, "The legislation I am introducing to the Parliament today responds to the increasing prevalence of hate speech and hateful conduct in our society. This conduct cannot and will not be tolerated," end quote. To meet this worthy ambition, the bill requires significant expansion. This includes amendments to ensure that civil vilification protections, currently found in Section 18C of the Racial Discrimination Act, are expanded to include religious belief, disability, sex, and LGBTI people. While the recent decision of Faruqi and Hansen has clarified that public expressions of Islamophobia can be considered racial vilification in some circumstances, we nevertheless believe religious belief should be explicitly added as a standalone protected attribute to ensure all minority faith groups are covered. The inclusion of disability as a protected attribute would also be consistent with the recommendations of the Disability Royal Commission, and the introduction of civil vilification laws protecting LGBTI communities is necessary to respond to multiple recent incidents involving disturbing homophobia, biphobia, and especially transphobia. It would also bring Commonwealth law into line with the emerging consensus of state and territory approaches to this issue. And briefly on this point, it was disappointing to see the Attorney General's Department submission depicting the New South Wales Anti-Discrimination Act as only prohibiting racial vilification, when it also covers religious belief, homosexuality, transgender, and HIV/AIDS status. Finally, the Justice and Equity Centre makes two recommendations in relation to terminology and definitions. First, we submit that the protected attribute of gender identity, both for the offences contained in the bill and any new vilification provisions, should be amended to gender identity and expression. This is necessary to ensure Commonwealth law provides a response to threats of violence and intimidation against drag story times, which have been all too frequent over the past 18 months. Second, we submit that the protected attribute of intersex status be replaced with sex characteristics, including in the Sex Discrimination Act. Sex characteristics is now considered best practice and is terminology supported by Intersex Human Rights Australia, with this change promised by the Albanese government more than 2 years ago. Thank you.
Before I begin, I would like to acknowledge that I'm dialing in from the land of the Gadigal people and pay my respects to elders past, present and emerging. The Human Rights Law Centre welcomes the opportunity to provide a submission and evidence to the committee in its inquiry on the Hate Crimes Bill. The Human Rights Law Centre supports the Hate Crimes Bill as a first step in addressing the worst aspects of expression of harmful hatred. More specifically, we support proposed reforms to Section 82A and 82B of the Criminal Code, which contain offences of urging violence against groups and urging violence against members of groups. In particular, in relation to these provisions, we support the expansion of protected attributes covered by these offences. We support the change to the mental element required to establish these offences from intending to recklessness. We support the removal of the good faith defence for offences created by these sections. We also support the proposed new offences in section relating to threatening force or violence against groups or against members of groups. We support the bill's amendments of existing offences relating to prohibited symbols, which apply in relation to public displays of prohibited Nazi symbols and giving Nazi salutes, and publicly displaying prohibited terrorist organisation symbols and breaching sections to directions to cease displaying prohibited symbols in public. Although we support the bill, we know that these changes only address the worst aspects of expression of harmful hatred, as it only prohibits urging violence against groups or members of groups, threatening force or violence against groups or members of groups, or publicly displaying prohibited symbols. We submit for everyone in Australia to be able to go about their lives free of discrimination, hate speech, and vilification. Much broader set of reforms are needed. The Human Rights Law Centre have made the following recommendation: is strengthening Section 18C to prohibit offending, insulting, or humiliating on the basis of race, religion, religious belief, sexual orientation, gender identity, and disability. A uniform Anti-Discrimination Act to consolidate federal discrimination laws into a single uniform modern Anti-Discrimination Act, and enacting an Australian Human Rights Act. Thank you.
Thanks very much. And we'll go to the Castian Centre for Human Rights Law.
Thank you, Chair. And thanks for the opportunity to appear before you this morning. We're joining from the lands of the Wurundjeri and the Bunurong peoples of the Kulin Nations, and we also pay respects to elders of those lands, past and present, and respect to any Aboriginal and Torres Strait Islander people who are present with us on this call. We want to say in that some general points before we get into your questions, and that goes to these issues. Violent, hateful conduct is a significant breach of human rights, and it's abhorrent to the very foundation of human rights, which are founded on principles of the inherent and inalienable dignity and equality of all people. That conduct does significant harms to individuals and to groups who are targeted, and it also harms the very fabric of our diverse communities. Australia is a party to a series of human rights treaties in international law and therefore has an obligation to respect, protect and fulfil those human rights. And under these obligations, Australia is required to take adequate action to address the violent conduct, and it's this conduct that the bill seeks to address. Although the right to freedom of thought and freedom of expression and association are protected under human rights laws, these rights are not absolute, and limitations on these rights are permissible and often necessary. To be lawful, the limitations must be adequately balanced and legitimate. They must be proportionate. They must be made according to law and non-arbitrary. Laws that, like these, which appropriately define that hateful conduct and which do not impose wide-ranging restrictions on activity, are likely to be compliant with human rights, given the significant social ills that are sought to be addressed by these amendments. And the bill here addresses hate crimes through specific provisions that criminalise the making of threats or violence against specific protected groups and people. Importantly, the bill does not seek to criminalise mere expression of opinion, but focuses on conduct that escalates to violence or the incitement of violence. It's a targeted, proportionate response to a serious growing problem. The bill ensures that not only the most egregious forms of conduct are criminalised, that only the most egregious forms of conduct are criminalised. And in our view, this bill is proportionate and does not infringe human rights standards. The amendment, in fact, seeks to support the human rights of those attacked and affected by hate speech. But at the same time, we must acknowledge that the law alone cannot address the root causes of such conduct. It supports those impacted by the conduct, but cannot serve as the primary driver of social change. And for this reason, we want to reinforce that education, building social cohesion and public awareness are equally important in addressing the causes of violence against marginalised or targeted groups. We recommend that the laws here be accompanied by resources to counter extremist violence, to support social cohesion and interfaith initiatives, to invest in human rights education nationally, and for commissioning university research into the best practices to support proper investigation and evidence for the appropriate prosecution of hate crimes. It's important to establish effective practices so that police can enforce the laws and protect those who are affected. The bill sends an important message to the public, particularly the members of the targeted group, that the law seeks to protect them and that there are accessible pathways to adequate redress. So thank you, Chair. We welcome the committee's questions.
Thank you very much for your time. I'll hand to Senator Scarr. We'll probably have 10-minute blocks each. We've got a few senators that have questions. So Senator Scarr, if you're there, we can hand to you.
Yep, thank you. Can I first ask some questions to the Justice and Equity Centre? And I think we've received a number of submissions in this respect, but I just, I think, provide you an opportunity just to reinforce the point in relation to why it's necessary and clearly advisable to include disability as a protected attribute for the purposes of the offences relating to publicly displayed prohibited symbols.
Thanks very much. I think, as you already heard from witnesses this morning, people with disability were targeted under the Nazi regime in the lead up to and during World War II, and are therefore a potential target for far-right extremist displays of symbols that cause people with disability harm alongside other groups, including based on race and religion and LGBTI status. It's unclear to us why disability wasn't included as a protected attribute in the bill, and we think it is necessary to make sure that these protections, these provisions, are as comprehensive as possible.
Okay, thank you very much. If I can go to the Caston Centre for Human Rights Law, we received submissions from Equality Australia in particular that spoke to the need potentially to increase the scope of these laws to consider not just urging violence against a person, but also violence or destruction of property. So a number of case studies were given where property which was clearly associated with someone who had one of the particular attributes had been targeted because it was owned or in the case of art, had been prepared by, created by someone with a particular attribute. So the manifestation of the hate crime was not to use violence against an individual, but to destroy property associated with that individual. And that's how the hate crime manifested. I'm interested in your view, and I'll go around the panel of witnesses as to your thoughts with respect to either expanding the scope of this provision to include property, or whether or not that should be something which should be considered in a separate provision, or is there any reason why both shouldn't be considered in the same way or through the same lens?
Thank you, Senator. Look, I haven't turned my mind to this until this point this point right now. My initial reaction is I can't see why we would not protect the expression or incitement of hate speech in whatever its manifestation is, and the attack or destruction or graffiti of property may amount to the prohibited hate speech and threats, because it's not just a matter of the speech that's spoken or written, but it might be conveyed through the destruction of the property or the postering or graffitiing of the property. Honestly, this is my initial reaction to what you've said. I haven't really thought through the consequences, and you'd have to, if you were to add that in, you'd have to make the sentencing consequence of that be proportionate to ensure that we're not overbalancing. But hate speech can be conveyed a number of ways, whether it's holding up a particular flag or saying something aloud or writing it on property or a wall or on a banner. It still can amount to hate speech. So I think that is a feasible proposition.
Okay, if I can go to the I'll just go around the committee and give everyone an opportunity to give their thoughts in relation to that. And I appreciate you might not have considered it because it's not on the face of the proposed offences at the moment, but it was something which was raised by one of the committee witnesses. So if I can go to the Human Rights Law Centre.
Yeah, thanks for the question. And similarly, I haven't turned my mind to it in much detail, but what I know is that mosques, synagogues, and other areas that are identifiable to particular groups have been targeted and have been targets of hateful speech and expressions. And those have a profound impact on individuals and communities and can lead to isolation and serious mental and physical harm. So in that context, I think it should be considered.
And there was certainly an example in my home state of Queensland where a mosque in Toowoomba had been the subject of 2 arson attacks. But it has been built and is operating with the support of the whole community. The Justice and Equity Centre.
Like my colleagues, I haven't turned my mind to answering this particular question. We're happy to take it on notice and provide more information to the committee.
Okay. One other issue that's been raised during the course of the inquiry was whether or not the scope of the offence should be expanded to include those who have some sort of degree of association with people who have the relevant attributes. So where a hate crime is manifested, perpetrated, it's directed at those who are in some way providing support to or connected with people who have the relevant attribute. And examples might be someone who's potentially hosting an event or offering to host an event and they're subject to threats of violence if they go ahead and host the event or allow the event to occur. To what extent do you think that the consideration should be given to expanding the scope of the offence so it's to include those who are targeted, are subject to the violence, threat of violence or use of force as a result of their association with people who have the relevant attributes? So I'll go first to the, and again, I appreciate you might well not have considered these issues in depth, but interested in whatever thoughts you have in the first instance. And of course, happy to receive any additional thoughts you have on notice subsequent to the hearing. If I could go to the Caston Centre for Human Rights Law first.
Yes, so once again, I confess I hadn't quite thought this through in its expanded version. But if people are being attacked for their support or association with a protected group or a targeted group, then that is in effect a manifestation of a threat or the violent incitement. And I do think that comes within, or either it comes within or it should be drafted so as to come within these laws. Otherwise, we run the risk of proponents of hate speech very cleverly sort of trying to weave their way around very specific provisions and saying, oh, I wasn't attacking that person, I was attacking that person who gave comfort or space to that person. And I think that would undermine the meaning and purpose of these laws and these amendments. I haven't quite, on my feet, quite thought of how you would add in the extra words, but perhaps the parliamentary drafts people would have an idea of how.
Look, I appreciate that, but if you do have any additional thoughts on that,
yes, sure.
With the benefit of some hindsight and some reflection, we don't have a lot of time, but it was an issue that was raised, which I thought was quite interesting for obvious reasons, I think, which we probably all understand. The Human Rights Law Centre.
Yeah, again, we also haven't turned our minds to that question, but I guess in principle, I wouldn't disagree with the idea of protecting those imputed with attributes, because that has a similar effect on the community. So it's the imputing of a particular attribute to specific groups or their associates.
Yeah, so I understand the issue in terms of the imputation, those who are imputed with attributes.
Yeah.
This is even a once more removed, if I can put it that way, from potentially from that. The Justice and Equity Centre.
Thank you. I think our starting position would be to support in principle. I can see the utility of this type of definition, particularly for events like drag story times, where the threats of violence or intimidation are not just against drag performers, but against the organisations that host those events, including in a number of cases public servants. But we're happy to consider the issue further and get back to you with more detail.
Senator Scarr, I'll have to share the call in a moment if you've got one more question.
Okay. Thank you, Chair.
Thank you, Senator Scarr. Senator Faruqi.
Thank you very much, Chair. Good morning, everyone, and thank you for being here to answer our questions. If I could start with the Human Rights Law Centre, you have made a recommendation in your submission about Section 18C of the Racial Discrimination Act, that it should be amended to prohibit offending, insulting, or humiliating on the basis of race, religious belief, sexual orientation, gender identity, and disability. The Australian Human Rights Centre, in their recent National Anti-Racism Framework, have also recommended that a positive duty be included under the Racial Discrimination Act, which would be, they say, similar to the recent reforms to the Sex Discrimination Act 1984, and also as proposed by the Disability Royal Commission for introduction into the Disability Discrimination Act 1992. I just wanted to get your views on that, whether you would agree with the Australian Human Rights Centre in that respect of positive duty.
Yeah, so I believe you're referring to the Australian Human Rights Commission's recent report and framework around tackling racism. And I haven't looked at it in detail, but in principle, the positive duty would be, I think, including it in the Racial Discrimination Act would be a benefit. Yeah.
Do others have any comments on that?
Thank you, Senator. Yes, I think we would agree with that position of a positive duty.
We also agree. I think positive duties are emerging in anti-discrimination frameworks across jurisdictions and would be of benefit not just in the Racial Discrimination Act but elsewhere.
Okay, great. Thank you. And Mr. Hussain, your submission advocates for a comprehensive Human Rights Act at the federal level. This is something, obviously, the Greens have been advocating for a long time. I'm just wondering if you could expand a little bit on why is this Federal Human Rights Act necessary, and specifically, I guess, in terms of protecting marginalized people from discrimination, violence.
Thank you so much for the question. So Australia has signed up to and accepted international obligations on a voluntary basis, and those obligations include protecting individuals from discrimination, hate speech, and vilification. These treaties require the Australian government to ensure equality before the law and to protect individuals from discrimination, hate speech, and vilification based on race, religion, gender, sexual orientation, disability, and other protected attributes. At the moment, as pointed out in our submission, there is a piecemeal and inconsistent protection in our laws, and we believe that a Human Rights Act, a National Human Rights Act, that has been recommended by the Parliamentary Joint Committee on Human Rights would ensure that human rights of everybody in Australia is protected and that everybody is able to go about their lives free from discrimination, hate speech, and vilification, because it would provide a framework for the government to prevent human rights breaches and allow individuals to take action when their human rights are breached.
Thank you. And this is a question, maybe if you could answer it one by one. And I refer again to the Australian Human Rights Commission's recent report, the National Anti-Racism Framework, which has called for anti-racism work to be embedded in truth-telling and self-determination of First Nations people, and that it should be intersectional and community-centric. And I think from what I'm hearing from all of you, you really agree with that, and especially the intersectional aspect of the work. The framework recommends that Australian governments explore and fund community-informed and early intervention solutions beyond civil and criminal penalties to address far-right extremism and white supremacy in communities, particularly as they intersect with other forms of discrimination. And maybe if I could go to the Castan Centre first. I mean, do you also see the criminal justice system as just one of the many avenues to address hate speech? And what else would you like to see governments do to address the underlying causes of far-right extremism, hate speech, and violence?
Thank you, Senator. I think we had this conversation when we met last time at a different inquiry, and I think my answer remains the same. I think it's critically important that we fund deep work in social cohesion, in youth education, and particularly in human rights education, obviously for young people and children, but also in the community and for adults, of course, as well. I think that this we need a concerted effort for people to understand issues of civics and the importance of the institutions of government and how they function, as well as understanding the human rights framework and how it fits together. And I think that interfaith dialogue is a very important aspect as well of cultivating social cohesion. So there's a vast sort of collection of things that could be done. And as I mentioned to you last time, although we are a law centre, so we concentrate mainly on the law part of this equation, we see that the law will only work with a really considered effort at building up social understanding and respect and dialogue, even when people don't agree and they have very different views. They're entitled to have different views, but we must hold those views kindly with each other and leave space for people to express their different views. And that's why we see the human rights education piece of work very important. Laws alone will not cure the problems of hate speech and far-right extremism and violence in society.
Yeah, thank you. If I could go to you, Mr. Hussain, and I just want to raise the point that the Australian Human Rights Commission has raised as well about being very deliberate about anti-racism work and using the term racism as opposed to social cohesion as well. I just wanted to get your view on the broader question of what we need to do beyond the criminal justice system.
So I think the three recommendations briefly for us is reform to 18C, a consistent anti-discrimination framework, and a Human Rights Act. But more broadly on a societal level, you mentioned social cohesion and the use of that word. And I think that goes to the point of the rhetoric that and the discourse that exists in community and in these discussions and displayed in our polity. And in that sense, we need to be having a wider conversation around how different groups, and especially marginalized groups, experience racism in this country and the power dynamic that exists there.
Thank you. And how about the Justice and Equity Centre?
We agree with the colleagues who've already spoken that the criminal justice system is only a very, very narrow response to these issues. That's why, like them, we call for civil vilification protections to be expanded more generally. I don't have much more to add other than to say it would be remiss not to call for secure and sufficient funding for the Human Rights Commission to continue the anti-racism work into the future.
Yeah, thanks for pointing that out. And my last question is for you as well, Mr. Hussain. I think because you did mention this new offence in the bill of threatening force or violence. And I know that the Law Council has expressed concerns about this, in particular that the bill does not define force or violence. And I guess I just wanted to check in with you to see if you are at all concerned about this new offence being kind of insufficiently maybe balanced and not having a particular definition. And when I say imbalanced, I'm more concerned that, it could be misused against marginalized groups, as I think the Law Council has said. Is that something that concerns the Human Rights Law Centre?
The brief answer is no, given the package of laws, because the physical assault and threats of such in relation to individuals, I think, this relates to physical assault and threats of that, and it doesn't give any rise to any concerns from our end.
Okay, thank you very much. Thanks, Chair.
Thank you, Senator Faruqi. I just have a couple of questions with the time that we have remaining, and thank you for all of that. It's really helpful. Just to the Castine Centre for Human Rights Law, we've gone over this with a couple of other senators, but your submission refers to hate speech or vilification offences, and ensuring that they can't be used to suppress free speech. Obviously, a really important balance for the committee to get right. How does the bill find that balance in your view? I mean, you've said in your opening statement you think that the balance is there, and that there's not, I guess, a restriction of human rights in the sense that freedom of expression and freedom of speech fit under those categories. Some submissions argue that the bill impedes free speech. Is that misconstrued? And if the committee were to recommend a serious vilification offence, as recommended by some stakeholders, how should we balance that? Sorry, it's quite a long question, but an important one.
Thank you. Okay. I think you asked me three different things.
Yes.
Look, I think that the bill balances, finds the balance because it is not constraining the thing we describe as freedom of expression. It's constraining violent, hateful or extremist conduct or inciting that. And so the idea of the freedom of expression is not an absolute one. And so in the criminal law, criminalising certain extreme behaviour is not a question of expression of free speech. It's actually a question of the protection of the people who are being attacked by these threats or this extreme speech. So I don't think that I think the balance is met there. These offences have been put in place because there have been so few prosecutions, if any, successfully brought against people who are instigating hate or violence against various groups. And I don't imagine that there's going to be a floodgates approach to investigations as a consequence of this. There will be some more prosecutions, I imagine, but the balance also occurs in the prosecutorial authorities making the correct decisions and the police being able to investigate properly and take the correct evidence on what's happened. So it's not just resting on the words of the law itself, it's how they're going to operate in real life, which is why I initially said one of the important things that I think is missing is our understanding of how the police and the prosecutors actually go about making their decisions in prosecuting these kind of crimes, what kind of best practice is there for the evidence that they need to collect and they need to pull together in order to bring a case, and what the decision making is when they have to go ahead and decide, well, we're going to actually lay charges or not. And there's very, very little that we have on that existing now. So I suggest that what's needed is some serious criminological type of research done into what best practice is in other places and how we would deploy that in Australia, because I think it's a missing piece of the puzzle. In terms of an offence of extreme vilification, I think that is probably necessary here. It is apparent in the Victorian law, and that's a change that's been put in place, and it would support the protection of the people who are of this targeted hate and threatening speech. And I should just add, while I have the microphone, that we agree with the Equality and Justice Centre that the protected or the law should be protecting people with disability, and that's a omission of the current definitions to not include those people because they clearly are targeted in the ways that we heard this morning from the representative groups.
Thank you. I appreciate that. Some participants have recommended the introduction of serious vilification offence. We've gone through this with a number of other witnesses in previous panels. I'm just keen to hear from other panel members or from the Castin Centre about why, what other particular models of an anti-vilification provision the committee could look to or consider as examples. That's for anyone that wants to jump in on anti-vilification.
I think the starting point, Senator, if I might, would be to look at the current Victorian laws and the ones that are forthcoming. As the Executive Council of Australian Jury and the Equality Australia submissions have suggested, that's probably the starting point, because a lot of work's been put into what that kind of offence would look like.
If I may add on that, I think when we're thinking about drafting anti-vilification laws more broadly, we need to consider the experiences of marginalised communities, Indigenous communities, and their experiences in terms of how those laws are practically enforced on the ground. I haven't seen the Victorian example, but that's what I would caution, the experiences of marginalised communities in those scenarios.
Okay. And maybe, sorry, Mr. Laurie.
So we obviously in our submission have called for the introduction of civil vilification protections across attributes. That could be modelled either on 18C of the Racial Discrimination Act or the provisions of a number of states and territories which already have vilification laws which cover a large number of groups across the community. We could provide on notice which of those is our preferred approach, but most of them share a lot of similarities in terms of how they regulate those types of conduct.
Okay, thank you. And this may be something that others can speak to as well. One of the when we're conducting these types of hearings, I think senators like Senator Scarr and I can almost picture the parliamentary debate that may occur when the bill is actually brought before Parliament. And I can foresee some opposition to the idea of anti-vilification being included on the basis that, look, states deal with that, so let's just let the states, sort it out. There's no need or point for the Commonwealth to also have an anti-vilification provision, and maybe that's one of the reasons why the bill doesn't go that far at this stage. What are some of the other examples, or what are some of the benefits of having a Commonwealth law, not necessarily duplicating, but complementing our states and territories when it comes to discrimination, protection of hate speech and those sorts of things?
Perhaps I can jump in there. I think one of the objectives of this law is to fill in the gaps where they may exist, because obviously there are differences between the way that the different states and territories are regulating discrimination. So while some states are quite advanced in the way that they're doing this, other states are less advanced. And what a law like this enables to happen is to make sure that marginalised people living across Australia in every state and territory are able to receive the same level of protection, that the level of protection that you get as a vulnerable individual isn't purely based on where you happen to live in the country.
So very good. So does anyone want to add to
that? Just to add to that, I guess we challenge the premise that civil vilification laws are up to the states and territories when we've had racial vilification provisions at Commonwealth level for almost 3 decades, and we think that that is a model that has operated effectively for that period. I agree with the previous speaker in that the Commonwealth does have a responsibility to step in to make sure that vulnerable groups are protected across the country. So choosing, for an example, the LGBTIQ community, while most states and territories have already protected LGBTIQ people or parts of the LGBTIQ community against vilification. Western Australia has not, South Australia has not. In New South Wales, it's only lesbian, gay and some trans people, while excluding others. So this is an opportunity to make sure that these types of vilification are covered nationwide, to allow people to seek redress nationwide.
Great, thank you. I'm just conscious of the time. I'm sorry. I know our next witnesses have joined us, so we're going to have to say thank you very much for your contributions and your submissions and for giving evidence today. Thank you very much, and for the work you do in our community. We appreciate it. Thank you, everyone. Now, the committee won't skip a beat, and we'll go straight to our next witness, who I think has joined us online. Thank you. Hi, how are you? I now welcome the via video conference representatives from the Executive Council of Australian Jury. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been given to you and is available from the Secretariat. For the Hansard record, though, can I ask you to please state your full names and the capacity in which you appear today?
Peter Wertheim, I'm the co-CEO of the Executive Council of Australian Jury.
And Simone Abel, and I'm the Head of Legal of the Executive Council of Australian Jury.
Okay, great. Now, it may be my IT, but yours is a little wobbly, so we'll let you know, I guess, between the Secretary who's in Canberra, me who's in Cairns, and where you're appearing from today, if we're having any IT issues. Sometimes it's easier, if we do have an issue with the video, if you switch the video off, but we'll still be able to hear you. But we should be able to battle through it. And very grateful for you appearing via video conference today for this hearing. We had originally had a different date, but we've got you here now, so that's fantastic. Do you want to make a brief opening statement before we go to questions, and then I'll hand over the call to other senators?
Thank you, Madam Chair. Just a very brief opening statement. And by the way, we can hear you loud and see you loud and clear. On the 9th of October 2023, 2 days after the worst massacre of Jews since the Holocaust and the well-documented systemic rapes of people in Israel by the terrorist organisation Hamas, protesters in the forecourt of the Sydney Opera House burned an Israeli flag and chanted "F the Jews," with a police investigation determining that "Where's the Jews" was also chanted. The incident shocked Australia and shocked the world. Yet nothing was done to bring those responsible to account. No one was prosecuted under any of the provisions of the Criminal Code or under any other law. Since that incident, there has been an unprecedented surge in public demonstrations promoting racial and religious hatred, setting Australian against Australian and community against community. We have seen self-described religious preachers spewing hate to their followers and online against the Jewish people and the LGBTIQ community, street and university protests displaying degrading and dehumanising slogans, and many other unprecedented acts that have shattered the peace and harmony of our society. Again, none of these incidents has resulted in those responsible being prosecuted. The first question this inquiry needs to address is whether it believes that Australians will simply have to keep living with the sort of behaviour we witnessed at the forecourt of the Sydney Opera House last year. My community, and I believe the vast majority of Australians, are astonished that this question even needs to be asked. Of course, the answer should be a resounding no. To continue to tolerate such behaviour is a foolish and short-sighted approach. The lesson of history is that failure to act against racist and other hate speech invites an escalation to more aggressive behaviour and ultimately to violence and worse. If this inquiry concludes that the law is supposed to address the kind of social harm that was done at the Opera House last year, then the second question it needs to address is whether the bill now before us will achieve that purpose. On our analysis, as set out in our written submission, the answer to this question is also no. The recommendations we have made arise from the long experience of the Jewish community in Australia in witnessing the failure of anti-incitement laws and serious vilification laws that have been enacted federally and in the states and territories when applied in real cases, with only rare exceptions. We urge this inquiry not to allow itself to become yet another link in that long chain of failure. Thank you.
Thank you very much. And we've just clarified, it is a little patchy for me, but for everyone else it's fine. So we're just going to proceed, and I'll hand the call over to Senator Scarr. Thanks, Senator Scarr, for understanding. I might not have heard all of the opening statement, but we've obviously had these the Executive Council of Jury in front of us at other hearings. So I've got your written submission as well. Senator Scarr, are you ready to ask questions now?
Yes, I am. Yes, I am, Chair. Mr. Wertheim, can you hear me?
Perfectly.
Excellent. And Ms. Abel, good to see you again.
You too. Thanks, Senator Scarr.
Mr. Wertheim, I thank you for your opening statement. Thank you for your submission. And thank you for the passion underlying your opening statement, which I think is something which causes deep reflection in myself. One of the issues I'm grappling with, to be open with you, is are the laws as they're proposed to be amended advancing the cause at least somewhat? Therefore, because of the current situation, which you once again reminded this committee of, as it pertains to our Jewish community, is something which we need to at least make these changes in the shorter term, and then look at more substantive reform, perhaps in the longer term. How, from your perspective as a leader of the community, how do you see us balancing those issues? Because obviously just to expand on that point, lowering the bar to recklessness is obviously something which should theoretically, and I note it's theoretically, make it easier for prosecutions to be brought under these provisions to address the sort of conduct you outlined, as would removing the good faith defences. But from your perspective, there's still an obvious concern that still there are these barriers, the offences are too complicated. It's just going to be too difficult in practice for these offences to be mobilised, if I can put it that way, to address the despicable acts which we're seeing in the community today. How do you balance those competing concepts of, well, trying to improve what we have, as opposed to making it best practice, if I can put it that way?
Thank you, Senator, and thank you for your question and the concern that you bring to this issue. We've had some discussions in the past about it, and I thank you for your interest. To summarise the position from our perspective, we think that these proposed changes in the bill are just tinkering around the edges of the current law and do not really grasp the nettle. And we've seen this sort of approach by other parliaments in relation to similar laws in the past. I'll give you one example very quickly. In New South Wales, there used to be a provision called Section 20D for David of the Anti-Discrimination Act, which dealt supposedly with serious vilification. It was on the statute books for decades. Not a single prosecution was ever brought under it. In 2013, there was a parliamentary inquiry into that particular provision. It recommended some procedural changes and some changes around the edges of the provision, but didn't grasp the nettle. And in the end, 5 years later, the Parliament was compelled under the pressure of circumstances to scrap that law entirely and to come up with a new one, which has its own problems, by the way, but that's another story. So the difficulty we have with the current law, and we've set out our reasons at some length in the submission, is that it doesn't overcome the sources of the difficulties that prosecutors have had in practice in applying the law. And that includes applying the law to the Opera House forecourt situation and other situations. One of the principal obstacles is the use of the word incite, which has a complex meaning at the best of times in the eyes of the law, and a very almost impossible to enforce meaning when it comes to the criminal law, where the evidentiary standard is beyond reasonable doubt. So that has proven to be an obstacle where a prosecutor needs to prove that a particular action involved incitement with intent, urging people to a particular course of action. And as we said in the submission, and as this Senate found in 2014 in connection with its inquiry into terrorist-motivated violence, language is much more subtle than that. It does not lend itself neatly to that kind of paradigm. And so we have urged that the Parliament look at other words that have been used, for example, with regard to urging of terrorism offences, where the word advocate or promote or some similar verb is used, or a series of verbs, which is more realistic in the current circumstances and which has better prospects of a prosecutor in an appropriate case securing a conviction. And of course, the other difficulty we have is the double mental element, which is extraordinarily unusual in the criminal law. It's hard enough for a prosecutor to prove one mental element. To add another mental element to it seems to be counterintuitive. And I would say that most Australians would think that if somebody intentionally or recklessly, without regard to consequence, promotes or advocates hatred or especially violence against another group of people on the basis of race, religion, or other attributes, that is already a criminal offence in their minds, and they'd be astonished to find that that's not the case.
Do you know the background to this second element? So I've doing a deep dive into these provisions, and as you say, it's a curiously drafted provision, because you've got this double mental element. First, the first person urging another person to use force or violence, intentionally urging another person or group to use force or violence or recklessly, but then the first person does so intending or reckless as to whether or not force or violence will occur. What's the second element trying to get at? Because like you, I'm looking at this and thinking, well, if you're recklessly urging, or even using your words, promoting, advocating, or glorifying the use of force or violence, what more do you need? Surely that's clearly a hate crime. It's clearly against the public good. It's clearly is posing a risk to groups in our community. It's clearly unacceptable. It's clearly connected with force or violence. So it can't be defended as any form of freedom of speech that is recognised as being legitimate. What's the purpose of the second mental element? Do you know what the background is to that?
I believe I do. You have to go back to the introduction of sections 80.2a and 80.2b of the Criminal Code in 2010. That was preceded by a parliamentary inquiry. It was also preceded by an inquiry by the Australian Law Reform Commission. And the Australian Law Reform Commission, not unnaturally, and this is not a criticism, but it takes an ultra-civil libertarian view of these sorts of issues. And I think this is the legislation that ensued, the legislation we have now, which doesn't work, is a consequence of that approach, where an ultra-civil libertarian approach has been taken in the abstract without regard to the real-life situations in which these sorts of events occur. And the Australian Law Reform Commission recommended that second mental element. But just pausing to think about it for a minute, taking the current legislation at face value, imagine you have a situation where a prosecutor actually proves to the criminal standard that a perpetrator or an alleged perpetrator intentionally has incited violence against a person or group on the basis of their race, and has also proved beyond reasonable doubt that the perpetrator intended that violence would occur. In what universe is it possible to have that confluence of intentions, and yet the perpetrator is somehow acting in good faith and can avail themselves of a defence under Section 80.3? It just doesn't make sense. I've never yet spoken to a lawyer who says it does make sense. And so this is the legislation we have now is a result of that flawed approach.
So one of the obvious issues that it seems to me arises from this, and I'm beyond the good faith defence, right? I understand the argument that's being made in relation to good faith defence, subject to one point which I'm going to raise with you on a subsequent question. But that's clear to me. But it would seem if you're going to have this torturous process of having double intention, that someone who faces a prosecution under these offences can simply say, the way the legislation's drafted at the moment, that, oh, I might have said that, but of course I was carried away with my rhetoric, I was emotional, I misspoke, et cetera, and then it comes down to a state of mind issue, and you can see the complication in trying to actually bring a prosecution under the existing offence. Is that the concern? One of the concerns?
Well, it is, but the onus is on the prosecutor to prove the intention. And so if somebody is just venting, as they do, then it's arguable that the requisite level of intent or even recklessness may not have been present. Certainly the intention was not present. Recklessness is a bit more tricky because, as we know, the standard of reckless disregard for the consequences is it's above mere negligence, it's above mere inadvertence, but it's just short of intention. And it's a difficult one to define even in the abstract, let alone to apply in real life situations.
Yeah. Okay. The Australian Human Rights Commission has proposed some words. Have you had a chance to have a look at their submission?
I regret that I have not.
That's okay.
I'm happy to do so.
And I suspect I know what your reaction is going to be, but they're proposing words that they say are consistent with something the AHRC proposed. So if they're saying, look, the good faith defences drop away, but you still need something which looks at context, and they're proposing that consideration should be given of the context in which the conduct occurred, including whether or not it was part of some artistic work or genuine academic, artistic or scientific purpose, genuine purpose in the public interest, connection with an industrial dispute, the dissemination of news or current affairs. Can I ask you to take that on notice? Interested in any initial view you've got, but I suspect I know what it is. But if you could take that on notice and just give us a formal response to that, but whatever you'd like to offer now.
Look, I'm happy to deal with it now, and if you think it needs a further response, I'm happy to put that in writing. But essentially, as we've argued for this inquiry and to many previous inquiries about this, where there is a genuine academic or artistic or intellectual purpose, the requisite intent can't be established in the first place. The guilty mind is not there. They are, I mean, if the purpose is to give artistic expression to a particular theme or to explore an academic situation, a historical situation, for example, and understand how racism has ruined societies and led to genocides and crimes against humanity in the past, the requisite intent is not there. And I would also add that the standard of recklessness could not be met either. No prosecutor would take on a case like that in those circumstances. So I just think it's a non-issue because you don't get to first base with the elements of the offence that a prosecutor has to prove from the outset. The first point you raised about context, I think is already inherent in the law in any event, but I would have no objection to making it explicit. A court is obliged to look at the totality of the circumstances of an alleged offence in coming to its conclusions. You cannot judge a person's intentions without looking at the full context, and that would include not just the audience to whom the words are addressed, but what else was going on in society at the time, and perhaps a lot of other things as well. So I think that's already there in the law. I think that's what courts do as a matter of course in any event. But if it's a matter of making that explicit and that gives some comfort to people, I have no problem with that. And if you're looking for a halfway house, and this is not in our submission, but I'll put this on the table. If the concern is that innocent people might be inadvertently caught up in a law that sets the bar too low, why not, at least as a first step, use the words that we're proposing, advocate, promote, glorify, and restrict it just to intention, not to recklessness, and get rid of the second intentional element and get rid of the defence. Now, to me, that might work, and it might carry with it the realistic possibility that a prosecutor in the Opera House forecourt type situation could get a conviction.
Yeah. So, from your perspective, if you drop that second element of the second limb, if you like, of the mental element, and changed the words to refer to promotes, advocates, or glorifies, which is a formulation used in other contexts, that could actually provide a tighter definition to capture the concern about conduct, yeah?
Correct. In other words, you broaden the scope of the actual action you're seeking to capture, but narrow the scope on the intentional element, on the mental element to intention.
Yeah, okay. I see that. I see the logic of that.
Mariska, I'm conscious it's only yourself and myself asking questions on this panel, but I do have a series of questions I need to put as well. If you've got one or two more questions, and then possibly I could share the call, and then I can come back to you if we've got more time at the end.
Okay. Well, I might, Chair, I might just raise two quick issues, and I'll raise them in the one question to just make it as easy as possible to make sure you've got the opportunity to ask your question. So some previous witnesses from Equality Australia raised an issue around expanding the scope of the offence to include threats of damage against property owned by people who have the attribute. So it might be a business premises, it might be, we've seen an awful despicable acts in the eastern suburbs of Sydney recently. So interested in your view with respect to that it's a manifestation of a hate crime which is occurring today. We're seeing it today. And secondly, potentially expanding the scope of the offence to include people who are providing support to a community or associated with the community, so they might not have the particular attribute themselves, but it might be, say, a leader who's giving support to the community and is receiving threats because they're giving that support. It might be someone who's potentially hosting an event for the community, receiving threats of violence or force because they're hosting that event. So interested in your views on those two issues, and also feel free to take on notice if you'd like some chance to reflect.
Oh, I don't need to reflect on that. I agree with them both. We have a almost an identical position on these issues to Equality Australia. I've had discussions with their principal officers over it, and I think those two suggestions are very valid, and we would support them.
Okay, thank you.
Thanks, Senator Scarr. I really appreciate it, and thank you for your time today. Look, I can't speak for the Attorney General. I wouldn't attempt to, but I think our committee has had a strong reputation of making really worthwhile recommendations that are taken on board by the government. So I am really keen to understand the elements of the bill. I understand you support the bill in the way that it's put, but there's an extension or you'd like the bill to go a bit further. And that's
a lot further.
Yeah, and that's really of interest of me. And I hope, I hope that's something that we can get sort of broad support around for if there is a view that needs to go further, that we can get, all sides of the parliament on board with that as well. So my questions are going to sort of focus on that. Before I go to that, though, I know that you speak about this publicly all the time, but just for the purpose of our committee, I wanted to get some comments from you about the escalation you referred to in your opening statement. I'm not sure, do you know Rabbi Ari Rubin? He's sort of referred to as the Outback Rabbi. He covers from Cairns all the way to the Cape and Mackay, so he covers most of regional Queensland. And there was a really disturbing article on the weekend where Rabbi Ari spoke about the rise of anti-Semitism even in our regional communities. And there was a sort of disturbing quote that one of the members of his community said that he had told me that he is absolutely afraid to walk down the street with his kippah on. He definitely is now changing his habits and not going to be walking around visibly Jewish anymore. And I know this is well documented in the media, but I just thought for the purpose of this committee, if you could explain why we need these laws, but why the escalation towards violence is what we're seeing in the community at the moment.
Thank you. It's a great question. Well, look, we're very familiar with the article you quoted. In fact, the article cites our organisation and the report that we just published last week about the massive increase in the number of anti-Semitic incidents that have been reported in Australia over the last year. The Executive Council of Australian Jewry has been publishing these reports about anti-Semitic incidents since 1990. And they come out every year. They cover a particular 12-month period. And we have seen in the past increases and decreases. When there have been increases, they've been 20, 30, 40, 50% even. There have been some years where there have been decreases, but we have never in that 30-year period seen an increase in the number of reported anti-Semitic incidents of 316% as we saw over the last year. That's totally unprecedented. It's off the charts. And so the rabbi's concerns are well-founded. They are supported by statistics. We don't claim to be perfect in our recording, but I think we do a pretty good job, and our statistics have been relied on and cited many, many times by this Parliament, by governments, by human rights organisations and the media. So we're quite certain that the statistics that we published recently provide a fair longitudinal comparison to what has happened in the past. And what we're seeing is very, very concerning. And we also know from other studies that have been done by Monash University, among others, that the number of reported anti-Semitic incidents is understated severely. So, we're seeing situations now where people can't, like a rabbi, cannot walk down the street safely wearing a religious head covering. Jewish school children who go to a Jewish day school are afraid to wear their uniforms on public transport lest they be abused, where people have lost jobs because of doxing, or lost their businesses because of that, where there has been exclusion of Jewish artists in the arts and culture space, and of course the university encampments and the treatment of Jewish university students and staff, which has been the subject of another inquiry of this Parliament, well, by your committee and more recently by the Parliamentary Joint Committee on Human Rights. So we're not making this up. This is a real and empirically verifiable phenomenon.
And I guess the reason, sorry to cut you off, I guess the reason I had given that example, there were some other examples in that article, but of course you've provided some and you've spoken in your opening statement, which I didn't get all of it because of my IT issue. But what I was really interested in understanding is the recommendations that you've made to the committee, particularly around a serious vilification offence, and that any such offence not contain a good faith defence. What are some of the cases of anti-Semitism that would be covered by the proposed amendments to the bill? So I guess we can have a very a legalistic debate about that, but for a practical point of view, so that senators on the committee, but other members of the public can understand, what are the things that are happening at the moment that you'd like to see covered by proposed amendments to this bill?
Okay, well, at the risk of repeating something I said in the opening statement,
I'm sorry, I didn't hear
now.
But...
Yeah, so, I mean, we've seen, for example, self-described religious preachers addressing their followers and going online with some extremely graphic anti-Semitic statements, calling Jews vile, despicable people, buying into classical anti-Semitic tropes about Jews controlling the world's media and the banks. I mean, I can give you a compendium, if you like, of tropes.
You can provide some on notice if that's easier.
And we speak also about, in our submission, we speak about this one example where the language that was used was actually the final solution. So, you know, where a preacher stood up and spoke about the Ummah and a spark to the final solution. Those words obviously have a particular meaning to the Jewish community, because that was what Hitler referred to as you know, the extermination of the Jews, the final solution.
And interestingly, you know, when a member of Parliament used that expression some years ago in connection with immigration law, I mean, it caused a huge furore, and rightly so, because it's not just a meaning that is conveyed to the Jewish community. I think it's now entered common parlance as well. Yeah. And I mean, this is the sort of speech that, if it's left unchecked, can create a permissive atmosphere in which people feel emboldened to ratchet up their level of hatred to further an even more extreme speech, and then ultimately into acts of violence, as we have recently witnessed, and which Senator Scarr alluded to a moment ago.
Yeah. And just to build on that, you know, a lot of the time the language is very coded, but it has specific meaning in different religious contexts. So, for example, you know, in some religions, being a thief might mean that you have your arm amputated. So obviously when you hear public language about Jews being thieves or Jews stealing land, you know, that may potentially have implications in terms of urging some kind of violent action. So the language can be coded and subtle perhaps to members of the general public, but it's certainly not subtle to the audiences that it's reaching who have a shared understanding of what that language means. And we've seen this in many contexts.
And is that why you said that there's an underreporting of anti-Semitic incidents? Is that because some people don't quite understand the intention or the maybe the meaning behind some of the references? There's a specific example that I won't go into because I don't want to interfere with investigations. But where I'm aware of people cleaning off graffiti, not knowing that it was anti-Semitic before they took a photo of it to record it. But is that why that is sort of underreported at the moment?
I think the reason that Jewish people don't report every anti-Semitic incident that they experience or witness is because, firstly, they don't believe the law can deal with it effectively.
Yeah.
And that's what we're talking about today. And secondly, they don't want to become personally involved in having to become a police witness or become involved in some legal proceeding unless there's some reasonable certainty of a successful outcome, and they just don't have that confidence.
This we spoke to the Australian Human Rights Commission earlier today, and they spoke about these types of laws doing two things: sending a message to the community about appropriate behaviour and what is criminal and non-criminal behaviour, but also to prevent that escalation to the next level of violence, hopefully. You talk about, you've spoken with Senator Scarr in quite some detail about the lowering of the intention threshold that's in this bill and recommending removing the second element of reckless that force or violence will occur from the offence. Why do you think it's important to have that lower threshold? For me, I can see in incidents where there is that escalation, and I think that there is an argument to be made that we stopping it at that level before it gets to the next element is an important thing to do, but I'm really keen to hear your views.
So what I was proposing to Senator Scarr as a kind of compromise that this committee might look at seriously, and one which I believe might be more palatable to those who are primarily concerned with civil rights, is one where there's a lowering of the bar or a widening of the scope, I would prefer to call it, when it comes to the range of conduct that is caught, but a raising of the bar when it comes to the mental element. So that the mental element is just intention, not recklessness. And I've had conversations with colleagues in other faith communities who are particularly concerned that ministers of religion in the course of making an ordinary sermon might be quoting some religious scripture or what have you, and might be inadvertently caught by such a provision. And I said, but in those cases, you would never say that the minister of religion intended to promote, advocate, or glorify hatred or violence against another group on the basis of their race or religion or even their sexual orientation. And they, the conversations I've had, everyone's agreed with that. No, they would never have intended that to be the case. So if intention is the mental element, it might possibly give some comfort to those who are worried about the unintended consequences of such a provision.
Thank you. I put this question to other witnesses, and I thought I might ask you as well. One of the points of opposition to the Commonwealth introducing or establishing an anti-vilification provision might be that, look, the states and territories deal with that, let them be the ones that police that sort of thing. the Commonwealth doesn't need to duplicate those types of laws. The Attorney General said, I think in his second reading speech, that actually this is intended to fill in some of the gaps that exist. What about the gaps in anti-vilification law? Is there a benefit to the Commonwealth pushing that forward?
Yes, definitely. I mean, we are one country. It is a good idea generally to have the same rules apply to everybody rather than have a different regime apply in different states. We already have a Commonwealth law against racial vilification at the civil level in the form of Part 2A of the Racial Discrimination Act. It seems to me that there's no good reason not to have a uniform criminal law across Australia about that, but certainly a federal law that will complement state and territory laws and ensure that whatever gaps there are in those state and territory laws are filled by having an appropriate law that covers the whole Commonwealth.
Okay, I'll hand back to Senator Scarr if he has any other questions. One last thing just to get your view on. I asked the Australian Human Rights Commission if a threat of violence could ever be made in good faith. I think the pretty obvious answer was no, but you know, your submission notes removing the good faith defence for existing offences is a good thing to do. Can you just expand on the reasons why that defence is inappropriate?
Well, I think you pointed the way already, Senator, in your question, and I respectfully adopt what you just said. If a person intentionally, and we would say even recklessly, promotes, advocates or glorifies violence against other people on the basis of their race or religion, sexual orientation and other attributes, it seems to me that that mental state of intention or recklessness, reckless disregard for consequence, is incompatible with the very idea of good faith. The urging or promotion of violence by one Australian against another simply on the basis of a personal attribute is the antithesis of good faith, we would say, especially in a democratic country.
Yeah. Senator Scarr, do you have any other final questions? I know we've got a few more minutes and I did want to hand the call back to you if you had time.
Just one further matter to tease out, if I could, Chair.
Of course.
And that is this, and again, this is I must say, I find these offences just so complicated, and they're like a cryptic crossword puzzle in some respects, right? And I was never good at cryptic crossword puzzles. This concept in the new offences that it's an offence if the person threatens to use force or violence against a group. The targeted group is distinguished by one of the relevant attributes. And then the third element is a reasonable member of the targeted group would fear that the threat will be carried out. And I'm trying to work out what that third limb adds. Now, if and why it's necessary. So if someone actually threatens to use force or violence, I would have thought on face value that should be considered if you prove the relevant intention, that should meet the threshold. Why do you have to consider whether or not a reasonable member of the targeted group would fear that the threat will be carried out? Why put the onus on the prosecution to prove that someone who's a member of the targeted group would, listening to the words, think that person has the capacity to do it, or doesn't have the capacity to do it, or will do it, or won't do it? So I'm interested in your thoughts with respect to the how that may be appropriately addressed to take into account that concern.
Well, that's the problem with threats of violence. You don't know whether they're likely to occur or not. You're forever looking over your shoulder and having to worry about it. And no citizen should have to put up with that. It's the job of government to protect us from that sort of situation. And so it seems to me to be just a drafting quirk that has been added to that particular provision to maintain some sort of symmetry with the current provisions, which, for the reasons we've been discussing, don't work. I think it's just an extra requirement that has been put in there to satisfy some abstract civil libertarian principle without regard to the real world consequences.
Well, I'm trying to even understand what the abstract civil liberties principle is as someone who cares about civil liberties and freedom of speech, because if you actually threaten to use force or violence against a member of a particular group, well,
that should be
that's
enough.
what you've done. I'm not sure why we need to search for something else. Threatening the use of force or violence against someone is unacceptable.
And that's why, I mean, that's been the problem with these laws. They're Clayton's laws. They're laws against incitement to racial and religious hatred that you have when you don't really have a law, because they've never been used. I don't believe there's ever been a prosecution, certainly not a conviction. And the provisions that have been put to us in this bill, in my view, are unlikely to alter that situation in the future.
So, as I understand it, Mr. Wertheim, one of the proposals you make in relation to that subsection C, which is in both 80.2BA1 and 2, is that C, to the extent it's needed, could be converted into a defence, such that it might provide an avenue for someone to say, well, no reasonable person would think when I said that I was saying anything other than some sort of high-blown rhetoric, which I was never going to act on. Is it something which, if it is to be included, it's more appropriate to be included as a defence, and then put the onus on the person who's actually threatened to use violence to actually demonstrate that it was something which no reasonable member of the targeted group could interpret as a threat that might be carried out?
Yes, I believe so, and it would be a defence that would directly address the mental elements. So it's appropriate that the person who carries out the conduct is the one who has to explain the conduct.
Yeah. Just one last question, Chair. Sorry. I just want your views. There's this distinction in terms of penalty between a threat, if carried out, would threaten the peace, order and good government of the Commonwealth, and the lower offence, if I can put it that way, doesn't have that extra limb. Is there any law you're aware of as to how you discern whether or not an offence threatens the peace, order and good government of the Commonwealth?
I think that it goes back to the old sedition type offences in the Crimes Act, and it's just a recapitulation of those sorts of provisions. I don't think a lot of deep thought has been given to including those sorts of provisions in this legislation, and I don't think
the only thing I could think of was scale, right? So if something on a larger scale, or seeking to urge force or violence across a whole community as opposed to against an individual, that might be one of the elements you look at. But there's no other insight you can give us in that regard?
No, it would be something that would go to penalty rather than guilt or innocence.
Yeah. Okay. Thank you. Thank you, Chair. Sorry.
You're right.
Just can't hear you.
Sorry, I was just saying thank you very much, Senator Scarr, and thank you to you for your appearance today. We've gone a little bit over time, but we understand your very keen interest in these laws, and for Senator Scarr and I to make some good recommendations in regards to them. So we will endeavour to do that. Thank you very much. The committee is going to suspend for lunch, and I think we're due to come back at 10 past 1.
Thank you, Madam Chair.
Thank you.
Thank you, Senator.
Thank you.
Senator.
Thank you. The committee will now resume its hearing and welcome our next witness. I now welcome representatives from the Islamic Council of Victoria who are joining us via video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you to each to please state your full name and the capacity you are in which you appear today?
Yeah. My name is Mohammed Moideen. I'm the President of the Islamic Council of Victoria.
And my name is Bridget Mackenzie McCog. I'm the Policy and Advocacy Officer at the Islamic Council of Victoria.
Wonderful. Thank you very much for joining us today. Now, before we go to questions from senators, do you have a brief opening statement you'd like to make?
Yes, sir. Certainly, Senator Green. Shall I read it out to you? Yeah.
Yes, please. That would be great.
Thank you. Good afternoon, and thank you for the opportunity to address the committee on behalf of the Islamic Council of Victoria. My name is Mohammed Moideen, President of the ICV, and I'm joined by my colleague, Bridget Mackenzie, the Policy Officer. We are the peak representative body in the state of Victoria, representing over 270,000 Muslims and over 80 member societies with over 100 ethnic groups. Part of our role is to represent Victoria's Muslim community in policy matters and advocate for their rights and well-being. The rights and welfare of Muslims in Australia is undermined by a range of challenges, including increasing instances of Islamophobia. Islamophobia remains a deeply entrenched issue in Australia, with incidents surging in response to global events and divisive public discourse. For example, the following invasion of Gaza in 2023, reports to the Islamophobia Register Australia increased by a staggering of 1,200%. Such figures underscore the urgent need to robust legal protections against hate crimes. The ICV supports the Hate Crimes Bill intended to strengthen the protection against hate speech and violence targeting vulnerable groups. We welcome measures such as inclusion of threatening to force violence as distinct offences and removal of the good faith defence, as well as the lowering of fault threshold for relevance of offences. We maintain some reservations about how the legislation will be applied and enforced. This includes the risk of conflating religious or national symbols with hate symbols, which could exacerbate Islamophobia and undermine legitimate expressions of identity and political solidarity. We also maintain that legitimate religious teaching and political expressions must be protected, though we support outlawing the promotion of violence on the basis of protected attribute. We hope that this bill will actualize a suitable and effective balance between prohibiting hate speech and vilifying behavior and safeguarding freedom of expression. Thank you, and look forward to addressing your questions.
Thank you very much. I appreciate it. And we will go to questions. I'll hand the call to Senator Scarr to kick us off. Thank you.
Thank you, Chair, and thank you to the witnesses for appearing today. I want to give an opportunity to Ms Mackenzie if she would like to talk about the particular vulnerability of Muslim women who may be subject to an increased risk of hate crime due to dress and vulnerability in the community. So I thought I might just give you an opportunity to provide some comment to the committee with respect to the particular vulnerability that I've heard in my home state of Queensland of Muslim women who may be alone in public with their children and due to their dress are targeted for particular despicable acts of hate crime.
Yeah, so that's a very important point. I think most of the data and research on Islamophobia, particularly in Australia, highlights that women are the most vulnerable to hate crimes and to Islamophobic incidents. I think particularly when they are in public and when they're with children or alone. That is presumably due to the visibility of their identity as Muslim women. But there is also data that suggests that Muslim women of color are the most vulnerable. So women who are visibly Muslim and visibly not white in their ethnicity. The most recent report from the Islamophobia Register said that 78% of victims were Muslim women of color, and 70% of the perpetrators of Islamophobic incidents that they reported were men. Aside from that, previous reports have also noted the same trends. And experts who research Islamophobia tend to highlight that it is an intersectional problem. It's not an issue that's based exclusively on religious discrimination. It's an issue that's based on the intersectionality of different attributes, so commonly race or ethnicity and religion, as well as gender and religion.
Okay, thank you. Thank you very much. I just wanted to give you an opportunity to speak to that issue. President, when I go to the submission made by ICV, there are a number of particular recommendations which I wanted to draw out in the course of your appearance here today. The first is the concern about the application of the principle of recklessness. And as I understand your submission, the concern is that the relevant characteristics or definition of recklessness appears to be a subjective test, depending upon the viewpoint of the individual, whereas ICV considers it should be an objective test as to whether or not a reasonable person in the position of the accused would note the risks involved in their conduct. If I can ask you just to speak to that issue. Sorry, you might be on mute.
Sorry, I should be used to this. Sorry.
You're right.
Thank you, Senator. Thank you, Senator. And yes, the reason I think we believe in this, I think because it's very subjective and sometimes it could have a bias as well in how the law is applied. I think because for Muslims, sometimes reflecting on our religious tenets doesn't mean that we are promoting any form of violence against any parties. It means that the religion says something, and I think it's also to support and educate our community how best to work within the religious frame, but also follow the law of the land, because we know at the end of the day, the law of the land will prevail. And sometimes because these statements could be wrongly misconstrued and seen as possible hate crimes or hate-directed messages, this could be looked at in a point of view as recklessness as well. So I think it's important, when looking at the laws, I think to make sure that these issues are not looked at in that manner.
Yeah, so I understand the issue, and it's something I'm particularly mindful of, that we don't want to get the balance wrong in this regard. I note in page 7 of your submission, you say, or ICV submits, this is because a genuine religious practice or political expression should not involve calling for violence against a group or individual because of a protected attribute, and thus the actus reus of these offences would not be justified in this context. So I understand that point. And then you say, however, given the lowered fault element of the offences and the expanded list of protected attributes, we must emphasise that legitimate religious teachings or political opinion must never be criminalised, and that the offences must not cover the expression or teaching of religious belief, statements of political or other opinion, or legitimate criticism of an ideological or political group, but only conduct or speech that involves actively urging violence or force on the basis of a protected attribute. So is it from your perspective, President? Is it clear where the line is drawn in this regard? So we're very interested, and I'm sure all senators on this committee are very interested in making sure we're protecting the community from threats of violence, from people being subjected to despicable hate speech, etc. From your perspective, is it how do we draw the line in the right place? Where's the bright line, if I can put it that way, between what is acceptable conduct and what is unacceptable conduct? So we actually produce a law where the vast majority of Australians read the law and say, well, clearly that is something which is unacceptable, it breaches the criminal law, but this is something which is clearly not something which falls within the domain of a criminal offence. How do we get that balance right, President?
Thank you, Senator. I think it's very important to understand what the religious requirements are. And I think when things are taken out of context and sometimes quoted with just one sentence without looking at the overall aspect of the message that is being put out by the imams on Friday sermons or in a discourse, that's where I think the problem is. I think where people could misconstrue these as sentences promoting violence, whereas this could be talking about an edict that is in the faith, but really not breaking any law or not advocating for any violence against any group of people in any community. So I think it's very important, to always look at the overall message than just looking at what the sentence or one-liners that say.
So we've had a previous witness to this committee say that from their perspective, they would be happy not to have recklessness, so to take it back to intent, but instead of the offence using the words urging another person or a group to use force or violence, to actually look at the language of the offence in that regard and potentially use promotes, advocates or glorifies the use of force or violence. Is that from your perspective, and feel free to take this on notice, would that be a better way to achieve the balance, to actually make sure that the not going to the world of recklessness, but so it's got to be intent, but to lift it up? So we talk about promoting, advocating or glorifying the use of force or violence. Is that potentially a way to address this conundrum?
Yeah, I think certainly that would be a way, of addressing this issue. I think because it's all with what's in intent, and I think how it's perceived and how it's even interpreted. And because you'll find that lots of preachers and imams, when they do talk about it, they talk about it from a religious point of view, but always emphasize that life is important and the safety of every individual. It doesn't matter which religion or what race you come from. It is the safety of every individual that matters for us as Muslims.
Yeah. Okay.
I think, if I may add something, I think on that question, from the ICV's perspective, I guess in terms of anecdotal evidence or dealing with people in our Islamophobia support service who have experienced what may potentially amount to a hate crime under current laws, something that often dissuades people from going to police or from attempting to pursue a prosecution is having a high sort of evidentiary threshold, or having the perception that there isn't enough evidence that proves this was a hate crime, or they may be able to report a crime against them, but it won't be classified as a hate crime because it's obviously very difficult to prove someone's motivations or intentions in certain circumstances. I think it is definitely worth us giving more consideration to the proposal that you mentioned, but I think from our perspective, it is important to make that prosecution process easier for victims by lowering the fault threshold. I think we do, at a minimum, support lowering the threshold to recklessness. in the sense that it removes that barrier and it makes actually prosecuting offences under this legislation easier for victims.
Yeah, no, I appreciate that, and thank you for that. It's sort of, as I'm looking at this, there are so many different elements of these offences. You sort of look at, okay, well, if there's a concern that recklessness might inadvertently, unintentionally capture some conduct, is it possible for us to tweak something else, and then you don't need to lower that bar? So again, we heard evidence earlier today about instead of having two states of mind that needed to be proved, maybe there's only one state of mind that needs to be proved. You don't have to go the extra step. So it's trying to get the balance right, and that's why I'm so thankful that ICV's made their submission and their comments. So I find it very useful. I'd like to move then to the definition of hate symbols, and I can say to you that when this issue around the ISIS symbol emerged, there were a number of people across all parties, I think, who immediately saw the issue in terms of how to deal with the fact that the ISIS flag used a central tenet of the Islamic faith. It was something that was almost like a group reflection that, oh, how's that going to work? Which should maybe and should maybe provide some comfort. And I guess that's why I'm raising it. The process that we have as a parliament in terms of our committees, in terms of considering draft legislation, is intended to address those sorts of legitimate issues which might arise, to make sure that unintended circumstances don't arise where things are prohibited which shouldn't be prohibited, or lead to absurd outcomes. So, to what extent, President, does that give you comfort? That I know you've obviously got residual concerns, and you've given some examples with respect to the issue of these symbols, but to what extent do you get some comfort from the fact that the issues around the use of the words that are to the core of Islamic faith were intercepted, if you like, by the lawmakers, and it was recognised at a reasonably early stage that was going to be problematic? To what extent does that give you comfort?
Thank you. I think it gives us great comfort that the lawmakers do consider these aspects of it, I think especially in a multi-faith, multicultural society. And because the Shahada, that's our covenant with God, and that's what the symbol is. Unfortunately, it has been misused by some. So it was really comforting to know that the lawmakers have considered that. And I'll give you a good example. Like, for example, in Victoria, when initially they tried to ban the swastika, the swastika has a lot of religious symbols for other faiths, like the Buddhists, the Jains, and all that. And there are children who are called by the name swastika in the Hindu community. So I stepped in my other hats that I wear to say we need to look at it in more detail than just banning the swastika and identifying which aspect of it that you want banned. So, and then subsequent changes. So I think it's very important, I think, when looking at any banning of any religious symbols, to look at how it could affect another faith or another community as well, and the repercussions on that aspect as well. Yeah.
So I've in fact trying to discipline myself not to use the word swastika in this context at all now, but to use Hakenkreuz or crooked cross, which doesn't trip into those areas of people of Eastern faiths, Buddhist faith, etc. And but again, that was an example where this committee and other stakeholders recognised that issue, and the law was adjusted to make sure not to capture that legitimate religious use of the symbol. But there's also a concern you have, as I understand it, in relation to symbols that can potentially be confused with or associated with prohibited symbols. Could you expand upon that concern, please?
I think with the Muslim faith, I think we have very few symbols as such. But I think the symbols that are there, like, for example, the crescent people might have pendant with the crescent symbols or with even the Palestinian symbol of wearing the kafir. I think the kafir is looked as because for Muslims, the Al-Aqsa Mosque is the third holiest shrine for all Muslims. So it's more linking ourselves to one of our holiest cities and holy shrines and the people. I think so. Even looking at that and banning that wearing of the kafir, I think it should not be there. I think it goes against very fundamental issues of your right to be able to wear something that supports your thoughts and thinking, as long as it is not offensive to all people in general, I think.
I might leave it there. Thank you very much for that. That was very useful, Chair.
Thanks very much, Senator Scarr, and thank you for those answers to the question. I hopefully won't traverse the same issues as Senator Scarr, but I will put a couple of questions to you. I asked some of our previous witnesses who gave evidence of the types of the prevalence of this type of behaviour towards them and their communities about the escalation. And Ms. McKenzie, you spoke about that at the beginning, about the statistics that are really clear about the escalation that you've seen over the last sort of 12 to 18 months of these types of incidents. For the benefit of those listening, can you explain the prevalence of Islamophobia and how that if there has been an escalation recently?
Yeah, so I think for many years, Islamophobia has obviously been an issue faced by a lot of Muslims in Australia. That can be in terms of something like an actual hate crime, an assault, a threat, something like that, or in terms of a more subtle form of discrimination in like a workplace, a school, a university, something like that. I think the evidence that we have does point to an escalation, particularly within the last couple of years, and particularly it shows spikes when there have been, I guess, certain publicized events or certain media coverage. So one example of that is obviously since the invasion of Gaza in 2023, a lot of media rhetoric and political rhetoric surrounding that has coincided with spikes in Islamophobic incidents. So one prominent example is in relation to the protests and the student encampments that happened earlier this year. The Islamophobia Register noticed a spike in Islamophobic incidents that were reported on university campuses. So that included things like threats or physical instances, people being assaulted, people being spat on, as well as discrimination sort of between students within classes or within working groups and things like that. Another example is when the Bondi Junction attack happened earlier this year, there was some false reporting initially that that suggested the perpetrator of that was a Muslim or was an Islamist terrorist. Following that, the Islamophobia Register of Australia reported that they received 720% more reports of Islamophobia that week compared to an average week throughout the rest of the year.
Senator Green, can I say something?
Yes, of course you can.
Thank you. I think one of the key things, I travel right around Victoria and I meet many people of Muslim faith. I think one of the biggest issues we have today is Muslims have come to sort of take it for granted, to be yelled at, to be spat at, and to be, treated like something that they're not Australian citizens. And that has made them also not report many incidents to the police, because we have found that, and in Victoria we have made issue of this, that many issues reported are not acted upon or there's no feedback. So many Muslims have decided what's the point of reporting, and this is why we feel that there's under-reporting still taking place with regard to Islamophobia. And sadly, the Muslim community, especially our women, have taken it for granted that this is part of our normal life, which should not be. They should be able to go about freely walk the streets in their hijabs and their, their clothes without having to fear that somebody is going to target them.
Thank you. And the new offences created in this bill and the strengthening of existing offences by changing some of the defences that apply to them are designed to assist combating those high levels of Islamophobia and the promotion of violence against communities such as yours, but of course other communities as well. How do you think this bill assists in sending a message to the broad community about the tolerance for that sort of behaviour, the message that it sends to your community about being able to report those types of incidents, and I guess further to that, how do you think it will help protect your community if these sorts of things are criminalised?
I think there's been a lot of positive aspects to this, I think, because it gives people an opportunity and also a hope that things will change. I think we want the country to change, to be a better place for all people, all faiths, all communities. And I think such bills would help to a great extent alleviate that fear that is out there in the community. There's a lot of fear in the community at the moment that nothing has been done and nothing will be done. And so I think such laws would help create that. And also it'll send a message to those who are involved in such criminal acts to think twice before they start attacking vulnerable women. Because unfortunately, this is a coward's way out. They do not attack the men, they attack the women who are with their children, and we've seen many incidences of those reported as well. So this will give them some comfort, and this will also, I hope, make the law enforcement people to act. And given that the threshold is then easily, you can see that it's achieved. Because I'll give you a good example. When we were talking to the police told us that if there's no physical harm, then it's not an offense. So you can have a woman who's walking down the street, sees a person coming towards her. So she's going to think twice, flee or fight. Is this person come to talk to her or is this person come to attack her? So I think it's important to sort of build up that trust and confidence in people going forward, I think.
Yeah. And she feels the physical threat, even if there isn't one. There's a lot of women around the country that would understand that, but it would be so much more intensified for women of Islamic faith. I wanted to ask about political or religious expression, which is, of course, incredibly important. And the task that we have in this bill and the committee needs to consider is getting the balance right. So making sure that we can prohibit or criminalise behaviour that is, threatening violence, hatred, but also give people the opportunity to have political or religious views expressed. I was interested that your submission, you believe that the codified defence for political and religious expression, it's necessary, but certainly wouldn't cover, it's necessary and means that the bill doesn't extend to the expression of teaching or religious beliefs. I thought it was interesting that you said that, because violence and urging of violence is never part of genuine religious practice. But could you explain that a little bit more for the committee, that where you think the bill lands in terms of protecting religious freedom of expression, but also making sure that if there is those threats of violence, whether they're in a particular religious situation, that they're covered as well?
Thank you. I think when we talk about many faiths, many religions, I think we all have the do's and don'ts. And sometimes it's important not only for preachers, but also parents to be talking to their children about the do's and don'ts according to their faith. But none of them preach violence against any person or any individual as such. So I think, again, looking at any statement made by the clergy or any person, not in that just those words, but looking at it in the overall picture of what's being conveyed is very important, because that's where I think there's a difference between intent and expression of a religious edict or statement. So as long as we learn to understand that this aspect is considered, and I think, and the decision and the intent was never to promote violence against anyone. I think then you have a better understanding of how the faith works as well.
And that's why you advocate for reasonableness to be part of the element of the offence, that should be considered by courts if there was a consideration. Because if reasonableness is part of the fault element, then that would protect those situations. Is that right?
Yes, that's correct. Thank you.
Okay. And just one last question I have for you. I'm interested in, we've had a number of organisations of very diverse communities recommend to us that we should consider whether the law could be extended to cover a serious vilification offence. I was wondering if you have a view on that type of recommendation. It's come from all different parts of the community, suggesting that while this is an important bill that prevents the promotion of violence, that it doesn't, at the moment, it doesn't include a serious vilification offence, and yet we're seeing that type of vilification occur more and more in different communities across the country. And so we've been asked to consider that by other witnesses. I was wondering what your view was on that.
Thank you. I'll ask Bridget to, I think, speak to it. I think she's done a lot of research on it and has a
Yeah. And you've also got the bill in Victoria that's been, so that would be,
I'll be honest, it's not something I thought about within the scope of this legislation, but the ICV did support the recent changes to the legislation in Victoria. I think that a serious vilification offence is probably a good provision to add. I guess it's clear that these sorts of hate crimes are harmful and obviously not acceptable, even where it's not an active threat of violence or it's not explicitly saying that violence should be done against a protected group or against a protected community. I don't think, from the ICV's perspective, we would have many reservations about the introduction of a serious vilification offence, and I think it is something that we would support.
Thank you. If you want to add anything to that on notice as well, if you want to go back and send us some more information about it, given there is that Victorian experience, but it's a bit patchy across the other states. So it'd be good to know your views more broadly on that. That's all the questions that I have. Senator Scarr, did you have any other remaining topics you wanted to cover off?
I guess just one question I'm interested in, President, is in terms of, and to Ms Mackenzie, in terms of your communication with respect to relevant authorities about these issues, especially around symbols, potential misunderstandings, a lack of knowledge of the significance of and history of potential symbols, and you've given another example in your submission with respect to someone who had particular standing in terms of the Muslim faith and misinterpretation of that person or the reference. Are the lines of communication there for the community to in relation to federal authorities, the Department of Home Affairs, the Australian Federal Police, and also state authorities, so that you can easily resolve any issues of confusion, misunderstanding, particularly in a context where people may, out of ignorance, simply jump to conclusions which are wrong? How effective are the processes we actually have in place at this point in time to make sure that your voices are heard and misunderstandings are resolved as quickly as possible? Because I think in the current environment, that's of incredible importance.
Senator Scott, I wear many hats. I think I also am a VMC commissioner in Victoria, And I do travel around, and also we do engage with the federal police, with the local state police and all that. And one of the best examples I can give you is I go once in 3 weeks to the police academy and talk to the new recruits about the Muslim community and Muslim faith to give them a better understanding of how they should engage with the community. So we do a lot of those sessions with various communities. And we also engage with the state government and other authorities about how best you can engage in all spheres with the Muslim community. So it's an ongoing engagement that takes place. And I think we're quite happy with how we go about it. And I think it's been very proactive and receptive from the other side, all the law enforcement and state government areas as well.
Okay, thank you very much. Thank you, Chair.
Thank you very much, and thank you for taking the time to speak with the committee today. It's been really valuable, and thank you. Have a lovely day.
Yeah, thank you for having us as well.
Thank you. I believe that we have our next witnesses in the room, most of them anyway, so I'll invite them to come forward. I now welcome representatives from the Uniting Church in Australia, the Synod of Victoria and Tasmania, the Combined Church Leaders and Christian Schools Australia. Thank you for all being with us today. Thanks for making the journey to Canberra. I have to admit, after spending 2 weeks in there and a very long day on Thursday, I couldn't quite bring myself down to Canberra from Cairns, but we really do appreciate you being there. So I'll just get started in a moment. I'll let you get settled. Thanks for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? We can start at the end of the table if that's helpful.
Sorry?
That's fine, you start.
Yep. So Mike Southern, Executive Director of Freedom for Faith.
Bishop Michael Stead, the Chair of Freedom for Faith.
Dr Mark Zernzak, Senior Social Justice Advocate, Uniting Church in Australia, Synod of Victoria and Tasmania.
Dr Rachel Carling, Director of Public Policy, Christian Schools Australia.
Dr Brendan Long, Executive Officer, Christian Schools Australia.
Okay, wonderful. Thank you. Now, before we go to questions, can I ask whether you have a brief opening statement to make? I'm assuming maybe you all do, so we can take turns if that's helpful. We might start with the Uniting Church in Australia.
Thank you for the opportunity to appear before the committee. As per our submission, the Synod is supportive of this bill. We have understood that the bill aims to set a very high-level bar against expressions of hatred that have the intention or are reckless in regard to creating threats of force or violence against people. As a Christian church, we believe our role is to be expressions in the community of the love of God, and we find it difficult to understand circumstances in which any Christian would wish to be expressing hatred that causes harm to other people. When we looked at similar laws in other jurisdictions, we find that the prosecutions for these laws tend to be at a very high level. So they tend to involve very much threats of violence directly. Probably a very notable case in the US is that of Reverend Fred Phelps with the Westboro Baptist Church, who held a protest at the funeral of Matthew Snyder, who was a soldier killed in the US, and the Reverend Phelps' opposition to the US military was around their acceptance of people from the LGBTQI community. They attended the funeral holding up signs of "Thank God for 9/11, thank God for dead soldiers." That case was prosecuted, and the US courts upheld that was a legitimate expression of freedom, and there was no successful prosecution in that case. So it gives you a sense of, as we look at laws across globally, the prosecutions tend to be very much for very extreme behaviours in this space. We also have quite a bit of experience about the impacts that these expressions of hatred, for example, have on people with disabilities, and that was covered very well in the Royal Commission into the abuse and neglect of people with disabilities. That those expressions of hatred can cause people to live in fear, make them stay out of the community and affect their mental health further as a result of that. I'm happy to leave it there and open for questions.
Okay, wonderful. Thank you very much. Now, in my program, I've got the combined church leaders next, but I understand Reverend Steed and Mr. Southam, you're specifically representing Freedom for Faith today. Is that correct?
Freedom for Faith helped coordinate that submission,
wonderful.
And we were the contact point for that submission.
Okay, wonderful. That's why I'm referring to you as a different organisation.
Yes,
so I apologise for that, but thank you very much. Do you have an opening statement you'd like to make?
We don't have an opening statement except to say support of no person should be subjected to expressions of violence or desires for violence, but we are concerned about the possibility of scope creep in the definitions of harm in the legislation if harm is not very clearly defined, that the concepts of harm could keep expanding so that what is more ordinary Christian preaching, apart from the extreme example, could then eventually be encapsulated as being hate speech, which is defined as harmful. So that's what's covered in our submission too.
Okay, wonderful. Thank you very much. We'll definitely unpick that with you, but I'll go to Christian Schools Australia. Do you have an opening statement you'd like to make?
Yes, thank you very much.
Thank you.
Appreciate it. Thank you for the opportunity to come to this hearing today and represent Christian Schools Australia. We are, as we pointed out in our submission, a national body representing member schools, educating over 86,000 students and employing over 13,500 staff across 200 locations across Australia. Our schools operate as independent, locally governed religious organisations. As stated in our submission, our schools take a really strong stance against bullying, abuse, neglect and violence of any kind. The idea of hate does not fit within our biblical worldview. Our schools hold themselves to a high standard, as demonstrated in ministry agreements signed by staff, codes of conduct signed by students and strong policies signed off by local boards and enforced within our schools. These policies cover bullying, the formation of character and a strong alignment to the biblical worldview, where again I'll state very clearly that the idea of hate has no place. Our concerns around this bill are shared with our colleagues from Freedom for Faith that centre around the overall effect of the bills in terms of subject creep and the effect of that on our member schools and perhaps the unintended consequences that are within the drafting of this bill. Specifically, as we pointed out in our submission, the bill lowers the bar of existing and proposed new offences, with the definition of force or violence expanded to include psychological harm or recklessness, which is a subjective test open to broad interpretation. The subjective nature of this lowered bar of offence appears to introduce a possibility that claims of psychological harm can arise from instances of robust debate and discussion, which you will find within all education institutions, not just within our schools. The bill as it stands in our interpretation risks encompassing legitimate debate and disagreement and risk covering the biblical teachings around, for example, sexuality and gender. This to us represents an unacceptable limitation on the fundamental human freedoms of speech, thought and religion. Our solution, as we pointed out in our submission, is simply to ask for sections 80.2a, B, BA and BB to clarify or refer to physical force or violence only. This would limit the offences to the objective measure of physical harm and the comparatively objective measure of fear of physical harm, and it would avoid applying serious criminal sanctions to the far more subjective measures of psychological harm or fear of psychological harm. Thank you.
Thanks very much. Senator Scott, I'll go to you first and then I'll have some questions after that. Thank you.
Thank you, Chair, and thank you to all the witnesses for appearing today. I'd just like, in the first instance, to try and get a deeper understanding of the concern around this issue of psychological harm. What are the things in the bill which, in particular, provide concern that the scope of the bill could extend to persons arguing that because a faith is being taught or worship is occurring in accordance with whatever the faith's religious tenets are, that would bring that fact itself, with nothing more, would trigger, and I would have thought it is an unintended consequence, that the provisions would extend to the mere fact that there's that teaching in good faith extend to amounting to a threat of force or violence because there's psychological harm. What are the particular aspects of the section which are giving rise to that concern, which is held obviously by a number of faith leaders?
I'd be happy to answer that. The particular concern arises from the fact that the word violence is not defined. Violence is equated with harm in other pieces of legislation, and the fact that there is not a limitation on what forms of violence are in view here opens the possibility that it could not just be physical violence but also psychological violence. So our concern is that the courts will interpret that widely and say this act, which was perceived to be harmful by a group of people, which was so it caused harm and therefore it is violence and therefore it comes within the ambit of the section. That's the number of our concern is that violence is equated to harm in other places. Harm includes psychological harm. Some people assert, we would not agree with this, but some people would assert that the mere teaching of Christian doctrine is harmful to some groups.
Yeah. So, do you have examples of violence being interpreted, the use of the term violence being interpreted as meaning harm, and harm being interpreted as including psychological harm to help us better understand that concern?
Yes, thank you. If I can draw your attention to paragraph 11 in our combined submission, we refer to a judgment in the New South Wales Court of Criminal Appeal, which expands the category of actual bodily harm in New South Wales law to include psychological harm, injured psychologically in a very serious way, which had to do with some what I'd characterise as verbal abuse was the kind of action that was in view here in this judgment. But there the courts have expanded the idea of actual bodily harm used to mean physical harm, but there, as I said, there's examples where that has now been extended. Actual bodily harm includes psychological harm. Okay, and just in that, do you have any, and maybe you can, I can have a look at the case myself, but yep. I'm interested just in terms of the fact situation in that case, just have a better appreciation of what actually occurred in that case. Do you have any further background on that with you? I can't recall, and I'd prefer not to.
No, that's okay. Yeah. No, I'll have a look. So one of the ways in which you've proposed that the issue be addressed, as I understand it, is to explicitly state that the concern of the provisions is physical violence. Correct. Is there another way? So I understand that argument, and that's certainly something which I'll be putting to the Attorney General's Department to flush this issue out. Is there another way in which context would be considered by both the police, the prosecuting authority, the courts, in terms of how these provisions are applied, because clearly there needs to be an intent behind the Act, which is of a certain type with respect to committing violence, if you like, on a particular person as a member of a group. And that doesn't give you the comfort that what we're talking about here, or what your concern is in relation to teachings in good faith of religious tenets, and we've heard from the Islamic Council of Victoria, they've raised a similar concern about not wanting simple teaching of their faith inadvertently triggering the application of provisions like this. That doesn't give you sufficient comfort that someone would say, well, sorry, this faith, whatever the faith is simply teaching the tenets of their faith. There's no incitement to anyone to actually commit violence against anyone, or there's no threat against anyone. That doesn't provide sufficient comfort.
If I could contribute, Senator, I don't think so. I think there is still the risk that, say, a principal in a Christian school would find themselves potentially, being accused of causing psychological harm by presenting a biblical view of teaching in the context of a stakeholder, a parent, or even a student, where there's who has a non-biblical sexual expression in their lives. So I think that all we're seeking is that clarity, and we're arguing the clarity isn't present in the current wording, and the definition of harm being linked to physical harm, as is stated in other sections of the Criminal Code, it would be an easy solution. But if I could also point to the evidence of the Executive Council of Australian Jury today, Senators. So there was an interesting proposition put by them, which I think Christian Schools Australia would agree with, even though for different reasons. And their argument was, as I recall watching it, that they would, referring to the clause, like clause 3, that changes the criminal test from intention to acting recklessly. They were saying, well, they could live with without the recklessness test and maintaining the intention test, as long as there were additional words added, and those words were to advance and to promote. Essentially, they had another word too, which I couldn't pick up from the
glorify.
Glorify. I thought it was that, but I didn't. Yeah. No, that would. I think that would a form of words like that would help. I think with address our concerns as well.
Okay, so actually tightening, if I can put it this way, tightening the words of the offence, but lifting the bar above recklessness would give a degree of comfort, would it?
Yes, it's the combination of recklessness and then uncertainty as to what harm is. How can you know that you're reckless about causing harm if we don't have a precise definition of what that harm is? It's the two put together which is really causing our problem.
Yeah, I understand. Have any of the witnesses had an opportunity to have a look at the Australian Human Rights Commission submission or to listen to the testimony of Commissioner Finlay earlier today?
No. We tuned in after that, Senator. Sorry, I was driving down.
No, that's okay. So I'm happy for you to take this on notice, but Commissioner Finlay proposed some words of clarification to be added that would require consideration of the context in which conduct occurs and the relevant limbs of the context. And happy for you to take this on notice and provide a considered response. But the elements of the context which were listed included, which the court would need to consider, would include one limb associated with whether or not it's artistic work, another one whether or not it's done for research or something or some other genuine purpose in the public interest. Third, whether or not something in connection with an industrial dispute. And fourth, dissemination of news or current affairs. And the argument was that might be a way to provide some additional comfort that conduct which I believe it's not intended to be captured would be to remove any doubt in that regard. So I'd be very keen to hear your views with respect to that. But perhaps also, if at the same time you could provide some additional views to the extent you can in terms of Mr. Wertheim's submission from the Executive Council of Australian Jewry, and whether or not you, because I think this is important we get this right, whether or not that would be a way to close out your concerns in that respect. I would like to give an opportunity to our witness from the Uniting Church, who we see quite often before this committee, and we always appreciate the submissions we receive from you, Mr. Zernsak. I'll give you an opportunity to give any comments you have in relation to the discussion we've just had around making sure that there are no unintended consequences flowing from the adoption of a recklessness standard in the context of people of faith preaching or giving teaching in relation to the tenets of their faith.
I think in this case, because the test in the legislation is hatred, it's a very high, so therefore we were completely comfortable with reckless, because it's hard to imagine expressing hatred unintentionally or legitimately. I mean, the reason for removing the in good faith was very much going to the heart of that notion that if we're talking about hatred, this is not, expressing merely a view on a matter, and therefore don't agree with the Human Rights Commission about the need to have those tests. I mean, the suggestion that it would be acceptable to promote hatred, putting forward force and physical violence in an industrial dispute strikes me as a rather odd view to be enhancing, and would be interested to, for the Human Rights Commission to perhaps articulate under what circumstance they kind of think that might be a legitimate way that people could express hatred. We probably don't share the concerns around, the impact of psychological harm, like if our reading of the legislation was it did only apply to physical harm, but there are very serious psychological harms, and we do see this again, with the disability community. Expression of stigma, prejudice, even discrimination, which this legislation doesn't go to, but even just those kind of factors can cause mental health issues. They can cause PTSD type symptoms. They can lead people to consider self-harm and to suicidal ideation, and there is research covering that. We can send you paper references on that. There's also been some work by Rachel West and Belinda Johnson that does cover hate speech against people with disabilities. But again, when we've looked at other jurisdictions, we couldn't find really examples of where hate speech in itself leads to prosecutions. If I look on the US Department of Justice website where it lists all the prosecutions, they generally have to meet a very high threshold. They're normally for death threats in that case. The UK data is kind of interesting. They have very high numbers of hate crimes being reported to police, but they don't provide a lot of detail about the cases. So you end up with, I guess the closest to this kind of legislation is offences dealing with stalking and harassment offences in relation to hate crimes. And typically, depending on the characteristic, it's somewhere between 20% up to a third of hate crimes relate to those stalking and harassment offences. But again, they're different to in this case, expressions of hate speech. So probably don't share the concerns, just looking at how we think law enforcement will actually use this law, and probably more likely, as we express in our submission, it's not likely to be used very much at all, and if it is, it's going to be at the very extreme end.
Do you have and I was thinking when you gave that example of the protesters outside the funeral of the deceased serviceman, in the US, which I can remember that occurring at the time. I wish I didn't remember it, but it was quite vile and outrageous. And I was thinking about the words that appeared on their placards: "Thank God for 9/11, thank God for dead soldiers." And then that immediately triggered the proposal from the Executive Council of Australian Jury that they would get more comfort if the words of the offence were changed from urges another person or a group to use force or violence to promotes, advocates or glorifies the use of force or violence against another person or a group, which obviously includes conduct which might occur after the event, which can have odious ramifications, I would have thought. Do you have any views in that regard with respect to the alternative language which the Executive Council of Australian Jury is proposing? And happy for you to take it on notice.
Yeah, look, a war, that'd be fine, but I mean, I think, again, I think they are doing a trade-off where they're sort of saying, well, if you broaden it and then you make the test intention rather than mere reckless, I think there's an advantage in the current drafting in that because it is about expression of hate, reckless doesn't bother us being in that space. I mean, and I think the other point we'd make here, I mean, when we start talking about vilification laws, and I know you've questioned a number of other witnesses on that, I mean, part of the trade-off here is also the level of penalty and sanction that applies. So obviously something that's very extreme, which I think this legislation is trying to capture, therefore justifies the higher penalties. If you're trying to deter other unacceptable forms, which the broader community would see as unacceptable forms of speech, the sanction, should be tailored to that as well. So you probably would look at a lower sanction around some of those things. I mean, I was thinking around this, some of the earlier controversies. I mean, Professor Peter Singer, in some of his very early papers, he talked about, that children with severe disabilities have less right to exist than animals, for example, and certainly provocatively suggested infanticide for children with very severe disabilities, having read his paper. I mean, that sparked huge outrage and offence among the disability community at that time, and I'm not suggesting he necessarily holds those views still today, but certainly he was very reckless in the way he expressed those views. Whether, you would want to deter that kind of view being put forward, but again, I probably wouldn't suggest that was at the level of intention of what this legislation would be trying to capture. Okay.
I'd forgotten about Dr. Singer's papers until you'd reminded me again.
You did that reminder.
Thank you for that. Okay, I might leave it there. That's been a very useful discussion, Chair. So I might hand the call to you.
Thank you very much, Deputy Chair. Just to the Uniting Church, thank you. We're having a discussion across the internet, not across the table today, about distinguishing physical and psychological harm. But your submission outlines the harm that hate speech can cause. And for the benefit of those listening, can you sort of step us through, I mean, you've got it in your submission and you refer to the Australian Human Rights Commission, but it occurs to me that psychological harm is quite harmful, particularly for young and vulnerable people.
Yes, so I mean, the submission itself does outline previous research that was done by the Australian Human Rights Commission, and from memory also Vic Health did work on looking at the impacts of racial, expressions of racial hatred and also just racial discrimination and prejudice. And again, it leads to, across a community, can lead to mental health issues, can lead to low self-esteem, can lead to self-harm, PSD-type symptoms, mental health problems. I did look at a paper by Delaney Sherritt et al. From 2015. Again, that looked at LGBTQI community But these weren't looking so much at, that later paper wasn't looking so much at expression of hatred, but it does sort of suggest that a hostile environment can have mental health issues. I think what this legislation captures and what Parliament is rightly trying to restrain is the potentially would be those harmful effects as a result of hate speech. Now, as I understand this legislation, though, it doesn't currently capture those mental health impacts. What I'm indicating is we're probably not opposed to that if it's capturing the extreme end of expressions of hatred and the harm will occur. Given the severity of the penalties, it might, there might be a legitimate case to be made to also deter other forms of expressions of discrimination, prejudice that actually cause people harm, but you wouldn't have this level of penalty attached. I mean, again, I did point to earlier the Royal Commission into neglect and abuse of people with disabilities. Also, you have lots of testimony of people with disabilities talking there about the impacts, the mental health impacts on their lives of, extreme forms of prejudice being expressed and hostility, views that people with disabilities are better off dead type attitudes, which has severe impact on people's sense of worth and well-being. So we do think they are things that, in a society, you would seek to move. The question is, to what degree do you do that via cultural shifts, but also you do need at some level a level of protection that has sanction attached to it for those who go to the extreme end.
Yeah, and I mean, look, to be clear, this bill doesn't contain an anti-vilification or serious vilification offence, which would probably capture more of that type of conduct, I imagine.
Correct. So this is only dealing with the very extreme end of the spectrum.
Yeah. We have had a lot of submissions from a huge range of diverse communities suggesting that the bill actually should go further and have a serious vilification clause, predominantly because they feel like the bill at the moment will only capture the most extreme forms of threats of violence. On the issue of a serious vilification offence, I think you went to this with Senator Scarr, but just interested in views across the table about including that. The bill doesn't at the moment, but there are a call from many witnesses for us to do that. So I'm happy to take everyone's view on that, just so everyone has put it on the record, given it's come up throughout the day.
My view is that calls for a separate piece of legislation rather than something on top of this conversation and a separate conversation.
Sure.
Bishop Stead?
I'm aware of the recent report from the New South Wales Law Reform Commission, which was looking at amendments to Section 93Z of the Crimes Act. One of the questions there specifically was the question of criminal sanctions for serious vilification, and it rejected that. And I'm quoting from paragraph 4.63 of that report. No Australian criminal vilification offence has an objective harms-based test, and to our knowledge, no recent law reform inquiries recommend introducing one. And it goes on to express uncertainty. It goes on to say that they do not think it would be appropriate to introduce criminal sanctions to something that doesn't have a tightly defined. So to put it the other way around, the criteria about something which is likely to or reasonably likely to insult, humiliate, intimidate, or ridicule, or those things at a serious level. These terms, quote, are subject to interpretation and community members do not always agree on their meaning. This uncertainty could make it difficult to determine a reasonable person's view to the criminal standard, that is beyond reasonable doubt, and apply it to the circumstances of the offence. And so it goes on to say that it would be inappropriate to have something so uncertain embedded in the criminal law. So that would be our concerns about a serious vilification offence, is the uncertainty as to how the test will be applied means that we have criminal sanctions attached to something that the community members may not even be aware that they are breaching.
Thank you. Christian Schools Australia, I thought I should just get your view on that because I've asked everyone else today.
Thank you, Chair. I think we would tend to agree with Mike Southern's contribution. I mean, I think we, as communities of faith, we've been promised for many years effective legislation against religious discrimination. It hasn't been able to be legislated, so I think we'd prefer to wait for that serious piece of legislation in the future rather than to tack on elements of that to a bill of this nature.
Okay, thank you. That's good to have on the record. The offences in this bill, though, are not as broad as vilification offences, and actually the explanatory memorandum says that offences are not intended to capture mere expressions of opinion or belief, however hateful or reprehensible. This conduct would be criminalised only where it involves threats of force or violence. There are current offences in the bill that are being amended by this one, which deal with threats of violence or urging violence, sorry. I'm just still struggling to see how that might extend to psychological harm, as you've suggested. I don't think that... Do you know of any prosecutions under the existing offences that have involved psychological harm? I know you've suggested there's a potential scope creep, but at the moment the legislation doesn't cover that.
So if we could refer to explanatory memorandum, we indicated in our submission that it indicates that fear can arise from a threat of force or a force of violence under the two new proposed provisions, section 82.2BA and 80.2BB.
Yeah. But
yeah,
I
suppose we're saying it's just been admitted in
because I mean a threat of violence. I mean, I get a lot of really despicable emails through to my inbox on a daily basis, but the ones that threaten violence are different, and they're of a different nature. Yep. And obviously those have to be dealt with in a different way because they're serious, and the people who make those types of threats, the risk of those escalating to real physical violence is higher and more likely. So I'm just trying to understand where there would be a situation where the genuine practice of belief would be considered a threat of violence.
I can answer that, Senator. Where it all turns on what you think the act of violence is, and we're all thinking, as I think we should, act of violence means something physical. But if you say the act of violence is a psychological harm, then the act of violence is the thing that I do that causes someone psychological harm. If Christian teaching causes people to live in fear, if it causes them to experience or to be fearful of exclusion from a religious community, that causes anxiety, that causes depression. That is the act of violence is the causing of that thing, and my intention to teach that in a church context could be construed as either urging violence, if I'm telling other people this is how you should live, parents, this is how you should raise your children, or if I'm doing it myself, then I am threatening violence because I'm doing something which is threatening the mental health of people. Dr. Zerznak referred to hostile environments that create mental health impacts, and he's referring to studies which talk about churches. In our submission from the Sydney Anglicans, we cite a recent paper that says this is what's going on in religious communities. It claims that Christian communities teaching traditional theology and ethics which treat diverse sexualities and gender expansive identities as sinful can be places where faithful LGBTIQA people are subject to spiritual abuse. And so that paper uses the language of spiritual abuse, harm and violence to talk about traditional teaching about. So that's the moment, is to understand that some people think that teaching traditional teaching is an act of violence in itself against LGBTIQA plus people.
But the court would have to stick that as well, not just the person.
Yes, a court, but as I said, nobody...
And the way that they're drafted at the moment, you think a court would find that?
Yeah. The fact that we could move from the category of actual bodily harm in New South Wales to include psychological injury is an example of the way in which the courts have been able to reconceive of things. Something, actual bodily harm, I would have thought meant something that involved my actual body. Now it involves my psychological harm. And as I said, that's generally the trend in understanding harm is not... Things that hurt me are not just the thing that breaks my bones, and that has been the trend elsewhere, and that is our concern here. And I think everybody's agreed that's not the intention of the legislation. Therefore, let's frame it in such a way that we can be clear about that intention and not have the possibility of the unintended consequence.
I mean, the explanatory memorandum is very clear, and that would be taken into consideration by the courts as well. It's part of the legislative interpretation exercise that anyone applying the law would go through. What, without, I mean...
May I? Sorry.
Of course, go.
No, may I just ask then, would it not... Is there a problem then with adding the word physically? If the explanatory memorandum wants it to be this, if we all agree that this is the way that the legislation is supposed to move, then creating that crystal clarity by saying physical harm or violence, a single word added to the bill, just makes everybody happy. That creates the absolute crystal clarity that we're saying is in the bill. It seems to me there's no harm in creating that in the bill.
And on that point, there is sufficient latitude in the explanatory memorandum to actually lead to the very conclusion that I'm suggesting. So I refer you to paragraph 73 in the explanatory memorandum, where it clarifies that fear includes apprehension. This subsection is intended to ensure that the new offences not only capture immediate and tangible fear, but also anticipatory or psychological apprehension. Now, this is not directly to the point that I'm making, but it is recognising psychological anxiety is broader than just the category of fear. And if you have the same broadening around fear, then why not the same broadening around the idea of violence? There's nothing in the explanatory memorandum that limits violence to physical violence. That's our point.
One of the other questions that Senator Scarr has asked a few other witnesses was about the bill doesn't, but some submitters and witnesses have suggested that we should consider laws that would prohibit threats of violence to property of certain groups. So we've seen some really horrific examples of churches, mosques, synagogues, other places of worship being graffitied, damaged. There's been like arson attempts on some religious places. Have you had any I mean, we've been sort of following these threads throughout the day, and I just wondered whether you had any consideration about those types of acts and how we should be dealing with them in the criminal law or the civil law. I mean, I can imagine being a member of one of those groups. If that were to occur to the place that I visit every week and worship, it would be very threatening to be the victim of that sort of attack. But this is quite a high threshold provision, so it doesn't quite expand to where the threat is to a property.
So those kind of provisions already exist in the UK law, where hate crimes do cover that, and it should. I mean, clearly the harm being caused is much greater than simply a act of vandalism. As such, I mean, having attended a number of forums with the Jewish community in Victoria, I mean, there's a very palpable sense of fear that results when Nazi symbols are spray painted onto synagogues or, areas such as Caulfield, where there is a much higher preponderance of the Jewish community there. So it does have a much greater impact, and therefore it does make sense that the force of law should try and provide a greater general deterrence against those who would engage in those activities. I mean, again, I would stress though that I think that force of law and the penalties are only one part of this equation. I mean, we do need to be thinking about what are the kind of educational and structural changes we need for de-radicalisation and to try and overcome these forms of hatred that otherwise do exist currently in our community.
Okay.
My argument would be that violence against a group of people would include violence against their property. This goes to the scope of what exactly do we mean by violence. But I can see that it would be possible for this offence to be understood that spraying a Nazi symbol is in fact an act of violence against a Jewish community. It's not just an act of vandalism.
And I think the physicality of that crime is exactly what we are saying that the legislation should be covering. I'm open to I'm aware of a Christian school that was equally defaced because of what they believed as well. I agree that there should be. Whether it should come under the same level of penalty, I think is a conversation, but yeah.
Okay. Good.
Chair?
Yes, Senator Scarr.
Oh, sorry, I just wanted to bring to your attention, I've got just one follow-up question if there's time.
No, there is, and maybe you could ask that now and we can...
Yeah. Look, I've just tried to refer to the reference to the Court of Criminal Appeal case in relation to this issue of harm. And happy for you to take this on notice. But it seems to me what I'm reading, it was a discussion the court had with respect to the meaning of actual bodily harm in the context where an assault had occurred. So there was an assault within the meaning of the criminal law, and the question was whether or not it was an assault. And as you probably know, there's a common assault, right, which is the lower standard. And the question was, in the context of there having been an assault, whether or not it was an assault that had in fact caused actual bodily harm. And then there was the discussion with respect to harm encompassing psychological harm. Yep. But it was in the context of there first having been an assault. And so if I could just, I'll dig a bit deeper in terms of reading the case, but that raises the observation, I won't put it any higher than that, the observation that perhaps in the context of that case, which is referred to, and I understand the concern, and I'm seeking to address that concern some way, but it raises the context was there was an assault. So there was some physicality in terms of what had occurred. And then the question was whether or not that assault had occasioned actual bodily harm as a consequence of the assault. And it was there that the court looked at what is harm and drew a distinction between a transient feeling of fear as opposed to PTSD or something. But this was in the context of an assault having occurred. Yeah. Can I ask you to take that on notice? I'll take that on notice. And perhaps provide additional thoughts. We haven't got much time, but I'm very keen to tease this issue out and make sure that there's the relevant confidence that there won't be any unintended consequences, and I think it would be unintended. Yep. Thank you.
Wonderful, thank you. Look, that's all the questions I have. I just wanted to say thank you very much for appearing in front of the committee. It has been very helpful throughout the day to get every type of perspective and view on this piece of really important legislation, and it's now mine and Senator Scarr's job to get it right in terms of recommendations. So thank you, and those questions on notice will seek to get them back to in a pretty tight time frame, unfortunately, with the parliamentary part of the year grinding to a halt very quickly. So thank you very much for your appearance. We appreciate it.
Thank you.
Thank you very much.
Thank you. I'll just perhaps we're still broadcasting too, just in case those microphones are still on, so don't want you to get hot mic'd. I will invite our next panel who are joining us via video conference. We're just a couple minutes ahead of time, so I'll do my best filibustering, but I want to welcome via video conference representatives from the New South Wales Council of Civil Liberties, and I believe we will have at some stage the Queensland Council of Civil Liberties also joining us today. Thank you for taking the time to speak with the committee. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you to each please state your full name and the capacity in which you appear today?
Stephen Blanks, and I am a member of the Executive Committee of the New South Wales Council for Civil Liberties.
Thank you. Mr. Pallas.
And Josh Pallas. I'm a past president of the New South Wales Council for Civil Liberties.
Great. Thank you very much. Now, while we try to connect our other witnesses, do you have an opening statement you'd like to make before we go to questions?
Yes, Senator, I can make an opening statement now if that's helpful.
That's very helpful, thank you.
Wonderful. So the New South Wales Council for Civil Liberties thanks the committee for the invitation to give evidence today. We acknowledge the bill's context, which is increased reporting about threats of violence directed at people with protected attributes. We've recently detected more reported threats directed to the Jewish, Muslim and transgender communities. Threats of violence are never legitimate exercises of free speech. The criminal law has long prohibited uttering threats of violence. Insofar as protecting people from threats of violence has been the domain of the criminal law, this bill demonstrates the expanding encroachment of the Commonwealth into matters of state jurisdiction. This is unusual and not ideal. For the sake of operational clarity and certainty, New South Wales CCL is suspicious of Commonwealth attempts to encroach into matters of state jurisdiction, where the states are the subject matter experts and state law enforcement agencies can make decisions to investigate and prosecute without confusion. Where threats of violence are directed at people with protected attributes, by the time the criminal law becomes involved, the time for the intervention to minimise harm has passed. The Australian Human Rights Commission, as recently as last week through the Race Discrimination Commissioner, called for a whole-of-government approach to respond to anti-racism with fully funded education and prevention programs. Prevention approaches are better at addressing the harms connected with this bill than the criminal law. A coherent and comprehensive anti-discrimination framework, human rights framework, and properly resourced Human Rights Commission are essential to respond to threats of violence directed at people with protected attributes. That said, we support the intentions of the bill, but think work needs to be done to make the operation of the offences certain. The bill particularly requires clarity that it could not attach criminal liability to conduct that occurred wholly in private, which we do not understand to be the bill's intention. So put another way, there ought to be an element of each offence that the threat made was a public threat. The committee should take care to ensure that there are no unintended consequences which create uncertainty, investigative or prosecutorial difficulties. Thanks again for the invitation. We're happy to take questions.
Thank you very much. And I see that we've now been joined by the Queensland Council of Civil Liberties. Thank you, Mr. Cope, for joining us today. Do you have an opening statement you'd like to make before we go to questions?
Sorry, the last committee I'll be here for, I wasn't asked for an opening statement, so I haven't prepared one.
Oh, no, you don't need to make one. Honestly, it's it's a courtesy.
I'm sorry, your practices are sort of changed. In Queensland, I'm always asked for an opening statement, but it doesn't seem to be consistent in the Commonwealth, so sorry, I haven't done one.
Mr. Cope, unless there's some summarising points you'd like to make, we can dive straight into questions.
No, let's just ask questions, yes.
Okay, thank you very much. Senator Scarr, I'll hand the call to you to begin with.
Thank you. And Mr. Cope, as a fellow Queenslander, you're with Queenslanders today, and typically we're more concerned with opening statements that eat up all the time for questions rather than someone not giving an opening statement. So
I'm sorry, I can try to make one up for you if you wish.
No need for that. No need for that. I want to, if I can go to you first then, in relation to this issue of strict liability, which is raised by the Queensland Council, can you just maybe walk us through how strict liability would act, if I can put it that way, or work in the context of these offences, and why, from your perspective, it's inappropriate that there be strict liability, and again, from your perspective, how you think the offences should be modelled not to have strict liability and what might flow from that?
Well, I suppose I should start with saying that I must confess, as a person trained under the Queensland Criminal Code, I find reading the Commonwealth Criminal Code fault provisions extremely confusing. Clearly, there are some strict liability elements, but having read some of the other submissions, it appears that I've misinterpreted some of them, and they are changing it to recklessness. But our central point is that whether you look at these provisions from either a free speech point of view or a general criminal law point of view, people should not be subject to criminal responsibility unless they intended, in this case, that they intended to do speech acts and that they intended to threaten violence, and that, as the Law Reform Commission put it, that they intended the violence to occur. So, so from both those points of view, the mens rea, as the common law would call it, a term that we don't use in Queensland, is fundamental. Well, either from the point of view that you shouldn't be making people criminally responsible for, except in certain narrow circumstances. There is recklessness. There's recklessness in the concept of manslaughter, but generally speaking, in the criminal law, people are held liable for their intentional acts. And that is a fundamental principle from the civil liberties point of view, because that allows people the maximum freedom. It allows them the choice as to whether or not they're going to do something wrong or not. That's the fundamental principle underlying it. But from the point of view of a free speech perspective, it's also important from that point of view, because it narrows the operations of these laws. So that's the sort of the group offence point of view. I mean, in relation to the offence relating to individuals, I must say, the more I think about that, the more I think, quite frankly, that should be left to the states, because assault, which includes threatening somebody with an assault, is already an offence, and the states can deal with that, as we have done here in Queensland, by making it a circumstance of aggravation, that it is done with the intention of, it's done because that person falls within a certain category, has a certain attribute. I mean, I must confess I don't know what's happened in the other states, but I mean, it seems to us that that's the better way of dealing with it in relation to individuals. And ordinarily, of course, in an assault, there are the usual mens rea requirements. So that's the gist of what we're saying.
Okay. One of the issues raised by the Executive Council of Australian Jury was in relation to this issue of what the intent is. If the intent, if there is an intent to actually use, and you do use threatening words which threaten the use of force or violence, and there's evidence of that, why do you need the extra step? And this was queried by the Executive Council of Australian Jury, to demonstrate that you you intended the threat to be carried out, or that a reasonable member of the target group would have a fear that the threat would be carried out. Isn't it on one view, the mere making of that with intent of making that threat of inciting or urging people to use violence? Why, and you intended to utter those words, why isn't that sufficient?
Well, I think the purpose of that is to deal with people who get up and say things in the spur of the moment, or which, even though it may be very bad humour, they are attempting to be funny. But I think the main point of it is the first one, which is that people get up and say things that, if they thought about it afterwards, they would never have said. And so I think that's the point of having the two intentions.
But there are still potentially odious consequences arising from someone getting up, even if it's in the spur of the moment, and saying something which threatens the use of force or violence, or urges others to use force or violence, isn't there?
Well, that comes down to the question of whether or not the people saying it know there's a risk that there might be some violence occurring. I mean, that's the other aspect of it, isn't it?
Yeah.
But I mean, that's the essential purpose of the second requirement, because, well, I mean, I'm always reluctant to refer to American cases because everybody says they're irrelevant, but I still like to illustrate the point. There's a famous American case about some student who said when he got up in the morning he thought about killing LBJ, and the US Supreme Court refused to convict him on the basis that it needed to be demonstrated they really intended it to happen, and he plainly didn't.
Yeah.
So, I mean, that's a classical illustration of what I'm talking about, which is why I refer to it, because he was obviously, middle of the Vietnam War. LBJ wasn't exactly the most popular person in America if you're a uni student, and he got up at some rally and said that. But he clearly did not, was accepted by the court that he didn't intend. That's not what he wanted to do, but, it came out, and, on the face of the provision, he would have been convicted. But because they applied the First Amendment, they said it wasn't. So that's the sort of thing I'm thinking about.
Okay, understood. If I could go to the New South Wales Council for Civil Liberties, Mr. Pallas, you know how to push all the relevant buttons with your opening statement referring to the Commonwealth encroaching on state jurisdictions. There's a place for you in the Senate, the State's House, with that sort of rhetoric. Can I ask you this? Distinguishing between a public act and a private act, what is a public act for the purposes of New South Wales law? When does something cease to be in private?
Yeah, so it's an act that happens in public, or an act that is also ascertainable from public. So, say, for example, the definition of a public act in New South Wales would include, say, if you stood on your doorstep with a megaphone saying terrible things and passers-by could hear those terrible things, that would be encapsulated within a public act as well. So it's not just stuff that happens in public space. It can happen in private space so long as it can also be heard by members of the public.
So if I say something in the context of a group where I've invited a group of people to have a discussion about something, it might be about a proposed protest activity, so there aren't members present other than those members who I've invited to the discussion about something which we might be planning to do, and I say something in that context, is that a public act?
So that's a tricky example, Senator. So maybe if I can recast it slightly. So say if you...
It was intended, Mr. Powers, to be tricky.
Yeah. So I mean, say if you invited a group of friends, but it was private, and everybody came at the invitation of you or someone who was allowed to extend a further invitation. I mean, that's probably still private. But say if other people showed up because they found out about it, I think then we'd be in trickier terrain under the New South Wales Act about whether that became public. But say, for example, if you just invited you and your friends, but then you live streamed it, you broadcast it some way so that people could access it, and then that took it out of your control, and someone watching the live stream then screen recorded and further live streamed it and broadcasted it, well, then that would clearly become a public act for the purposes in New South Wales legislation, because it's clear that broadcasting is something that renders something public and not private. So I think in New South Wales they're trying to cover all bases, but of course haven't been able to do.
If I can just supplement that answer by pointing out that that means of communication would presumably be using a carriage service and therefore would engage all of the provisions relating to uses of carriage services to make threats and so forth. So, yes, it's a question about what is a public act, but what the example points out is that there is already Commonwealth legislation which would deal with some methods of communicating threats.
So presumably that comment around public act versus private act pertains to the proposed offence relating to threatening force or violence against groups, as opposed to the existing offence which is proposed to be amended, dealing with urging force or violence. Or does it apply to both? I can understand it in the context of threatening force or violence, but in terms of urging others, if you're urging others to use force or violence behind closed doors, why shouldn't that be called?
Yes, I think we've framed the submission that all of it should relate to a public act. But that being said, it certainly makes more sense for the two threatening offences to require there to be a public act. I mean, something that we've been trying to grapple with is how to build in some proportionality with the diminution of that intent element, turning it into a recklessness element. So I suppose when we think about it from a free speech perspective, it's probably less free speech encroaching if there is a requirement that there be a public act. I mean, because remember, like under the New South Wales criminal law, it remains an offence to threaten violence sort of generally against anyone. So there, as Stephen has said, there's already this quilt of regulatory regimes where sort of threats and incitement are already covered. So how do we appropriately constrain this, particularly when the jail terms are high? So 7 years and 5 years, like 93Z in New South Wales, I think is only a 3-year imprisonment period. So they're drastically higher penalties here.
Okay,
yeah, so the equivalent. Yeah. Can I just add that the equivalent provision in Queensland is 3 years, which is referred to in the New South Wales submission. It's just been increased. I think it was only 1 until we supported the change to it. Actually, last year or the year before, they moved it out of the Anti-Discrimination Act and put it into the Criminal Code. But it also has, as New South Wales submission notes, an in-public requirement. And I must confess, I always thought about that as being something related to, people are at a barbecue, family or social gathering, and that's in private and in public as some broader thing than that. But that concept is in what is I now think Section 50 capital C it was in the Anti-Discrimination Act, but it also has an in public requirement and is designed to getting it out. I take your point, but as Tim said, that threatening violence is already an offence, which is of course one of the points about this. Some of it seems a bit unnecessary, which is sort of what I'm particularly trying to say about the individual offence, because it's already an offence. It already will be an offence.
So we seem to be producing a patchwork of offences at both the federal and state level, and all trying to address the same conduct, which leads to complexity. And I guess I'm not sure how the law enforcement agencies are going to work out who pursues which offences under which law following, say, some public event where things are said. How's that all get worked out? Mr. Pallas, you got answers for me there?
No, Senator, no, I don't. It was one of the questions that I raised in the opening statement. And I suppose the Law Council in their submission raises that maybe it's worth having a wholesale review of, I think it's Division 80 of the Criminal Code, in connection with the Commonwealth's human rights framework and the state-based regulatory regimes, so that what we end up with is a set of offences and a set of anti-discrimination protections which dovetail quite well together and give certainty to law enforcement agencies. Because at the moment it seems like different governments are going in different directions, and different regulatory regimes are doing different things. And, I mean, even these new offences don't read super well with the offences that are being amended in the same bill. The elements of the offences are quite different. So we completely agree with the Law Council submission that maybe it's time to review all of them as a whole and just rethink how we regulate all these things as a matter of criminal law.
Senator Scott, I'm going to share the call in a moment. Senator Faruqi has some questions.
Yep, sure. Well, just my last question, and I've read the Law Council submission. I understand the basis and the logic behind what they propose. At the same time, we've heard very strong testimony from Peter Wertheim from the Executive Council of Australian Jury that there's a deep frustration that there are people at the moment in our community spewing hate that is being interpreted by members of that community. And I'm sure the same can be said for members of other communities. People are spewing hatred, and that could, on the face of it, only be reasonably construed as promoting or at least glorifying violence. And there's a frustration that there's a lack of appropriate action being taken against individuals in that regard. Presumably you all understand and appreciate and empathise with that frustration, but how do you respond to the concern that we need to amend laws now to address that, and actions needed now because things are getting out of hand?
If I could just address that.
Mr. Blanks?
I'm not sure that the new offences in this bill go any way at all to addressing that concern. I accept that it's a legitimate concern, but the new offences are concerned with threats of using force or violence, which is a only small subset of the kind of speech which I think groups like Executive Council of Australian Jury and others are concerned about. They're concerned more, they are concerned with vilification more generally, and hate speech more generally. And of course, that is a much more difficult area to criminalise because you have the free speech concerns, and Michael is a strong advocate of that. I don't think these offences, properly understood, in substance address those concerns. And to take a very, I think, high-profile example, in October 2023 at the Sydney Opera House, there was an event which got reported in the media. I won't use any of the words that were reported to have been said. They were highly offensive words. Perhaps they might be understood to have urged violence, but probably didn't go so high as to incite violence. Certainly no violence actually occurred. Under the new offence proposed, paragraph C says a reasonable person, being a member of the targeted group, has to fear that the threat would be carried out. And taking the particular words which were alleged to have been said at that event, I'm just not sure that the element in paragraph C even then could be made out. And so there's another reason why this proposed offence doesn't actually address the issue that is being raised.
So, Mr. Blanks, Mr. Wertheim.
I'm going to have to share the call. I'm just very conscious of time, and I do want to be fair to others, if that's okay. We might have time to come back to you.
Sure.
Senator Ricky, you have the call.
Thank you, Chair. Good afternoon, everyone. If I could start with the New South Wales Council of Civil Liberties. In your submission, you state that the law is likely to unintentionally criminalise and stifle expression in contexts or circumstances where such expression poses minimal or less serious risk to others. Could you perhaps give some examples of this?
Josh.
Yeah, Stephen, I was waiting to see if you wanted me to go or you. So, for example, thank you, Senator Faruqi, for the question. For example, this goes back to that public-private distinction. So, I mean, it's not to say that threats of violence in private are any less harmful, generally speaking. But in terms of when the criminal law needs to intervene, if we go back to that example of a discussion at a barbecue, well, maybe it is less harmful and maybe we don't need to have a 5 or 7 year jail term attached to it. We're not sure that the Commonwealth government intends to criminalise that sort of conduct, but they were the sorts of examples of free speech that we thought might be, or free speech in inverted commas, because a threat to violence is never a proper speech act, that could potentially be criminalised.
Okay. I have another example, which is, what if a parent reacting to a child's disclosure of their sexuality threatens to ground the child until they change their mind? Why is that not a threat of force within the scope of the second offence section aimed at an individual? And so I'm quite sure that no one has thought about that example as an intended target of this legislation, but reading the words, perhaps one could come to a view that that sort of behaviour would be caught.
And there was a discussion on that Public Act element before as well. Are you suggesting that there should be a definition in this bill of what a public act is? Like you were saying, New South Wales has some definitions. Is that what you're recommending?
Yes, and we think it would add clarity to the offence provisions, and it would also make the offence provision sort of more congruous with what's happening in the states and territories as far as we know.
And both the submissions that we're talking about now express concerns that the enforcement of vilification laws can disproportionately affect vulnerable groups. Could you, maybe we start with New South Wales, could you kind of highlight who are these vulnerable groups in your view, and maybe give an example of how they might disproportionately impact them?
Yeah, well, for example, Senator, as I know you're very well aware, there is a common phrase being used by the Palestinian community at the moment, which some people say is a threat to violence and some people say is not a threat.
You're referring to from the river to the sea?
I am, Senator.
Yep.
And, you know, would under this offence, could that chant at a rally meet the elements? Maybe. Would it be reasonable for a person who is an Israeli citizen to consider there to be a threat that might be carried out? Maybe. It's hard to know how this offence provision would be interpreted by a court in that context. And I think that's problematic. Or, you know, if a transgender activist says, you know, so-and-so needs to get in the bin, they're transphobic, like what is that? Is that a threat? Is that a threat of violence under this provision? Could the person reasonably think that the threat might be carried out? They might be thrown in the bin? I don't know, maybe. It's hard to know how it could be interpreted in those contexts. And we know that policing and prosecutorial agencies generally disproportionately impact on minority communities. So like we pointed out, 93Z has been used against an Aboriginal person. Now, how it's been used against an Aboriginal person, what the facts are, we don't know, but it gives you an example that already we can see from the data that minority groups are being impacted by the vilification.
Okay. Thank you. And do Queensland...
I mean, I agree with everything that Josh has said. I mean, these are all matters of prosecutorial discretion. And I mean, quite frankly, the history of all these hate laws, going back to the first ones were implemented in the UK, the first people who were protested under the anti-hate laws in the UK were black people, black political protesters. The moment you introduce these laws, they can be used against anybody. And our starting point is that free speech is the most powerful right that anybody has to change society. And the moment you introduce a law, it can be applied to anybody. It just depends, you know, who's in government and who's deciding the prosecution. And even if people are subsequently convicted, they have to go through the whole criminal process with all the stress and expenditure that requires. And there's nothing to stop somebody deciding to prosecute somebody for saying from the river to the sea, or equally any other of those phrases that are in contest over what's happening in Gaza.
Thank you. Now, just coming out of these particular laws and kind of trying to look at the bigger picture, the Australian Human Rights Commission's report, very recent report, on the National Anti-Racism Framework, has recommended to include a positive duty in the Racial Discrimination Act 1975, similar to the reforms to the Sex Discrimination Act 1984, and also what was proposed by the Disability Royal Commission for introduction into the Disability Discrimination Act 1992 to strengthen that act. Would you agree with that?
Well, I'm not quite sure. Not familiar with that recommendation, but we supported the positive duty which has been implemented in the Anti-Discrimination Act in Queensland. So if that's the same thing, then yes, we do support that.
Yeah. How about New South Wales?
I can't see why a positive duty should be in all of the Discrimination Act, really. Like, it should be something that's uniform across the Commonwealth Discrimination Act, if it's something that the Parliament thinks is important. And there's a whole body, as you say, Senator, of research that's come from agencies saying it's important and recommending it. So why not?
Yes.
And just similarly, looking at the bigger picture, the Human Rights Law Centre in their submission have stated the best way to combat forms of discrimination, including racism and hate, would be to implement a comprehensive Human Rights Act, which is something the Greens have been pushing for a while. Is that something that you are on board of as well, in terms of its importance in combating hate and violence and discrimination?
Oh, of course. Well, we were very much involved in the campaign for the Human Rights Act here in Queensland, and we've been back in the Brennan Commission days. We were supporter of that. So yes, of course.
And also from New South Wales Council for Civil Liberties' point of view, we think that that is a fundamental failure of the legal framework governing all of Australia's laws.
Just my last question from me. Given the concerns that you have raised about, I guess, some of the elements of the bill, do you think that this is a law that needs to be passed at this point, or do you think it's going to make a difference, or not really?
I think I would summarise our position by saying more work needs to be done in order to be sure that the law is making a useful contribution to the harms which it seeks to address. It is, as I said earlier, not addressing the concerns raised by some community groups about vilification, and what it does propose, it proposes in a way which seems to create more uncertainty and more potential for bureaucratic troubles between Commonwealth and state agencies involved in enforcement.
I suppose my answer to that would be I divide it into two. In relation to the offence about individuals, I quite frankly don't see a need for it, and it's more appropriately dealt with at a state level, as we've already done here in Queensland. In relation to the other one, it needs a lot more work. It needs significant change, and it shouldn't be passed in its current form.
Okay, thank you very much. Thanks, Chair.
Thanks, Senator Faruqi. I just have a couple of questions before we go to our next witnesses. Just quickly, one of the issues that's been raised, obviously, is about the way that journalists would be treated under a offence of this kind. I think, Mr. Cope, your submission advocates for a defence to the new offences for journalists. The explanatory memorandum provides that it's not the intent of the bill to criminalise journalism, but can you explain where journalism would intentionally urge others to use violence or force?
Well, I mean, the answer to that, of course, the question is whether somebody might be prosecuted for it, even though they might not be actually guilty of it. But I mean, I put that in there because I was reading a few submissions that were on the website when I finalised it, and that was one there, and I thought that was a good point. But ultimately, the real answer to all of this is to construct a provision which is narrow and which requires the relevant intents, in which case, I mean, I suppose you've still left the prospect of some journalists being prosecuted. But if you construct an offence which is narrowly based and requires the relevant intentions that we've been talking about, then any of those defences, including good faith, are not necessary. I think that's made by the Law Council submission. But in the absence of that, I do think the journalist's submission made an important point, and I couldn't see why it was being removed. Which is why I put that in the submission.
Your reference there to being removed is to the good faith defence?
Well, they've no longer got the journalist defence either.
Right. Okay.
Yeah. But I mean, as I say, you could apply it to both of those. But yeah.
Yeah. I guess we took evidence from the Australian Human Rights Commission earlier in the day about whether a threat of violence could ever be made in good faith, and they were of the view that it would be very unlikely for a threat of violence to be made in good faith. But
that's a point. Yes. I mean, as I say, I mean,
sorry, Mr. Cope.
The more I think about it, is.
Mr. Cope, I haven't finished my question.
Sorry.
It's okay. I was wondering then, in terms of recklessness, that's the I guess the fault element in these offences. Where would a journalist be reckless to a threat of force or violence?
Well, once again, I think the issue is whether in theory anybody could be prosecuted for anything, it becomes much easier to prosecute somebody if you want to allege recklessness. I mean, you're obviously going to have different types of journalists, aren't you? You might have someone who's very close to the issue and republishes something which somebody might want to allege is reckless. That's the possibility that occurs to me.
Okay. All right, thank you for that. And then just to the New South Wales Council of Civil Liberties, one of the things that's come up in a lot of the submissions of witnesses is the issue around serious acts of vilification. And whether it should or shouldn't be criminalised. We've gone through this with other witnesses today and traversed towards it in your answers to other senators, but just wondering whether you think that that's appropriate or inappropriate, whether you can explain why.
Stephen, do you want to take that one, given your involvement?
All right. I would say in isolation, without a Human Rights Act and appropriate balancing of rights and freedoms against the criminal law, there would be a grave risk that any attempt to codify a criminal vilification offence is going to trespass on either free speech or religious or other rights which need to be carefully balanced. There is certainly an intersection between all those areas, and simply criminalising some conduct without recognising the rights associated with related conduct, I think would be dangerous.
Okay. Thank you. It's helpful to get on the record. I've asked every witness today about that. Just on the issue of free speech, I know it's obviously very important to both of your organisations around making sure that there are obviously well-recognised limits to speech, particularly where it impedes others' rights or urges violence. The Castian Centre for Human Rights Law, did you get a chance to have a look at their submission or their evidence today? Maybe if you could take on notice that submission. They put forward the proposition that the bill appropriately protects free speech in the circumstances, but I wonder whether you could just take it on notice and provide us some feedback on it. Yeah.
Sure.
Great, thank you. I think that's all the questions we have, and I think we're due to move to our next witness. So thank you very much for your time. It is a pretty tight turnaround for those questions on notice. I'm sorry. I think it's
going to say, when is it?
Friday, close of business at a stretch.
Okay.
Apologies. The end of the year, everyone's trying to squeeze in as much as they can.
I also have some interesting Queensland government legislation to comment on.
Well, good luck with that. Enjoy. Thank you very much for your time today and for giving evidence. We do appreciate it. And I think our next witnesses are on the line. Sorry, we're due to go to a short break, so we will suspend and return at 3:30 p.m. Canberra time.
Thank you.
Thank you.
Thanks.
Thank you.
Well, the committee will resume its hearing. Thank you very much. And I now welcome representatives from the Law Council of Australia who are joining us via video conference today. Thank you for taking the time to speak with the committee. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. But for the Hansard record, can you please each state your full name and the capacity in which you appear today?
Yes, my name is David Neal. I'm co-chair of the Criminal Law Committee of the Bar Council, of the Law Council, I should say.
And my name's Michael Stanton. I'm a member of the Criminal Law Committee of the Law Council.
My name's Chinook Chatterjee. I'm a senior policy lawyer here at the Law Council.
Great, thank you. Do you have an opening statement you'd like to make before we go to questions?
Yes, thank you, Senator. We have a longer version of this, which I do not propose to read, but we will provide to the committee if it has not already been, which provides a bit more detail to amplify some of the points that are made in this more brief statement. We firstly acknowledge the traditional custodians of the country throughout Australia and their connections to land, sea and community, and pay respect to their elders past, present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. We acknowledge the importance and concern for social cohesion in a multicultural society that brings us here today and has, especially in recent times, caused some concerns about civil unrest and division within the community. So while we acknowledge, of course, the need for social cohesion, the question is whether these measures go too far in imposing on freedom of thought and expression, which are cornerstones of modern democratic societies. And we exhibit our own concern that the balance here, a difficult balance, is struck in the right place. We are very concerned that if the fault element of the urging offences and threat offences is reduced to recklessness, that will cross the line that the AHRC was so keen to protect when it insisted that intent should be the fault element for these offences and not broadened in the way suggested in some of the submissions to include recklessness. Both at common law and under the criminal code, and this is contrary to what is said in the explanatory memorandum to this bill and in the submissions of the Attorney General's Department, the crime of incitement to incite conduct of any sort or to commit offence is committed only by those people who intend to commit it. Neither the legal frameworks in the code or in the common law do extend recklessness for the crime of incitement. In its report in 1992, the Model Criminal Code officers, who was a body that had been originally set up to advise the Attorney General on the best pathway forward for the criminal code, maintained that position and said that extending incitement, which I actually chaired that committee, we consulted widely. We had representatives on that committee of senior criminal lawyers from all over the country and consulted broadly. In the discussion paper, we canvassed the issue of whether recklessness should be included in incitement. The answer was no, it should not be, and that was what the report recommended and what the criminal code has implemented, in fact, in section 11.4. So the proposed offences in relation to urging and threatening would broaden the law in two ways. One, the existing law of incitement requires proof that you were urging someone to commit something which is an offence. This provision talks about urging force or violence. And I note from earlier, just watching some of the earlier discussions, words used are force or violence. They're not, the word is not the word harm is not used. There are some circumstances, of course, where force and violence are justifiable, for example, by way of self-defence. So there's one extension, but the other one is the more significant one in this context, recklessness would enable a conviction of a person who did not intend to cause another person to use force or violence by saying, well, you took a risk that someone listening to your words might do that. We think that's where the line has been crossed, and that should not be the case, that the words themselves that are used in this context, and there are various words used in the law in relation to incitement. Some are encouraging, urging, advocating, all similar things, but including within them the intention that some other person should commit the offence that has been incited. One of the justifications for including recklessness has been, as we see in the other submissions, the idea that it's too hard to prove intent. We notice that there's no evidence offered to support that proposition and point out that intent is, as your previous presenter said, quintessentially about criminal intent. And thousands of people are convicted on a daily basis of intent offences, ranging from murder to rape, drug offences, etc., etc. And that is proved every day. And indeed, in these contexts, where words are being used, there will be pretty good evidence of what the person said or wrote, which will be there, and there'll be someone who's heard it who can talk then about the context. So those are the matters that we say where a person has urged another person to commit a violent act or use force on another person. There should be a conviction, but it's terribly important then to make sure that that's what's actually what the defendant intended. And in the normal way with criminal offences, the prosecution should have to prove that. And indeed, because this is a preparatory offence, that is, as soon as you utter the words and someone hears them, the offence is committed. There's inherently a predictive nature about the offence. It's predicting that someone will do what you have incited, or on the recklessness approach, that they might do what the words mean. In order to be reckless under the code, that introduces the words substantial and unjustifiable risk. There's a complexity in that should be avoided in terms of ease of prosecutions. The simple question on the existing law is, well, did they intend or not? And we have a detailed investigation into that and the circumstances surrounding it to see whether you're satisfied that when I said, I'm going to kill you, I actually meant to do that, or I want you to kill someone else, I actually meant that, as opposed to expressing exasperation at the kids who've yet again not done the dishes or what have you. So we are urging, as several other detailed reports on this subject, not only the Model Criminal Code Officer's report in 1992, but also the AHRC in 2006 and the New South Wales Law Reform Commission in 2010 in its report, all considered and rejected the notion that the incitement offence should be extended to recklessness. Indeed, and this is important, the AHRC, we think it may have been misunderstood. The AHRC, in its reference, was asked to consider whether the good faith defence should be abolished. Sorry, and said it should not be. But let me start that again. The AHRC basically said, we think you should not use recklessness and you should stay with intent, and that the good faith defence, which is somehow inapt in this circumstance, really should be addressed by paying very careful attention to the context in which the words are used, so that the true meaning of what the person uttering the words is will be cleared and proven to everyone. They said that that's a preferable approach to the abolish the good faith defence. We say, however, where this law this proposed law extends not only to recklessness, but also would abolish the good faith defence. The danger there is you've broadened it on two fronts, which run the risk of people convicting people who actually did not intend another person to use force or violence. So there are basically 5 points that we make. Firstly, that the recklessness proposal in these two offences should not go ahead, and ideally, if it does go ahead, we would be more concerned that the good faith defence were retained, even though we see that as the second best option, because like the Australian Law Reform Commission, the focus on intent and proof in court about the context and circumstances behind the words is thoroughly explored. Secondly, that these offences should not be applied to children. Thirdly, and very importantly, the offences should not be broadly drawn in the ways these are, where selective prosecution could do more harm than good, where the person prosecuted can portray themselves as, look, nothing happened here, I said those words, I didn't mean them, oh yes, but you took a risk, and then someone, unpredictably to me perhaps, if I'm the word utterer, does go and do something or is about to go and do something. But it is very speculative because, as I said earlier, the offence is already committed once the words are spoken and heard. What would have happened next didn't happen, but you are prosecuted. See the need here then to be certain about what the intention behind the words is. And then fifthly, and this applies in particular to the threat offences, there are provisions in the threat offences which in subsection A talks about an intent to threaten or urge. B then goes on to talk about what is the consequence of that, and that's in subsection B an offence, an element of recklessness, and then 3 in the perception of the audience to those words, strict liability as to what the audience would understand by those words. This is just mindlessly complex and something that really ought not to be done. So I think we should leave it at that.
Yeah, I think we should too. Thank you, Senator Scarr.
Thank you, Chair. Mr. Neal, can I just ask you? You had a list of 5 items. I got 1, 2, 3, and then the last item I had at 5. What was your 4th item?
That was the one which I wrapped up in the other comment about. Well, there were 2 other ones. There was that one that I wrapped up in the more general comments about the breadth of the offences, but the 4th one was that the one that's been brought up by the Councils for Civil Liberties in New South Wales and Queensland, the interoperability of these offences at Commonwealth level when the states and territories already have a list of offences for threatening, injuring, risking people, endangering them, etc., etc. All of those substantive offences are part of the suite of powers that are available to be used against people who urge threats and violence. And not only are the substantive offences available, but also incitement or attempt to or conspiring to do those things. All of that is captured by the suite of offences already applicable to offences against the person, so that the differences then in the penalties, which again were discussed in the last session, as we saw, where these offences are carrying 7 or 5 year penalties. The New South Wales ones, I think, were 3 or 4, and I think the Queensland one has recently gone from 1 to 3. So really, what is the point here? And that's in particularly the case where the state offences, generally speaking, cover threats of force or violence to all people and in public or in private.
Yeah. Okay. Understood. Thank you for that clarification. And
sorry about the maths.
No. You're trying in good faith to try and abbreviate the opening statement. So I appreciate that effort.
Thank you.
And good to see you, Mr. Stanton, wearing a different hat. You're a veteran of a
I am, Senator.
Committee.
Thanks. It's nice to be here.
Okay, thank you. Can I ask just a high-level question first? And that is, the Executive Council of Australian Jury appeared before us, Mr. Wertheim, and provided a heartfelt plea, as it were, that on behalf of his community, and we've also heard from the Muslim community, that members of the community are suffering an escalation of anti-Semitic attacks. There's great fear in the community. There are all these provisions on the legislative books that are meant to be enforced against people who are promoting threats and violence and hatred in our community, and yet nothing appears to be happening. And there needs to be something that occurs under these provisions. If those provisions are inadequate in order to do that, then we need to quickly move to amend the provisions so that the community is protected. How do you respond, first to you, Mr. Neal, and then I'll give Mr. Stanton and Mr. Chatterjee an opportunity to respond. How do you respond to that plea, if you like, for the Parliament to do something, to amend the laws that are on books? I agree with you, Mr. Neal. These laws are extraordinarily complicated from my perspective, and I can see the difficulty. But how do you respond to that plea that something more is done in order to provide offences which could respond to the situation, the real life situation members of those communities are finding themselves in?
Well, Senator, it seems to me that there is ample scope in the existing law where people have advocated force or violence to prosecute them. So I'm not sure that definitionally is really where we're talking. It's more, are the available laws, of which this is only one, suitable? And listening again to the submissions from some of your earlier submitters today, it does seem to me that their real ambition is for a racial vilification offence, which may or may not be, justified, and that this, in a way, is being used as a way of getting to the really desired objective. But when you're speaking about it, I guess the main point is simpler is better, and if that's what they want, that's what we should all be talking about, not by broadening an offence which is an inherently vague, unspecific sort of offence, which has often in the past been used in highly political situations. It was used by anti-apartheid campaigners in South Africa. It was used during the Vietnam War, as you heard from Council of Civil Liberties. It was used in Northern Ireland, where the Catholic protesters were behind barricades and the police were coming, and they were defending themselves. So that, the very political nature of these sorts of events really risks, if you pick one side or the other to prosecute, that will deepen the divisions and possibly make people who are actually uttering repugnant words, turn them into sort of martyrs. And I do think that's a real danger when you think of the ways in which this can be dealt with, what we've said about education, arguments against what these extremists are saying, dealing with the civil society as a whole in a corresponding, in a constructive way, rather than some of the crazies on the net getting now hauled into court to have arguments about an offence of this sort, where you won't be able to show that their words actually resulted in any specific concrete harm. It's it's extremely risky. There are lots of heated things go on in a number of these discussions. Radio shock jocks, another potential source of this. Calls, for instance, for a certain political figure to be put in a sack and dumped in the ocean might fall well within this, but again, is this the appropriate response to these things? Rather than calling that person out and saying that's a reprehensible thing to say, and we won't we don't want to hear about that anymore, and then combating it. It simply won't go away, and the danger is making some of the extremists, either right or left, into martyrs for their cause on this. Really is not really the solution, unless you're clear that they have crossed the line and have actually intended to use force and violence, in which case no one could criticise the prosecution authorities for employing not specialised laws really like these ones, but the general criminal law to say you've crossed a clear boundary there and you will now be prosecuted for that. Otherwise, the martyr option is there, and it really just makes them worse and forces them perhaps underground, but gives them a sense of grievance that you really oughtn't to be giving them.
Mr. Stanton?
I listened to the evidence given by Mr. Wortham and the Executive Council of the Australian Jury this morning, and one can't help but be affected by and be very concerned by the accounts that were given in evidence. The concern, though, is that some of the examples given wouldn't be captured by this bill. So flag burning, those chants outside the Opera House, now that they wouldn't, on my view, meet the definition. So I echo Dr. Neal's point about there's a broader conversation here where a lot of groups seem to want more robust anti-vilification protections. And in Victoria, as the committee will be aware, we of course now have the Justice Legislation Amendment Anti-Vilification and Social Cohesion Bill, which has just been introduced, and that provides an example. And we have had in Victoria successful prosecution of one particularly notorious far-right actor using those criminal provisions. But in terms of the plea for empathy and understanding and the hurt that is caused by that conduct, this bill wouldn't remedy that. And on the other hand, there are serious concerns. The recklessness component is one, but also piggybacking off that, and we may get to it later, the strict liability fault element for the proposed additional offences causes us real concern. Hate speech has always been a crime of intent, with the intent of the actor and intending to cause an effect, including fear or othering of the affected person or group. And whenever we see a diminution of the fault element, or even more the next step, introduction of strict liability, then that makes us concerned because of the potential for a politicised use or weaponisation of these provisions in some circumstances.
Okay. I just quickly want to move through some of these 5 points, Mr. Neal.
Yes.
So I understand the argument in relation to recklessness. That was the first point, and
yes.
So the concern around introducing recklessness as the bar and at the same time removing good faith. The Executive Council of the Australian Jury, in my discussion with them, and Mr. Stanton had the opportunity to listen to at least some of that, was along the lines of, when we're teasing this out, from their perspective, they thought they would prefer a tightening of the language, if you like, in terms of the offence, but drop the recklessness, leave it as it is in terms of the intent, with the exception of making the intent a bit clearer as to what the actual intent was. So there was concern that the intent provision in the current clause has two limbs, the first clause is the first limb is the first person intentionally urges another person or a group to use force or violence against a group, and then the second limb is the first person does so intending that force or violence will occur. And from their perspective, that's extraordinarily convoluted in terms of having a double-pronged intent associated with the offence, and might well be one of the causes for the offence never having been actually used. So interested in your views in that regard.
Yeah, look, it's a bit of a standard issue in criminal law that you divide intent up into little bits, and it starts to make it all rather unreal. But what really is at work here is that there's firstly the intent to say the words, "I'm going to kill you." But the second intent is what do I really mean by that? Do I actually mean I'm going to kill you? So that's why the two notions are there. But they're bound up in the words urge, advocate, or those sorts of words. Really, what you are speaking words where you mean to achieve an objective, which is, in this case, to get someone else to use force or violence. That's in line, really, with what the AHRC was saying, and that's why they put in the two lines of intention, as well as in section 11.4 of the original code. But in strict logic, you don't urge something unless you mean to get someone to do something. So it's trying to spell that out a bit more. And then the AHRC would have added but the judges or magistrates need to be very careful to explore the context of the words. Because if I say, let's kill all the lawyers, as one famous playwright once said, and I'm saying that in a theatre, I don't think that, although I intend to say those words, that no one's going to act on them. On the other hand, if I'm
don't bet on that.
Yeah, well, I choose lawyers because it's we're so put upon that I think we need to be in on this too. But if I say this on a riot when some person inside is on trial for a serious criminal offence, and I mean let's go in there and do violence, that's what the second intent is dealing with. But really, I think the logic of what you've said is, how could I be said to have urged or advocated something I did not want to happen? The problem is that the ambiguity of language, or the different ways in which we use language, really does require you to say, hang on, but when you said that, did you actually mean literally, let's kill the lawyer, or you go and help me kill the lawyer, or you go and do it yourself? Or did you mean to say, look, I could kill him, they've just done this time and time again, and I'm completely exasperated, and you should be too?
Well, interestingly, Mr. Wertheim was comfortable adding a context provision. He actually, so the way he would construct the offence would be to replace urges another person or a group to use force or violence to, and these words are used in a different context now in the criminal code, promotes, advocates or glorifies the use of force or violence against another person or a group. And then tighten the intent clause, but then add context to the consideration of that into the mix. And on that basis, he, at least on the face of it, would be happy to lift it up from recklessness. So do you see any attraction in terms of that sort of approach?
Look, that was, I heard you talk earlier about the recommendation the AHRC made in that context, and something in the legislation. Look, the AHRC basically said that the good faith doesn't really fit this situation, and one can see the arguments. But if you're going to put recklessness in, we don't want to lose good faith. It's the only way out. But the preferable situation would be the one that directed the mind of the judge or the jury to context, which arguably they would be doing in any event because that's what the arguments would be, but some statutory signal that context is the critical evidentiary foundation for concluding what it was when this person said those words. What did they intend to do? Now, the context will tell you a lot. You know, if I've got a gun in my hand and I'm giving it to you, go and kill someone, you're going to be pretty much convicted there because it's very clear. And on the other hand, I'm going to kill you, kids, if you don't get in here. I mean, that's the point. It's the context.
Yeah.
And if we could focus a bit more on that, that would be that would satisfy the concerns that Mr. Wertheim was saying, and would preserve the integrity of the criminal process, which is a very long established one, and one which, under our system, you know, being guilty of criminal offences, it's all about criminal intent. And especially given the volatility of this subject matter, that should be very clear publicly to everybody. And if it's not, it runs the risks we spoke about earlier, that these people who are spewing hatred will be able to portray themselves as martyrs.
Okay. Mr. Sen, did you have anything to add on that? Sorry, you're just on mute.
I should have figured that out over the last 3 or 4 years. Sorry, Senator. So the only danger with context is how broadly that can be construed. And you would have read or will perhaps read in the Law Council submission that if the good faith defence is to be removed, then there should be robust, effectively defensive provisions, public interest provisions incorporated into the elements of the offence like there are with the symbols offences. Context is always important. The danger potentially is that a broad reading of context could be used to turn what are otherwise benign or apparently relatively benign statements into hate speech, and that then becomes a very difficult exercise as to where one draws the line. So context can operate defensively if someone's a journalist or getting up at in a public forum and making an academic point, that's one thing. But what about if context is used in another way to say, well, in this context, the flying of the Palestinian flag itself is a call, when you bring everything to bear, itself can be constituted as a call to violence. So there have been, in other jurisdictions overseas, calls to prohibit that flag or other expressions, which we all know, which could be regarded as calls to violence. So just the advantage of having robust public interest defences is that it could prevent context being used, in fact, to expand the ambit of hate speech offences rather than provide meaningful protections.
Okay. I want
to just to be clear, I wasn't advocating. I myself have my doubts about both good faith and public interest in these contexts. But really, criminal trials, murder trials, are all about intent, and it's what evidence is led then in front of the judge or the jury about what intent is all drawn from the context of things which are said, done, circumstances at the time, and we couldn't complain really if, accepting that this offence is restricted to intent, that all of those same sorts of evidence would be relevant to determining whether this person actually did intend to get another person to use force or violence.
Okay. Now I'm going to ask you a very technical question. I've got a lot of legal firepower on this panel, so I'm building you up before I ask this question. A number of the faith-based organisations have raised their concern around the concept of violence, violence potentially being interpreted to be violence in the sense of physical harm, but also potentially in the sense of psychological harm. And in that context, they've raised a concern that potentially the teachings of the tenets of a religious faith could be argued by some so indisposed that this has caused me psychological harm and therefore it is an act of violence. And in supporting that argument, they raised a Court of Criminal Appeal case, I think out of New South Wales.
New South Wales, yes.
Crown and Lardner. Now, I was interested in your view on that, and whether or not the that discussion really in that case really is responsive to what we're talking about here, because did there have to have been an initial assault in that context before you even got into the question of whether or not bodily harm had occurred and whether or not it's physical harm or psychological harm? How do you view that concern that was raised in good faith and very genuine concern raised by a number of faith-based institutions?
Look, I listened to that evidence and I heard your discussion with them. I think they sort of forgot a bit that the words in these sections are force and violence. They're not harm. Harm, ever since John Stuart Mill wrote that very famous essay on liberty, has been a very heavily contested concept. Force and violence too, you hear them getting expanded and contracted. In Victoria, for example, the word injury is used for a number of offences, and injury could include psychological harm. However, in a context of an offence like this, where really it's only the words, nothing will have happened in terms of anyone actually doing something, because the offence is complete as soon as you utter the words and someone hears them. I anticipate that a fairly strict reading by courts of what is involved in force and violence would restrict it to physical harm, but I acknowledge there's some plasticity in those words, but then definitionally trying to spell out what they would mean, I hope someone else gets asked to brief that drafting subject.
Mr. Stanton, are you going to accept the brief?
I might not accept. I agree with my leader, but I'm not sure I might not accept the brief. Certainly, it would seem to me that on a plain reading, and given this would be a criminal statute that should be read consistently with the principle of legality and rights. It would be a stretched reading to extend it in that way. That's not to say that there won't be potentially examples of actors who might seek to push the boundaries, but I echo Dr. Neal in relation to just the plain meaning of force or violence.
Okay, thank you.
You'll get plenty more briefs.
Okay, thank you.
Senator Scarr. I just have a couple of questions following on from that. I think Senator Scarr's covered off most of the issues I wanted to raise. I think the issue around the good faith we've discussed with a number of witnesses today. It's difficult for me to see when urging violence would be done in good faith. In terms of the removal of that defence for existing hate crime offences, what's the Law Council's opposition around the removal of that defence, given that it would be really difficult to see it would be really difficult to see a circumstance where the current offence would be committed in good faith.
Yeah. Look, what I was just saying to Senator Scarr, I think, responds to that question. It was discussed by the Australian Law Reform Commission, who said, well, look, those two defences are somehow inapt given the nature of incitement type offences. Yeah. But that then caused them to emphasise the intent. It's the intent that really is what's at stake here. And then really what should happen is you have clear expression of the requirement that the intent has to be carefully investigated to ensure that that was in fact what was being intended. Our position in relation to good faith is if you're going to introduce recklessness with all of those substantial risk and possible activity in the future, that opens it too broadly to lose the point about intention, so that we would be particularly worried if the good faith defence went if you introduced recklessness as these provisions propose to do. So long as the focus is on intent and the jury or the magistrate is satisfied beyond a reasonable doubt that this person did intend the second person to use force or violence, then the offence is committed, but not otherwise, and not if they took a risk and then some crazy actually went ahead and did something.
Okay. You spoke about the context being relevant to these provisions. One of the drafting mechanisms that you can see in other bills, but I'm not quite sure in Commonwealth criminal law if this occurs, but you could provide a list of circumstances for the court to take into consideration. Would that be an appropriate way to direct the court towards taking into consideration the circumstances of the offence?
Well, you could potentially, but again, that's a brief that Mr. Stan will have to take. Look, I think there's a sort of keep it simple approach that we taken here. In murder, the question is, did you intend to kill or do grievous bodily harm to the person whom you've killed? The facts and circumstances surrounding these cases are just numerous. And the risk is if you print a list, then someone says, oh, that's it, there's the list. Versus, look, as a matter of common sense, if we're looking for an intent, the judge will rule about what evidence is relevant to that issue. And I've not heard anyone suggesting that in murder cases we should have a list of criteria by which intent's determined.
Yeah.
And the other, there are also some of these where public interest or journalist privilege is there, but basically we think that extra complications, and again I recall something about the Queensland and New South Wales submissions this afternoon, making these offences endlessly complex is not serving the purpose of getting convictions when there's a simple-ish element. Did you intend to have that person go and do something forceful or violent? Yes or no? And look, and in some of the murder cases, there's a particular case that I have in mind, La Fontaine in the Victorian Supreme Court, where the judges were very critical of the prosecutor introducing an alternative argument of recklessness in relation to a case where it was very plain you either did or you did not intend to shoot and kill that person when you pointed a rifle at him and pulled the trigger.
Your submission also advocates for a public interest defence. So this is different from the construction of the offence itself, but rather a discussion about what defences might apply. And one of the ones that you advocate for is for public interest defence. When would urging violence be in the public interest?
It goes back to the same answer about the good faith defence, really. If the intent is the focus of these offences, then the need for those sorts of fallback provisions disappears, because we are content if there's an inquiry into whether the person intended and it's found that he did intend or she did intend to do the force of violence, then those issues don't arise. The good faith or public interest defences are introduced as a sort of fail-safe if the recklessness provision goes ahead, which we would say it should not.
I understand.
Chair, could I just make one supplementary point in relation to that, which is that as the committee knows, in relation to the prohibited Nazi symbols and Nazi salutes, there is a requirement that where the issue arises, it becomes an element of the offence in terms of legitimate religious, academic, educational, artistic, literary or scientific purposes. And wouldn't that be more precise than a broad idea of context? But also secondly, just say there was an artist who took a photo of that absolutely horrific banner that was displayed on the steps of Victorian Parliament, which some of the submissions refer to, which does appear to be a call to incitement, and that's then displayed in an artistic work. We in Victoria know how important it is, with previous examples, to have robust artistic defences, educational defences, because you can't guarantee that prosecuting authorities will always act with in a manner with which we agree.
The last question I had was, you made a range of recommendations of a non-legislative nature in relation to funding and awareness campaigns. And one of the recommendations you made was in relation to considering measures to improve data collection in relation to hate crime. I just wanted to understand why you've made that recommendation. How do you think that promoting, or sorry, that's the wrong word, I'd rephrase. How do you think collecting data on hate crimes would assist in addressing their prevalence in the community?
Well, firstly, having data, look, basically this is a freedom of speech argument here, the whole thing is, and we want to have available to us evidence about the nature and extent of the problem we are confronting, so to better understand it and to deal with it by education, by publication of articles or films or artistic productions, information which is targeted and constructive and really would hopefully smoke out some of the very nasty underground stuff, particularly on the net. Those sorts of things, we say they are part of a suite of measures that are going to be our best hope of coping with the rise of these extreme views.
I was asking particularly about the improvement in data collection, Mr. Neal, but if there's, you could probably take it on notice as well if you wanted to go back and have a look at a very lengthy submission.
Chair,
how many of these cases are there? When are they occurring? Where are they occurring? What is the modus operandi of the people that are doing these things? Are we in such a heated environment at the moment? What can we do? How do we explain that? Therefore, what can we do about it? But it all starts off with good data and good arguments, so that
Chair,
address the rest of the community.
If I could quickly add, in Appendix B, we've set out the criminal context across states and territories. So one of the problems here is there's no national visibility on, for example, when racial motivation is taken into account as an aggravating factor in sentencing. So this recommendation builds on that analysis of the different ways that hate crime arises within the context of the Australian criminal justice system. And as Mr. Stanton was saying, we're very much alive to the types of concerns that the Executive Council of Australian Jury and Islamic representative councils have raised about rising trends of Islamophobia and anti-Semitism. So we agree on the need for greater observation and analysis of those trends.
Yeah, great. I guess to be clear, you're not putting forward the proposition that this isn't an issue that needs to be dealt with, but the data would allow governments and particularly police forces perhaps to target responses and to understand what type of content or what type of behaviour is most prevalent.
Yes.
Okay, that's good to know. Thank you. That's all the time we have, sorry. But thank you very much for your submission and for your appearance today. We do appreciate it. And I think our next witnesses are ready to go, so we'll switch straight to them. Thank you very much.
Thanks, Chair.
Thank you.
Thank you. Okay. I now welcome representatives from the Attorney General's Department, the Department of Home Affairs and the Australian Federal Police. Thank you for taking the time to speak with the committee today. I'll just read out my opening bit before you get settled. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given a reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? And perhaps if we start at the end of the table, that might be a useful way for us, the folks online, to see who's in front of us today.
All right, thank you, Chair. It's Assistant Commissioner Stephen Nutt from the Australian Federal Police, Assistant Commissioner for Counter-Terrorism and Special Investigations.
Thanks.
Good afternoon, Deputy Commissioner Chrissy Barrett from the AFP, Deputy Commissioner for National Security.
Good afternoon, Brooke Hartigan, First Assistant Secretary of the Security and Counter-Terrorism Division of the Attorney General's Department. Thank you.
Good afternoon, Luke Mufford, Assistant Secretary, Security Law and Policy Branch at the Attorney General's Department.
Jonathan Savoury, Director of the Counter-Terrorism Legislation Section at the Attorney General's Department.
Good afternoon, Colette Hull, Acting First Assistant Secretary of the Counter-Terrorism Coordination Centre in Home Affairs.
Alec Wickerson, Acting Assistant Secretary, Counter-Terrorism Strategic Policy, Department of Home Affairs.
And Melanie McKenzie, Senior Director, Office of Community Cohesion, Department of Home Affairs.
Thank you very much for appearing today. I imagine we've got lots of questions and a short amount of time to ask them, but if you've got a brief opening statement from either department or from the Australian Federal Police, we'll go to those now.
Thank you, Chair. The Attorney General's Department has a short opening statement. On behalf of all of us here today, can I thank you for the opportunity to appear at this public hearing as part of the committee's review of the Criminal Code Amendment Hate Crimes Bill 2024. Before we begin, we thought it would assist the committee to explain the division of responsibilities between our agencies. My department, the Attorney General's Department, is the lead agency with policy responsibility for this bill. We will answer questions about the key measures in it. The Australian Federal Police, as the agency responsible for enforcing the offences in the bill, if passed, together with State and Territory Police, will answer questions which relate to operational matters. The Department of Home Affairs, as the agency responsible for national security policy, will answer questions which relate to broader policy relating to social cohesion. The measures in the bill seek to combat the increasing prevalence of hate speech in Australia involving calls to force or violence. Public discourse is increasingly being weaponised, with hateful rhetoric used to attack diverse groups in the Australian community. The bill seeks to respond to this by strengthening and building upon existing legislative protections against hatred and extremism. The bill would amend the Criminal Code to strengthen the urging violence offences in sections 80.2A and 80.2B to reduce the fault element to recklessness, protect an expanded list of targeted groups and disapply the good faith offence. The bill would also amend the public display of prohibited hate symbols offences in sections 80.2H, 80.2HA and 80.2K to protect an expanded list of targeted groups. And the bill would also insert new criminal offences in Division 80 for threatening force or violence against targeted groups and members of targeted groups. The offences are not intended to capture mere expressions of opinion or belief, however hateful or reprehensible. This bill is intended to target the most serious forms of hate speech, namely the urging or threatening of force or violence against groups. The reforms would complement existing Commonwealth, State and Territory civil anti-discrimination and anti-vilification provisions. The Department welcomes your questions.
Chair, I also have a short opening statement from the AFP, if that's okay.
Thank you.
Thank you. Good afternoon, and thank you for inviting the AFP to appear today to discuss the review of the Criminal Code Amendment Hate Crimes Bill 2024. The AFP acknowledges that there has been an increase in concerning conduct and behaviours that may marginalise individuals and groups in Australia. The targeting and threatening of a person or group of people distinguished by race, religion, sex, sexual orientation, gender identity, intersex status, disability, nationality, ethnic origin or political opinion is of significant concern to the AFP. There is a balance between policing criminal activity and potentially infringing on individuals' freedom of expression, and the AFP respects the right to lawful protest. State and Territory Police are often the first responders to hate crimes, including hate speech and hate-motivated criminal damage. The AFP may investigate reports of public statements where there are concerns these statements are urging violence against groups, advocating terrorism, including praising and inciting others to commit terrorism offences. For example, praising the death of a terrorist may be considered offensive, but in some cases it may not be illegal. However, where there is a risk that it may encourage another person to commit a terrorism offence, the AFP will act. In the AFP's view, the bill would enhance law enforcement's ability, including state and territory police, to address the threat or use of violence against targeted groups. It also sends an important message to the community about what is unacceptable behaviour in our society. It is important to note that the offences introduced and amended by this bill are not terrorism offences, and this legislation will complement existing state and territory legislation and is available to all law enforcement agencies. The AFP notes that there are very specific elements and thresholds set out in the Commonwealth Criminal Code and in the new offences proposed by this bill that must be met to charge an individual with an offence. In order to prosecute, the offence requires that we consider a person's intention and collect evidence to prove that intention. We will continue to work with the Attorney-General's Department and our state and territory partners to ensure first responders are able to understand and apply these legislative thresholds. Thank you again for the opportunity to appear today, and we now welcome your questions.
Thank you. And the Department of Home Affairs, do you have an opening statement?
No opening statement from the Department of Home Affairs, but thank you for the opportunity to appear. We support the provisions of the bill and the statements made by the Attorney-General's Department and the AFP.
Okay. Thanks very much. Senator Scarr, I'll go to you first.
Thank you, Chair. I might lead off with probably the easiest question I've got on my list, just to warm up the witnesses. The question was raised as to why attributes were expanded in 80.2H, HA and 80.2K with respect to prohibited symbols, but that expansion of the attributes doesn't include people with a disability. Was that issue specifically considered by the department in its deliberations, and if so, what was the reasoning behind not including that particular attribute?
Senator, it was something that was considered. I note that the provisions in sections 80.2H and 80.2HA and the expansion of those attributes are intended to implement specific parts of our international obligations. So that's evidenced by the statutory notes in those sections which specify the particular treaties that those particular provisions are intended to give effect to. So that was our focus at the time of developing this bill, informed by recent examples of these symbols being used to target trans people. So that was sort of the reasoning behind the particular attributes included in the bill. The only thing we'd note on including disability as a protected attribute is that we'd need to identify a constitutional basis to support that inclusion. So that would be probably by reference to a treaty provision, but that would just be something to consider in determining whether to expand that attribute.
Okay, I'm not across all the international treaties to the extent that I can point you to a provision. But on the face of it, assuming there is such a treaty dealing with the disabled, which I expect there will be, and their rights, presumably that is something that could be included. The only barrier is identifying the constitutional basis. Is that a fair summary from the perspective of the department?
That's right. I don't think there'd be any other barrier to including that attribute.
Okay, all right. Thank you very much. Now I'm going to start to get into more difficult questions for people, and this is a difficult area, and the evidence we've received as a committee is quite complicated. From my perspective, I'll speak for myself, and trying to get my head around all the intricacies of how these offences work together. It's a bit like a cryptic crossword puzzle from my perspective. So bear with me if I go down a few dry gullies. Some faith-based organisations have raised concern that the drafting, particularly the reference to threats of force or violence, might encompass psychological harm which might arise or be alleged to arise from people of faith simply conducting a service or prosecuting, if I can put it that way, their faith and the fundamental tenets of their faith. So in a situation where there's no clearly no intent to cause any physical harm or violence, quite the contrary, people of faith are simply conducting their faith-based activities by reference to their religious faith. But there's a concern that the provisions might be used in such a way to include that teaching of principles of faith, of religious faith. And there's a reference to a particular case in a New South Wales context of Crown and Lardner in that respect. What I'm presuming the intention is clearly not to capture that, but can you walk me through, from your perspective, from the department's perspective, as to how faith-based institutions, we also heard from the Islamic Council of Victoria, how faith-based institutions could get some comfort that their religious activities will not be unintentionally caught by the operation of the provision?
Absolutely, Senator. So, as you said, the terms are intended to refer to physical force or violence against a person. They aren't intended to encompass psychological or other sorts of mental harm. That's consistent with the ordinary meaning of these terms, which the terms are intended to take, so as evidenced by various sort of dictionary definitions that refer to physical coercion, exertion of strength, use of rough force. And another point to make is that as a matter of statutory interpretation, a court would look to the context in which the terms are used to sort of give a further indication of the intention, which I think we would say further demonstrates that they would only apply to physical force or violence. So, for example, these offences follow the treachery and sedition offences in the same division of the Criminal Code, which refer to the use of force or violence to overthrow the government. And so interpreting force or violence to include physical harm in that context would clearly be inconsistent with the intended scope of those offences. So that context would inform their interpretation in this context. By way of contrast, the term harm has come up quite a few times today. It's worth noting that the bill does not use the term harm. It uses the term force or violence, and these offences do not encompass harm. By way of contrast, harm does by definition in the Criminal Code include both physical and mental harm. And force and violence can be differentiated from that. So I think, yeah, that's the intention, and those are kind of the supporting context that demonstrates that intention. I think there were also references made to various bits of the explanatory memorandum which indicated the intention to use that force or violence was intended to encompass physical acts. Okay.
Okay, so that I understand that answer. The question was then asked, perhaps of us as policymakers, by the witnesses that, well, if that's the case, is there any reason why you can't insert the word physical before force or violence in order to remove any doubt and provide additional confidence? I won't necessarily seek an answer from you on that now, but is that something you could potentially take on notice as a way to try and close that issue out entirely?
I think that we could. The only thing that I would say on that is I think so that is the intention. So for this particular offence, I think conceivably there wouldn't be an impact of adding physical. It's worth noting that the terms force and violence are used quite a bit throughout the Criminal Code. So there's a range of other offences in this provision and, in this division which use those terms. On the spot, I think we'd probably say that adding physical is unlikely to have a significant effect to those. There are other references throughout the Criminal Code to violence. It would just be whether adding physical in this context would have any effect on the interpretation of those offences if they didn't use physical, or if you would then need to make broader expansions to the Criminal Code. But I suppose we could take on notice further assessment of that.
Yeah, if you could take that on notice, that would be useful. And I understand the complicated issues you need to consider in terms of unintended drafting consequences and how it might flow through to other provisions. So very, very happy for you to take that on notice. The Law Council of Australia raised a number of issues. I wanted first to perhaps provide an opportunity from the agencies to respond to the concern with respect to application of the provision to children. And that's something which we haven't necessarily received a lot of evidence on. And there was a submission from the Law Council that if these provisions are to be expanded, as is proposed, that there should be an exclusion or some sort of tempering of the application of the provisions with respect to their application to children. And I'm interested in the department's view in that regard, but I'm also interested to the view of the Australian Federal Police from an operational perspective with respect to how they practically deal with this issue of children in the context of offences of this nature. So maybe going to the AFP first in relation to the concern that if the provisions are altered in the way that's proposed in the bill, that there's additional concern that they may apply to children in the application of concepts such as recklessness in a child context is somewhat problematic. So interested in the AFP's views as to operationally how you would approach that position and what comfort can be provided that there wouldn't be an unintended consequences to the application of the provision to children where it wasn't warranted.
Sure. So I can state that there already currently exists some mechanisms around children, so particularly the Dolly Incapax, which applies to children under the age of 14. So that requires that we need to prove that the child knew what they were doing was wrong. So that is something that we already need to manage in a number of investigations. So that's existing, and that would apply in this situation as well.
Okay. Is there anything else which applies from your perspective apart from that consideration? So say we're dealing with an 11 or 12-year-old who does something and you meet that threshold. What other factors are then taken into account as to how to approach the situation?
Yeah, so I might pass to my colleague as well, but I couldn't see a scenario, given what I've just mentioned around Dolly Incapax, where we would be looking to prosecute a child of the age of 10 or 11. I couldn't see a scenario where that would be likely.
No, I can only agree, Deputy Chair. There, the Dolly Incapax requirement in the Commonwealth DPP as an issue at law is a considerable burden of proof that is on the Commonwealth to prove that the child knew that they were what we're doing was wrong. In addition to the acts and circumstances and everything there, it's not open to interpretation. We actually have to adduce evidence on that specific issue, and our experience is it affords a great deal of protection to young people.
Okay, and to the Attorney-General's Department, witnesses from the AGD, there's also the issue with respect to prosecutorial discretion and the policies the CDPP has. Can you inform the committee as to what sort of considerations they would give to situations or briefs that are referred to them that involve children?
Yes, Senator, we were going to mention the prosecution policy of the CDPP and them showing that there'd be a public interest in doing such a prosecution, and they would make that determination on a case-by-case basis.
Okay, thank you. The primary issue raised by the Law Council of Australia, and this question to the AGD, is the concern that it's one thing to introduce or lower the bar to include recklessness. It's another thing entirely to lower the bar to include recklessness, but then also to remove the good faith defence. And the argument was put by the Law Council of Australia that if you don't have the good faith defence, at the very least you need some sort of public interest test or exemption or qualification, which provides some sort of handbrake, if you like, or some sort of qualification, especially where you're dealing with the lower standard of recklessness. So I'm interested in terms of the Attorney General's Department's consideration of any public interest factor which should perhaps be introduced. I note the Australian Human Rights Commission proposed a clause which would consider context, albeit we heard from other witnesses that the court would do that anyway in terms of a criminal prosecution, in terms of considering context. So no doubt you've had an opportunity to read the competing submissions and views, so I'm interested in any insights you can provide us with respect to the department's consideration of these matters, especially given you've now had a time to view the submissions.
Yeah, thanks, Senator. I'll pass to my team to talk about it in more detail, but I guess we would rely on the CDPP prosecution policy in that context as well. So again, the requirement that there must be sufficient evidence to prosecute the case. It must be evident from the facts of the case and all the surrounding circumstances that the prosecution would be in the public interest for the prosecution to proceed. There isn't any public interest exemption contained in the bill, as you know. My team might want to speak more to that.
Yeah, thanks, Senator. I just wanted to clarify a few things in relation to some of the evidence from earlier today. When we talk about lowering the mental threshold from intention to recklessness, that is in relation to the second element of the urging offence. So the first element is that you intentionally urge the violence or force. That is remaining unchanged. So it is very much that the person still does intend that. What we're lowering is recklessness in relation to that other element, which is around sort of the result you expect, whether someone would be so urged. So just in terms of culpability here, the bar is still maintained quite high by that first hurdle. In terms of what good faith defence then does, I just wanted to again clarify, we sort of colloquially call it the good faith defence, but it is actually quite specific in how it applies. So in 80.3, it sets out six specific circumstances which the defence applies to. That is not all good faith, all public interest. It's things like in good faith trying to address an error of government or a mistake. There's ones around industrial relations disputes and other ones around sort of publishing, journalistic type defence. So it is not a general good faith defence. It's quite specific. So then when we look at that against an intention of urging violence, that's where the government, in particular the attorney, has been quite clear, both in the explanatory memorandum and his second reading speech, that there is no instances where you intentionally urge violence, and that is meeting one of those good faith provisions. In terms of the context point that has been raised, in terms of adducing evidence to the court to prove intention or to prove recklessness, is going to require the CDPP to look at the circumstances and the context of the offending. So the context is very much taken into account as bringing forth the evidence. So in terms of whether specifically articulating that actually starts to limit the court's ability to consider sort of the broad suite of evidence that the prosecution may want to bring.
Okay, thank you. The Law Council of Australia also raised an issue with respect to the strict liability component of one of the proposed new offences in relation to the third element of the defence, of the offence, I should say, of 80.2BA 1 and 2, and paragraph C is a reasonable member of the targeted group would fear that the threat will be carried out, and that applies to both clauses. And then subclause 4 says strict liability applies to paragraphs 1C and 2C, and that causes the Law Council of Australia some concern as to why strict liability should apply in that regard. Could you walk us through the thinking of the department in relation to the insertion of C and paragraph C first, and then as to why it's a strict liability provision.
Thanks, Senator. Look, I'll just start with, again, sort of stepping through that offence. So it still does require the person to intentionally threaten the use of force or violence against a group. So we do have that as the sort of that headline element. Then you move into the sort of the result that threat would have on a person, and that's when we are bringing in the reasonable member of the targeted group element, which is moving into more of an objective standard. Is there anything else?
I think that's right. Like, the reason for strict liability for this offence is that it's focusing on what a member of that group would consider. It's that factor isn't really directed to the state of mind of the defendant, which is why strict liability has been applied to it. And I suppose in terms of the insertion of that element, it refers to a reasonable member of the targeted group rather than requiring that a particular member of the group have been hold that fear. In part, I think that reflects the fact that one of these offences is directed at conduct that is threatening force or violence against groups as a whole rather than against a particular identified person. It doesn't require that a particular member of that group have received that threat. It's sort of targeting sort of precursor behaviour to that in some ways, and that it doesn't require a particular member to have received that threat. It's directed to the group. So that's why it applies to a reasonable member of the group rather than an identified individual within that group.
And just add one final point. In terms of the seriousness of these offences of 5 and 7 years, what it does too is not only is the person intentionally threatening the violence, but it is bringing an element into there of it's more than sort of simply rhetoric. It is something where a reasonable member would fear that this threat is going to be followed through on, and that is really for us around balancing the seriousness to warrant such a penalty.
Well, you preempted my next question, which was really, what's the purpose of adding C? If someone goes out into the community and they threaten to use force or violence against a group, or they're agitating for others to do that, and that's their intent. Their intent is that they're going to use force or violence, or someone else will use force or violence against that group. Why do you even need paragraph C? What's the purpose of paragraph C?
Yeah, look, sorry, Senator, not to repeat too much of what I said before, but it's really trying to bring in that is more than just rhetoric. It's that someone, the seriousness of it, that someone would, or a reasonable person would feel threatened, such as to warrant such a significant criminal penalty.
Okay, so it's drawing a distinction between, say, a drunken idiot just making a comment, being a blowhard, as opposed to someone who's agitating in a particular way with a deliberate intent, trying to rally certain people to cause violence. Is that the thinking?
Yeah, look, that's right. And I would clarify here too, it's not that we are saying that such behaviour is okay. It's around whether this criminal offence and an offence of this severity should capture it. Whether there are other civil penalty provisions that would capture that is sort of a different issue there. So it's not that it may not be prohibited, it's just that a serious criminal offence like this, it would sort of fall below that threshold.
If I could ask one clarification, sorry, it's just to say that only applies to the threatening force or violence offences. So there are a few comments about rallying people to violence. It's only the threatening force or violence offences that have that element, not the urging force or violence offences.
Okay, thank you.
Deputy Chair.
The New South Wales Council for Civil Liberties raised concerns that there's no provision that requires these acts to be public acts as opposed to private acts. What was the thinking? Was that something considered by the department as to whether or not there should be an element of the offence should be that it be a public act as opposed to a private act? Was that considered by the department in terms of its deliberations? And what's your response to the argument from the New South Wales Council for Civil Liberties? And I'm happy for you to take it on notice if you want to.
Thanks, Senator. Look, happy to answer now. It really goes to the harm that we're trying to address here. You can be threatened with force or violence in a private setting, and the harm to you or your group would be the same. Similar to urging violence, so it's just around the harm we're looking at addressing here is not distinguished by whether it is in a public or a private setting.
Okay, I can sense a change of the call being rotated. So I'll just ask this question before perhaps with the indulgence of the chair, before the calls circulated. In relation to, there were two issues that were raised, or two of the issues raised by Equality Australia related to instances where there's threats or harms which are incited against not just people but also against property. So attacks on, say, mosques or churches or the property of people falling within a certain class that's covered by the provision. So interested in the views of the department as to why the provisions don't extend to that sort of hate crime where physical acts are actually being promoted but they're not against the person, they're against property of the person. And we've seen some pretty vile vandalism and attacks on property over the course of the last 12 months, which has been very disturbing to community members. So that's the first element. And then the second element is that on the ground there appears to be a real issue in terms of associates or allies of or people connected with people who fall within the relevant classes being subjected to threats of violence or force being urged against them. And the concern is that those categories of people should also be covered by the ambit of the provision. It shouldn't just be members of the class themselves, but it should include people who, for example, are advocating on behalf of those people, standing up for people in those classes, or perhaps providing a service to people who are looking to put on an event, etc. So interested in whatever insight the department can provide in relation to those two issues. First, the extension of the offence to a threat against the property of a person, and secondly, a potential extension of the offence to associates, allies or people connected with people falling within a particular class.
Thanks, Senator. Look, have heard the evidence today and read the submissions and certainly acknowledge some of the harm and particularly the case studies put forward there. Just to go to how the bill as it's currently presented captures those circumstances. So if, for example, you were threatening violence against a person by, say, you were going to blow up their house while they were in it, is a threat to property, but is really a threat of force or violence against a person. So it can be sort of the vector for the threat of violence or force could be through property, but threatening, just a business of a particular person alone sort of would not be enough. Similarly, for associates or allies or other. Sorry,
just before we move from the first element, which I understand it would be caught if the person is with the property. And I think that's pretty clear. But what's the thinking behind? I'm urging someone to firebomb a business, say during business hours, when people are going to be in there, as opposed to urging someone to firebomb a business out of hours. Aren't they both heinous crimes, which perhaps should attract similar penalties, or do you think there's a difference?
Look, I would say they are both crimes. In terms of a threat to person is generally regarded as a more serious crime than a threat to property, but certainly interested in the committee's views on whether that should be included in the offence. From the department's perspective, should the committee be so minded to make that recommendation, we would just have to consider it from a constitutional perspective of whether there's enough coverage to capture such conduct.
Okay, and then, sorry, I interrupted you. The second element, associates?
And I'll be very brief. In terms of associates, just to say in terms of the application of how it applies at the moment, there would be some coverage in that you don't, it's around the offender's belief that the person is a member of that group, and sometimes we see in this scenario where allies or people associated with sort of a batched up in the group while may not technically be members of the group, but again, defer to the committee on whether you consider that to be worthwhile, and we would just have to consider it from the perspective of whether there's constitutional coverage to extend to that.
Okay, thank you. Thank you, Chair.
Thanks, Senator Scott. If I could just pick up on that issue, the example that's given, which is a very real life example, is where there might be children of LGBTIQ plus parents or family members, but particularly children. So they wouldn't necessarily be covered unless there's, well, what is the answer? Are they covered, or are they not covered, or do we need to be more express in the explanatory memorandum or in some note to the legislation?
They wouldn't, two things. So they wouldn't be covered in this formulation of the bill where it's a threat against the member of the group, not a threat to an associate of some or a child of someone in that group. I would just want to say, though, that it would, putting aside, not without setting out all the facts, it would almost certainly still be a crime under state provisions for that. So it's not that it wouldn't be criminal, but it was not something that we considered in formulating this bill, so certainly recommend, so would welcome the views of the committee on that one as well.
Okay, thank you. One of the other issues that came up throughout today was the serious, whether there's a benefit in having a serious vilification offence. The Victorian government recently announced that it will legislate this type of offence. I assume that you're aware of the Victorian proposal. What would the Victorian proposal cover? I guess we've asked consistently throughout the day whether people would want that to be part of the legislation, but it might be actually useful to understand what it would cover that isn't already covered by this bill.
Chair, we might need to take that one on notice given it's a relatively new offence, and I don't have it to hand, sorry.
Okay, if you could take that on notice, I think that would be helpful. You've already answered the question about the Human Rights Commission requesting or recommending that the bill be amended to require the consideration of context. In terms of artistic, academic or journalistic purposes, how would they already be covered in, how would people in those circumstances already be protected against this type of provision? Does it need to be expressed, or is it already sort of in there in terms of the way that the offence is constructed?
Thanks, Senator. Look, we would argue it is already carved out. If you're in the, well, for the offences to apply, you have to be intentionally threatening the use of force or violence or urging others to use force or violence. So if you are intentionally doing that and also have an artistic purpose, it could be captured, but solely for an artistic or other purpose would not meet that first element of the offences.
Okay. Sometimes the answer is as simple as that, so thank you. I think Senator Scarr might have raised this with you, so I'm really sorry if there's duplication. I'm trying to multitask like we all are at this part of the day. The particular issue around members of the community who are HIV positive was raised earlier in the day, and the argument that one of the protected attributes could be extended to cover health status rather than disability, predominantly because the nature of HIV positivity has changed over time and is less likely to be connected to a disability, but rather someone's health status. Are there any impediments to this? I think you referred to whether, in terms of expanding the attributes to disability, you were talking about the constitutionality of that.
Yeah, so we certainly acknowledge the concerns that were raised by those submitters. I think, as was discussed earlier in the day, the bill does define disability to have the same meaning as in the Disability Discrimination Act. That definition includes the presence in the body of organisms causing or capable of causing disease, as was recognised in the second reading speech for the Disability Discrimination Bill. HIV/AIDS is captured and is intended to be captured under that, but we do acknowledge the concerns that were raised by submitters about it being labelled as a disability for these purposes. I think in terms of the constitutionality of protecting health status as an attribute by these offences, it's probably something that we would need to take on notice, I think, but I can't immediately think of an international. So, these provisions all give effect to various international treaties. I can't immediately think of an international treaty that does cover health status, but we may be able to identify something there.
And Senator, just to not disappoint, knowing under some tight timeframes, given that probably is going to amount to sort of international law or constitutional advice, there's probably not much we could give on notice on that.
No, that's perfectly fine. Thank you. Might be something that comes up in parliamentary debate though, so you can get ready for that one. Can I ask about the recommendations around, in the same vein, around the characterisation of intersex status instead of sex characteristics? Why does the bill use that terminology?
So the bill uses the term intersex status for consistency with the Sex Discrimination Act, and again, we are very aware of the comments in submissions and from witnesses today about the use of that term. It is used entirely for consistency with the Sex Discrimination Act. It's also probably worth noting that it's a term that's used quite extensively across the Commonwealth Statute Book, so Sex Discrimination Act, the Fair Work Act, the Migration Act, and a number of other pieces of legislation. So I think that's the reasoning behind using it here. If amendments were to be considered, it might be worth considering that a bit more holistically, given its use quite extensively.
Yeah, more of a statute update rather than across the board, if there's a different terminology that's more appropriate now. Thank you. Now, we had an enormous amount of evidence and recommendations from people calling for, as I alluded to before, anti-vilification laws. I referenced the Victorian proposal. Of course, there were some people opposed to broadening the law out at all, but given the interest from particularly the Jewish community, the LGBTI community, there was also interest from, I think, from the Islamic community. When the department was conducting consultations on the bill, was that one of the issues that came through from submitters? And is there more work being done or to be considered, or is it something that the department is at the moment waiting for our committee to come back to you on?
Chair, probably the latter.
So I think it's fair to say, obviously, when we considered what amplification could be made of the urging violence offences in the code, we did think about serious vilification and have certainly looked at other jurisdictions and what they're doing or have done, including internationally. The bill doesn't include a vilification offence that you're talking about. That's primarily because it's intended to criminalise the most serious kinds of hateful communication where they involve force or violence or threats thereof. So, yes, in short, we are interested to hear what the committee says about that.
Okay, thank you. I might also ask, there were some specific recommendations around the fault elements, the second element of the offences, particularly around recklessness, and I think you had this conversation with Senator Scarr, so I don't want to duplicate it too much, but the Executive Council's Australian jury recommended that the second element of 80.2A and 80.2B be removed from those offences. That is the reckless as to whether force or violence will occur. What would be the implication of such amendments if we were to sort of take that out?
In short, I mean, Mr Muffet will expand, but that will sort of remove the nexus to force or violence from the intention when the person urges the force or violence. So we'll remove that important nexus, which this bill is focused on.
The only other thing I would add is in terms of general sort of Commonwealth criminal law policy, if you look at the extension of criminal responsibility in relation to an incitement, where it's a person commits the offence of incitement if they urge the commission of an offence, for the person to be guilty of that, the person must intend that the offence incited be committed. So it's a general criminal law policy piece where we have both the urging and the recklessness around the result and the likelihood of someone acting on that incitement.
What's the legal definition of urging? Sorry.
Look, it is used in the code, and as I just said, it's used in fact when talking about incitement. It's not defined, but look, I'm not sure if there's been any sort of jurisprudence or judicial consideration of technically the term.
Yeah, just because again that same particular submitter recommended changing the first element to promotes, advocates and glorifies the use of force or violence. And I would have thought that the definition of urging might actually cover some of that behaviour.
No, absolutely. And having considered that, particularly around promoting or advocating, there is significant overlap we consider with those terms. So I'm not sure from a practical perspective what behaviours would be caught by one and not caught by the other.
Okay, thank you.
From a policing perspective, the urging has more of an element of a call to action. So again, it's action orientated when you're trying to interpret the conduct. From a practical perspective, not necessarily from a legal. I'll defer to my legal friends on that particular issue, but that's in my mind anyway how I distinguish some of those conducts.
No, that's right. And sorry, when I was quite intentional when I talked about the similarity with promoting or advocating as distinct from glorifying or praising. So recently in the Prohibited Hate Symbols Bill that passed late last year, the advocating terrorism, the definition of advocating in that case was expanded to include praising, but praising where there was a substantial risk that the person would then act. So even in that context, it was quite an call to arms, sort of action-orientated use of praising.
Okay. I just have two last questions for the Deputy Commissioner, actually. We had some suggestions from witnesses who were opposed to elements of the bill that we could have some sort of scope creep, that we would see these offences would be created, and then we would have prosecution of people almost, for prosecution's sake. So journalists, artists, people who were going about exercising their religious faith but were being brought before the courts because people were, offended by those types of views. I imagine that the AFP is pretty busy, and there's an enormous amount of work that goes into prosecuting an offence like this. Could you explain to us what's involved in actually proving the intention, what's required under the way that the offence is drafted?
Yes, you're certainly right, Chair, in terms of these types of investigations, and we're also seeing it with the new hate symbols legislation as well. There is a significant amount of investigative activity that needs to occur and significant amount of evidence that needs to be collected in order to put forward something to DPP that under their prosecution policy presents reasonable prospects of a successful prosecution. To go to the first part of your question as well, we also have an operational prioritisation model within the AFP that determines which investigations we do take on. So some of those examples where you spoke about journalists or artistic or those sorts of aspects, I would say that they would not meet our priorities in terms of where we would apply our investigative resources. We're very much looking at what's the intent of the bill here, and therefore where can we have the biggest impact. But I might also just hand over to my colleague here just to expand a little bit in terms of certainly how much work goes into an investigation to prove an offence.
Thanks, Deputy. Circumstance and case-by-case basis examination of each allegation is incredibly important, particularly around, as my other colleagues have mentioned, around establishing intent. It may not just be the statement itself, it's very much the circumstances which led up before it and afterwards. You can't sort of, slice that out of the situation and treat that separately. Is very much establishing the evidence around the circumstances, history, what actually happened to the lead up to the event and following the event that's under investigation, which is and can be resource intensive depending in which manner the threat was made, whether it's electronically, in person. Obviously then you've got the witnesses, prior contact history, so there can be a lot that goes into establishing the actual intent of the person at the time the threat was made.
And Chair, I just add, noting the penalties that are attached to these offences, obviously that they're quite significant penalties. So these are investigations that we take extremely seriously, given the potential consequences.
And just finally, going back to the beginning, where we started the day, where we started this session as well with this panel. We have seen an increase in escalation of threats of violence to particular communities. We've heard that evidence in different forums in this committee and others over the past 18 months particularly, or 2 years. Do offences like this assist in combating the promotion of violence in our community by sending a message to the community that behaviour is unacceptable, but also giving prosecutors and particularly the AFP the ability to investigate this type of conduct?
Yes, they absolutely do. So I guess in two parts there, any sort of prosecution that makes its way to court, of course, is a deterrent or shows creates an example. But also, I think just us even investigating. So what we have seen, to bring it back to the hate symbols again, that the fact that we went very public, that we had stood up a task force, that we were investigating multiple POIs, that we put out a number of media statements, we did see actually a shift in behaviour at protests following that in terms of the display of hate symbols. So it's not just prosecutions that have a deterrent effect, it's also the fact that we're applying resources, we are actively investigating, we're calling for assistance from members of the public and other witnesses and the like.
Thanks very much. Deputy Commissioner, there is always a strain on your resources, and we thank you for your time today appearing before our committee, and thank you to the department as well. I'm sure there was a lot of work involved in getting this bill before the Senate, so we thank you. Senator Scarr, do you have any other questions? We're about to wrap up, but...
No, Chair, I just want to echo your comments to thank everyone for their appearance today and thank everyone for your detailed submissions, including the Attorney General's Department, which had their very useful table. So thanks to everyone, and thanks to everyone for your work in this area. It's such an important space. Thank you.
Thanks. Thank you. That concludes today's proceedings. So the committee has agreed, I think the committee is going to agree, that answers to questions on notice at this hearing should be returned by close of business on Friday, the 6th of December. Senator Scarr, thank you. I thank all witnesses who have given evidence to the committee today. Thank you also to broadcasting and to the Secretariat, our very hardworking Secretariat, who have done an enormous amount of hearings and reports over the last 6 to 8 weeks. I'm so sure Senator Scarr would agree with me. One of the hardest working secretariats in town, but particularly after an enormous 2 weeks of Parliament last sitting, to be here doing this hearing on a really important topic. We thank you and thank you everyone. I declare the hearing adjourned.